Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama. Hello, friends. Hello, couch potatoes. Good morning. Good morning. Hope you're all doing great today. It's almost 4th of July. Happy early 4th of July. I woke up this morning to my alarms going off, which I hit the snooze real quick. And then 2 gunshots this morning. I don't know. Here I live in a city. So when it's 4th of July, because it's the 3rd, but we do all the fireworks and everything here on the 3rd. And so it's the fun game of, is it fireworks or is it gunshots? It was definitely 2 gunshots. It definitely was that. But I'm so excited to play that game all weekend. I don't know if it's like that everywhere else, but that's how it is here. It's super fun. Love it. Love it, love it, love it. So I hope everyone's doing great today. I'm excited to be here. Good morning, Lady in Gray. Hope you're doing well. Oh boy. So fun stuff. We got a very long day planned together. That's right. You get me all day today, which is very exciting because we haven't got to do that in a couple of days. And it makes me kind of sad because I've missed you guys. But I have been working very, very hard, very, very hard, putting all of this Crystal Rogers case information together, which is one of my favorite things to do, but it is something tedious. Let me tell you what. So today we're going to be going over, so let me back up for a second. Where we left off was we have Brooks Houck arrested, and we have Steven Lawson arrested, and his son Joseph Lawson arrested. All of these, Brooks is charged with murder and tampering with evidence, and the father-son duo they got charged with conspiracy to commit murder and tampering with evidence. So now I'm not going to read you all the court documents. Don't worry. I'm going to try my best not to bore you today. I sure hope, though, that you guys like the sound of my voice because there's going to be a lot of reading today. We are going to go over some court documents that were filed for this case. Now, promise, they're not the boring ones, okay? There's like 3 of them. Some of them are kind of long, but why they are interesting? Well, I find court documents overall very interesting. I understand some people don't. But in these, the ones that we're going to be reading today are like excerpts from grand jury testimony, some from interviews, because we know the trials aren't televised, right? So I want to go ahead and read what those say because it's kind of, there's a little bit of tea in there for us. There is a 2, I think, hearings that we'll be watching. I have not watched them. I read the description and they're like, you got to watch this. And I was like, okay, we'll do. We are going to do that. Plus, I wanted to leave a little bit of mystery for myself, right? Watch something for the first time with you guys. So we'll be watching those today as well. And today should take us right up to the trial of Steven Lawson. That was just the end of May. Now, I started putting together the trial of Steven Lawson, right? Because again, no cameras, no audio, nothing. Don't worry. I have numerous rants planned for today about this. And I'm going to say this again when we cover Steve Lawson's, but this is why trials need to be streamed, okay? Because we could play a game of how many sources did Llama need to tell a complete story of a 4-day trial for somebody? Mm-hmm. The number's pretty high already. And I still have like 3 more pages of sources to go through just for that trial alone. So, because they all say different stuff. Yeah, well, and that is none of the news fault, right? They can't record anything. There's no cameras. They just got to write. So I understand why it's all scattered everywhere, but it is so annoying. I don't like it. So Lady in Gray, hello. She says this trial needs to be streamed. It's been nuts. Is. It is wild. And I think you guys are going to find all this pretrial stuff wild as well. Good morning, Mama Llama. Hope you're doing great this morning. I just now have a sip of coffee. I went about my business getting ready. Normally, coffee's already made for me in the morning before LLP goes to work. So I was, getting all ready. And it's, 9:45. I'm like, oh, I should get my cup of coffee. I forgot. I go over there. There's no coffee made. The horror, the shocking horror I had. So I'm just now getting caffeinated, you guys. Sorry about that. Anyway, I hope you guys find today very interesting because I do. And again, I said from the beginning, I want to tell a complete full story to the best of my ability of this entire Bardstown saga. And that includes all of this stuff. So buckle up because it's going to get a little spicy. It's wild. He's fired. I know. No, my guess is he probably woke up late today, too. We both went to bed pretty late last night. He was gaming and I was busy yelling at my computer, being annoyed with all these different sources to go through. So he's forgiven today. He gets a warning, LLP, if you're listening. All right. Well, since we're going to have a long day. Oh, sorry. I almost forgot to say. So I am putting together the trial of Steve Lawson. You guys are probably going to get a bonus weekend stream. Yes, because tomorrow I will not be on because it's a holiday. I don't really do anything for the holiday, but I need all the time to work on putting together Steve Lawson's trials. So I don't know if it'll be Saturday or Sunday, but we are going to have a stream sometime this weekend because Monday, this is so annoying because I really like things to be planned out and not just be like, well, you guys are just going to have to wait and see and be on my schedule. I don't like doing that. And I'm sorry that it's been like that recently, but apparently Monday they're coming to remodel my bathroom for 3 days. They said 3 days. I don't know. I don't know what any of it means. So I can't plan anything until at least Monday when I know what their plans are, because my bathroom is like 20 feet away. So it'll be very noisy and you guys won't like it. And I don't want to do that to you. So I'll know more Wednesday once the contractor gets here and we find out what the plan is. I don't know. Maybe we'll do some night streams. I don't know. But we'll get back on a regular schedule soon. I hope. I promise. Anyway. All right. Before we get going, make sure you hit the like button so it lets everyone know that we're live. If you haven't, subscribe, hit the notification bell so you know when we go live, since apparently all my plans are up in the air. Don't want you to miss us this weekend when we do cover Steven Lawson's trial. Oh, because it is wild. It is wild. All right. So, as I said, we ended part 1 of episode 4 with the arrest of Brooks Houck, Steven Lawson, and his son, Joseph Lawson. And Steven was the last of the 3 to be arrested in December of 2023. Now, we're going to be covering 2024, all of 2024, and all of 2025 up until the end of May, which is Steve Lawson's trial. So we got a year and a half we're going to cover. Now, I'm going to play, before we get into 2024, I did find an interview last night with Steve Lawson's attorney, Ted Lavit. Okay. Because we had brought up some of the stuff he was saying to the media about his client that I was just like, ooh, buddy, why are you telling everybody this? This doesn't sound good. But anyway, so I found this interview. It's from December 12th, 2023. So just a few weeks before we're going to kick off here. And we went over most of this in the last part, but we're just going to use this as a refresher to get into the moment. So we don't have a whole lot of videos. The ones we do have are going to be long. This one is like 4 minutes, so it's not too terribly long. So let's give it a listen, shall we? I'm going to go ahead and boost because they're outside. All right. Let's hope that StreamYard does good today.
Can you tell us when you first got in touch with Steven?
This year,
This year?
earlier.
What has the investigation looked like as far as you can tell?
Looked like they were trying to find evidence, and they hadn't found it yet. And they weren't satisfied. The Commonwealth wasn't satisfied with respect to what they had.
Good morning,
they were looking
Cindy.
for more.
What do you think they have on him?
I don't know if they have any more than I've told you, but they apparently they chose to indict him rather than give him the immunity that he was promised.
Oh, so he had been in discussions with them
He has, and I have,
regarding some sort of deal
immunity.
Oh,
to say what he knows.
What's known as transactional immunity.
About how many times do you think police have been in touch with Steven?
Over a dozen.
Just this year?
Many more than a dozen.
From
That's
your
a lot of
understanding, was Steven Lawson involved in the death of Crystal Rogers?
No, he was not.
What do you think his connection is to this case?
He was an employee, part-time employee of Houck, and he had an association with Houck. Mr. Houck has had conversations with him about Crystal, and that's the extent of my client's involvement.
And what about that phone call? Police have released it as that it was from the interrogation room.
That's correct.
What do you make of that phone call?
It was a set-up phone call. One was supposed to call the other, and the ring came in, and they spoke.
And what about Steve's son?
Steve's son, I'm not sure about the evidence that they have against Steve's son. I know that he's extremely involved.
Do you think that Brooks Houck paid Joseph Lawson to help in the murder of Crystal Rogers?
I think the Commonwealth has been trying to establish that a payment was made. As to who that payment was made to and when it was made, I'm not privy to that information yet.
What about the vehicle in this case?
Vehicle was the maroon vehicle that was parked out on mile marker 14 on the Bluegrass Parkway heading west. It was driven out there by Joey Lawson. He had a flat tire at that mile marker, and my client received a phone call, went out there and got him, brought him back.
So Steve has told you that he went and picked up Joey from the Bluegrass Parkway where he had driven Crystal's car.
He's told the state police that, told FBI that, told the Commonwealth's attorney that from Hardin County, who's in charge of the investigation.
Any other important details that you believe prove your client's innocence?
Other than his assertion that I did not hurt Crystal and was not involved in hurting Crystal. I didn't plan to hurt Crystal. I didn't conspire to hurt Crystal. Those are his statements. And that's what he has told the Kentucky State Police, and the FBI, and the Commonwealth's attorney time after time after time in this year.
What do you anticipate will happen in court next
Hello,
week? At Brooks Houck's arraignment, there was a lot of bombshells dropped. Do you think we'll hear something similar?
I do. And as we move on, the Commonwealth's ready to move on after all these 8.5 years. I would say that we're going to hear some things in court that we haven't heard before.
So that is the interview with his lawyer. Just, oh boy, saying a lot of things. So his lawyer, this is Steven Lawson's lawyer, by the way, for those just coming in. Steven Lawson's lawyer is telling the media that his client was at Crystal Rogers' car on the Bluegrass Parkway. He went there to pick up his son, Joseph Lawson, Yeah, no, Zoe, you were just outside. It's not happening. Joseph Lawson, and admits to being at the car. But they're arguing, hey, we've been talking to all the authorities, the police, the prosecutor, the FBI. We've had numerous meetings with them. And they said we got immunity, and my client's in jail. So what is happening here? Oh, sorry, apparently. So he needs to go outside again. So just a minute, please. I'm sorry. I don't have videos to entertain you guys today, but just a minute. All right, sorry, kiddos. Today is going to be one of those days. I hate to leave you guys when I don't have anything else going on, but I try to make it as quick as possible. I got dogs to let out. Elbow Feet called me to see if I wanted to go to a cookout tomorrow. And I'm like, why are you asking me this right now? I'm live. There he is. Good morning, Elbow Feet. And then at some point, my son is going to his dad's today. So it is going to be a day of interruptions. Let me just put it out there. It's probably going to be a day of interruptions, but that's okay because we get to hang out all day together. So it's fine. Catherine says at some point you'll have to accept that we live in Zoe's world. Don't we? It's ridiculous. She's feeling all better. She's even more stubborn than before. Anyway, so as we're talking about Steven Lawson, Lawson's lawyer. So yeah, they said, hey, we were under the impression we made an immunity deal, and for some reason my client's in jail, but he is admitting that his client was at Crystal Rogers' car picking up his son, who was driving her car that night on July 3rd or 4th. You know, it was midnight time. So around there. Oh, here's it spelled with no Y. Well, I'm convinced, Zoe and Elbow, I am convinced they have like secret meetings about me every day. I'm convinced. She's perfectly fine when he's home. When I'm home, she's like, even though she listens more. Okay. Anyway, so let me share this tab. All right, and let's get more into the story before the dogs knock on my door again. All right, so we're starting with January 4th, 2024. Now, Steve Lawson is January 4th. Steve Lawson is back in court, and his attorney, Ted Lavit, told the judge that evidence produced in the case so far indicates Lawson had nothing to do with her death, and that Steve, sometimes without an attorney present, met repeatedly with investigators, and they had an agreement he would not be prosecuted. But there he is, sitting in orange. So what happened? Quote, he has cooperated at all times, answering all questions for investigators, Lavit said. Their questions were exhaustive and repetitive. I imagine that they were. Lavit requested that Stephen's bond be reduced from $500,000 to $20,000 cash or $40,000 in property. Lavit told the judge that Steve has cooperated, is not a flight risk, and wants to extricate himself of any guilt associated with the indictments. Oh, hold on. I don't even have I am a mess today, you guys. I don't even have my slideshow up, ready to go. Oh, there we go. Zoomed right past it. There we go. So Special Prosecutor Shane Young said he was not going to talk about any claims of a deal not to prosecute Steve Lawson. And as far as being a threat to flee, Young said he told Lawson the day before he was going to be indicted, and Lawson didn't show up for work the next day and went to Indiana. And Young said there is additional evidence that will be turned over to Lavit that will show more of Lawson's involvement. Now, Lavit said Lawson did work that day in Indiana, which is not unusual, and that he was simply visiting his mother. During the hearing, Lavit told the judge that Lawson was an alcoholic at the time Rogers disappeared. Now, after the hearing, Lavit said in an interview that Steve Lawson picked his son up and also removed a miniature Louisville slugger bat from the vehicle. Remember, that was found in her car. Quote, my client was never asked to move the car and never volunteered to move it, Lavit said. My client has nothing to do with removing the car from the bluegrass. The only thing he took out of that car was a Louisville Slugger toy bat that seemed like a childhood toy that Joey kept with him and that was in the back seat. He moved that seat in order to get that bat, which, okay. Okay, it's kind of weird, but okay. Let's see, where was I? Lavit said Steve gave the bat to his son as they left. He maintained that Steve knew nothing about Roger's disappearance. Quote, my client said he would never harm that girl and never knew that she was going to be harmed, Lavit said. Lawson doesn't know what happened to Crystal. In all of the evidence thus far turned over to Lavit, there's not one line talking about my client hurting or being involved in the disappearance of Rogers. Now, Lavit also said police have information that Houck wanted her harmed, though he would not say how he learned that. He has previously said there was evidence of solicitation by Houck to find someone to kill Rogers. In regards to Steve's alcohol abuse, Lavit said he's not using that as a shield for telling the truth. He is telling all he can remember. And with that, give me just a second, guys. You know what Zoe wants inside. Okay, sorry. I decided to also take that opportunity to try and wake up little Llama, which I know he's just going to go back to sleep. So I don't even know why I bothered, but it's the thought that counts. Good morning, Juju Bean. Hope you're doing well. Good morning. Okay, so now we're on to January 9th, 2024. Where Judge Sims approved a motion to reduce Steve Lawson's bond from $500,000 to $250,000, which is probably not a better deal for him. So, but there are certain conditions Lawson must follow. He must adhere to a dusk to dawn curfew, except going to work in medical emergencies. He must remain drug and alcohol free, and he can have no contact with Crystal Rogers' family. Now, Judge Sims said he chose to reduce the bond after considering the gravity of his charges and Lawson's prior criminal history, which is mostly made up of misdemeanors and minor violations compared to his son. Remember, we read some of his stuff last time? Now, the judge noted that attorneys did not argue during the hearing on whether Lawson has access to many financial resources that would assist him with running away. He adds that Lawson is considered a moderate flight risk and has a moderate risk to reoffend. In regards to the prosecution saying that Lawson didn't show up for work and was found in Indiana the day after finding out he was to be indicted, Judge Sims said, although there is no testimony from witnesses about whether Lawson worked that day or why he was at his mother's house, he wrote, quote, "It is highly suspicious that Lawson was discovered in another state after being informed of the potential indictment." It's true. The judge said if convicted of both charges, Lawson is potentially facing up to 25 years in prison. Side note, so when I was putting together the stuff for Steven Lawson's trial that we'll cover this weekend, you guys, court is wild in Kentucky. Wait till you hear what the jury has to do. It's insane. It's insane. I've never seen another state that does it. It's wild. It was like 12:30 at night, and I was like, oh, no one to tell how wild things are in Kentucky. So make sure when we cover Steven Lawson this weekend, you watch, because you'll just be like, what is happening? Okay. But let's go back to 2024. I'll try not to have so many side notes. So February 8th, 2024. So for the first time, the three men arrested and charged in connection with the murder of Crystal Rogers are together in the courtroom. Yep, those three guys there. All parties tentatively agreed on a trial date of February 10th, 2025, and Special Prosecutor Shane Young indicated he would file a motion to try the three defendants together. Although Brooks Houck's attorney, Brian Butler, said he would object to that. And Butler told the judge he would be filing a motion to move the trial out of Nelson County, which I think is more than fair. That makes a lot of sense. Prosecutor Young said he expected to have all the evidence in the case, about 2 terabytes total, turned over to the defense attorneys by that time. Now, Joseph Lawson's attorney, Kevin Coleman, asked the judge to reduce Joey's $500,000 bond to a $50,000 unsecured bond, meaning he wouldn't have to pay bail unless he failed to show up for court. So his attorney said, since his client is disabled and confined to a wheelchair, that he would not be a flight risk or danger to harm anyone, and if released on this bond, Joey would be placed on home incarceration with GPS monitoring, and that he would get substance abuse treatment. Look how different he looks compared to his mugshot. You guys remember his mugshot when he clearly was on a lot of drugs? Drugs are bad, kids. Drugs are bad. But prosecutor Jim Lasowski said Joseph Lawson has a lengthy criminal history. True, we did read that. And is a risk to obstructing justice in the Rogers case, arguing that once he found out he was a suspect, he texted and called associates and friends to cover for him to give him an alibi for that night that Rogers disappeared. Interesting. Quote, you can let him out of jail, and the Commonwealth believes he will continue to do that very thing. He will obstruct justice so he can escape the law, Lasowski told the judge. Now, Steven Lawson's attorney, Ted Lavit, has said he's looked through the evidence provided by the state and said it's repetitive and without new information. He says Steve Lawson's only involvement is picking up his son, Joseph Lawson, who was driving Rogers' car when it got a flat tire on the Bluegrass Parkway. Quote, my client was never asked to move that car and never volunteered to move it, Lavit said. My client had nothing to do with removing the car from the Bluegrass. The only thing he took out of the car was a Louisville Slugger toy bat that seemed like a childhood toy that Joey kept with him and that was in the back seat. He moved that seat in order to get the bat. Lavit said Steve gave the bat to his son Joey as they left, then dropped his son at a 5-star gas station. So, okay. Okay, not all drugs are bad, okay, but definitely the ones that he was doing. Don't do the hard ones, kids. Don't do that. Hi, 80s. Good morning. Hope you're doing great. Gavel and wine earned. You hit the like. Great. Yes, everybody hit that like button. Okay. As I said earlier, if you guys missed it, I really hope you like my voice today because you're going to hear a lot of it. We got a lot of stuff to go through. All right, so now we're on to February 12th, 2024. So Judge Sims approved a motion to reduce Joseph Lawson's bond from $500,000 to $250,000. That's right. It's same as his dad. The court ordered that Lawson has, the curfew, all of that stuff. And it's just like, okay, but even if he got out, where is he going to live? Because when he was arrested, he was living out of his car naked. So I'm imagining he's not going to go live with his dad. That's not how that's supposed to work. So interesting. So the court says they have considered Lawson's criminal history, which includes 2 convicted felonies. And this is wild, right? So while he's trying to get his bail lowered, okay, during this time, he is currently serving a 1-year sentence at the Kentucky State Reformatory for a criminal mischief charge. That's right. He's already serving time in prison during this for a different charge. So, okay. He was also previously convicted of possessing meth, which is a surprise to no one. In his ruling, the judge explained that while the court is sympathetic to Lawson's paraplegic status, he made the determination considering the gravity of Lawson's charges, his criminal history, and the potential punishment if he is convicted, which could make him a flight risk. I mean, yeah. Juju Bean says, yeah, what's going on with that Louisville Slugger? Much stuff about the bat, the pigs, no spoiler those. Who knows? It's just nuts. I don't know. I cannot wait to talk about the trials, but this stuff is very important, I think, to really see the bananery that is coming down the road. So, all right, so that takes us to March 5th, 2024, and we're going to read our first document together. Ooh, how exciting. So Steve Lawson, this is Steve Lawson's attorney requesting dismissal of charges or to have his testimony excluded from evidence. Okay, and we're going to get some tea here. Let me see how I'm going to do this. We're going to share this tab. Ooh, look at that. I don't like how bright white it is, but here we are. All right, we'll do that. We'll zoom in a little bit. It's not that long. It's like 12 pages, so it'll be fine. All right, everybody can see that? You do bigger? Nope, that's too big. It's too far. All right, so as I said, this is the defendant's motion to dismiss or, in the alternative, to suppress statements. Okay, ooh. All right, so the beginning's just an opener, right? The plaintiff will hereby take notice that defendant Steve Lawson, by counsel, will, on the 21st day of March or soon thereafter, as counsel may be heard in the court, right? They're asking for a hearing. They want to move the court to dismiss these indictments as Mr. Lawson was promised immunity in exchange for his cooperation. In the alternative, Mr. Lawson moves to suppress all statements made to the KSP and Nelson County Grand Jury from June 8th, 2023 to the present. In support of this motion, the undersigned states as follows. So they're saying he testified in front of a grand jury June 8th, 2023, which would have been 6 or 8 months before they filed this, just a month and a half before they arrested Joseph Lawson. So interesting. All right, so let's get some factual background. I don't know how many of you read court documents before. I like them because It's where they like to slide in little pieces of tea before trial. And you're like, ooh, that's interesting. So, all right. So for factual background, Mr. Lawson voluntarily testified before the Nelson County grand jury convened by Nelson County Commonwealth Attorney in 2015. That's right after Crystal disappeared. Mr. Lawson was also interviewed by the Federal Bureau of Investigation in 2020. The special prosecutor subpoenaed Mr. Lawson to a new Nelson County grand jury on May 10th, 2023. Mr. Lawson testified as requested, and on May 24th, 2023, Mr. Lawson was indicted for tampering with physical evidence by allegedly assisting in moving Crystal Rogers' car. Mr. Lawson was arrested on June 8th, 2023, and taken to the Kentucky State Police Post in Elizabethtown. So, you know, what's also interesting about court documents is like, we thought everything had been quiet, you know, for a few years. And it turns out not so much. Steve Lawson was on the radar from the beginning because he called, Brooks when Brooks was doing the interrogation. So like we had heard of him, but like never really came up again. But I like, right? They're the best source. They are, aren't they, Captain? Because you can't really lie too much in court documents. So, okay. So from the beginning of this interview, the prosecutor and police made it clear that Mr. Lawson would get immunity if he cooperated with the investigation. The prosecutor stated from the very beginning that any statements made by Mr. Lawson were made as part of plea negotiations and could not be used against him. The following is a timeline of key statements made by the police and the prosecutor. Yes, a timeline of what did they say? Oh, really? That Elizabethtown's your high school from Jujubing. That's cool. All right, so let's take a look at this timeline. So for a June 8th, 23 interview involving Shane Young, that's the prosecutor, and detectives Luckett and Harding. So Detective Luckett told Mr. Lawson, "My goal is to have you home this evening." Detective Luckett told Mr. Lawson, "Our goal is to not ruin your life." Okay. Detective Luckett told Mr. Lawson, "We do have a prosecutor on hand today, okay? If you was to want some kind of deal, there could be some kind of immunity depending on what you say." Detective Luckett told Mr. Lawson, "You benefit us." Detective Luckett stated, "We are wanting you to work with us. We want your cooperation." Detective Luckett stated, "I don't want you to worry today that if you divulge something, you are going to get time. If that's a worry for you, we have the Commonwealth attorney on hand on the property to where we can make you an offer." Detective Hardin stated, "We are offering you the opportunity of a lifetime. You can say whatever you want, as long as it is 100% the truth, regardless of the incriminating nature of what you say, and you can walk out of here today." Detective Luckett walked in the room and stated, "I was just talking to the Commonwealth attorney. We are good to go." Okay. Detective Hardin repeated his statement that Mr. Lawson can say what he wants regardless of the incriminating nature and go home today. Detective Luckett stated, "I want you to be comfortable that anything you say, it's not going to be held against you." Detective Hardin repeated what Detective Luckett said and advised the Commonwealth attorney is on his way. And just a reminder, cops can lie to you. All right, cops can lie to you. They also cannot offer you immunity or waive time. They can't really fulfill any of those promises. It's completely up to a prosecutor for all that. Just to let you know. They can be like, "Oh, well, we could just, get you off on that." That's not up to them to decide, by the way, for you all to know. So, Special prosecutor, though, Shane Young, walks into the room. Okay. So now the prosecutor is sitting there with the detectives and with Steven Lawson. Hi, Amos. Good morning. So Young walks into the room and advised Mr. Lawson he is the prosecutor on the case. Prosecutor Young stated, if you are 100% honest with us, I am going to help you. I'm going to help you. It's on the record. It's on tape. Whatever you say to me, I am not going to use against you. Interesting. Prosecutor Young stated, I have the power today, okay? I then talked to the judge. You can roll on home this evening. Mr. Lawson stated, I want that in writing. Whatever I say is cool. That means always get it in writing, right? Prosecutor Young responded, let me give you this much. What you say today is considered plea negotiations. Once I arrive, the whole game changes, okay? And it's a rule. There's a criminal rule on it. I don't remember off the top of my head, but anyway, what you say today will not be used against you, okay? I can promise you that. If you are 100% honest with me, this all just goes away, okay? 100% honest with me, and that means all of it. You are. I'll take care of you, and I'll take care of Rebecca, all right? You hold the key to this. Mr. Lawson stated, okay, I'll talk to these gentlemen then. To me, it sounds right there that he's being offered an immunity deal. Okay, that's what it sounds like to me. Whatever he says is not cool. Oh, geez. So Prosecutor Young said, if you need me, I'll be right out here. And Young walked out to watch the interview on a monitor. The Detective Luckett said, this is important, the big one. For you to get immunity, it has to be 100% honest. Detective Luckett said, we are going to give your son the same deal. Now, Prosecutor Young comes back into the room and said, I've been doing this 25 years. I've never extended this offer to anybody ever, really. I've never done it. I've identified with people who are involved, but low enough involved that I am willing to give them immunity. You're it for me. So he's never done this in 25 years. Okay. Prosecutor Young re-entered the room and stated, I'm listening to this. I'm going to call bullshit on this. Why the fuck would you tell that story? You need to cut the bullshit and you need to come fucking clean. I'm giving you blanket immunity. Take advantage of it. Oh, Prosecutor Young is getting spicy. Detective Luckett said, this is your life. You and your wife's freedom is in your hands. Detective Luckett stated, you have a blanket to get out of murder. Prosecutor Young stated, you're telling most of the truth. It's getting late. In order for you to not go to jail, I got to call a judge. Detective Luckett said, you're going to have to come back to the grand jury and tell the truth this time. Mr. Lawson said, I'm confused again. Prosecutor Young said, no, you're not confused. If you walk out of here, I'm treating you as a witness, not a defendant. Prosecutor Young said, I think you have been about 70 to 80% truthful with me. At this point, you don't have immunity. Prosecutor Young stated, here in the next couple of days, we're going to have to come the rest of the way for you to get this. Oh gosh, wow, that's quite the exchange. Quite the exchange there. So then it's June 14th, 2023, just a few days later. And here's some grand jury testimony, which, oh, wait, maybe not. It says, at the direction of Prosecutor Young and Detectives Luckett and Hardin, working at the direction of Prosecutor Young, Mr. Lawson testified before the Nelson County Grand Jury on June 14th, 2023. So here is the June 14th, 2023 interview involving Shane Young and Detectives Luckett and Hardin. Detective Luckett stated, we are going to try to straighten a few things up. You are here based on an agreement between your attorney and the Commonwealth attorney. That's a full cooperation agreement. Detective Hardin said, "The more you tell us, the more you help, Steve." Mr. Lawson said, "I don't want to get things backwards. I will get into trouble." Detective Hardin stated, "If you want us to go to Shane and tell him you are good, you need to make us believe everything you say." Detective Luckett said, "You're facing 20 years. Prosecutor Young came into the room and spoke with me on the speakerphone. Prosecutor Young again said that he is offering immunity, but that everything has to be truthful." Detective Luckett said, "When we leave here today, if we uncover something else, I don't know that you will get this deal." Lady in Gray says, "These people are snakes. All law enforcement we've seen lately make me trust them less every day." I will say this does seem a little borderline not great. I can see why he also thinks he has an immunity deal. Remember, his lawyer's there too, which is interesting. So August 2022, or I'm sorry, August 22nd, 2023 interview involving prosecutor Shane Young and detectives Luckett and Hardin. So here's another interview of them. So Detective Luckett stated, "We're going to kind of start back from the beginning. We're going to get it all on tape. And we're going to get a good statement. Your attorney is present. The prosecutor is both present and observing in a separate room. There has been some discussion worked out as long as you are honest and truthful." All right, so it's a party for this interview. So Detective Hardin says, "You are at a crossroads. You are going to have to come clean." Detective Luckett, "You are going to have to come clean. We are trying to save your ass." Detective Luckett again, "The more stuff you say, the more truth you say, the more freedom. This is a gift like I ain't never seen." Mr. Lawson stated, "I put myself on your side of the table. I want to be on your team more than you will ever know." Mr. Lawson also says, "Boys, I want to be on your all's team." Detective Luckett, "This is the rest of your life." Now, there's a little footnote, and I'm going to read a little footnote because I do love footnotes. So at this point, where's this footnote 1? I don't see where the asterisk or the one is. Anyway, it says that at this point, Mr. Lawson has not been charged with conspiracy to commit murder, but the immunity offer and the plea negotiations clearly concerned this charge as well, because conspiracy to commit murder has a maximum penalty of 20 years, where tampering with evidence only has a 5-year maximum. Oh, earlier when they were like, "You're facing 20 years. That's what the lawyer's trying to point out there. It's interesting. Oh, hello, Dave. Good morning. Hope you're doing great. Hello there. So Detective Luckett goes on and he says, "This is your life. Your attorney has done you a big favor. Everybody has done you a big favor, given you the opportunity. You better jump on it." Detective Hardin, "You got to take this all the way home, Steve." Sorry, I don't know why that statement makes me laugh. Detective Luckett then says, "You're going to have to get real about this, Steve. Steve, I don't want to send you to the penitentiary." Detective Luckett says, "I'm getting ready to walk out, and you know who's going to be going to the penitentiary." Mr. Lawson, "You all act like I don't want to be on your team." All right, so September 12th, 2023, they have him in an interview like every month. This is wild. By now, his son has already been arrested, charged with conspiracy and tampering with evidence. So that's fun. But Brooks has not been arrested quite yet. All right. So again, the undersigned was present along with Prosecutor Young as part of the continuing effort to finalize our negotiations. Okay. Detective Luckett, "Man, before we get started, I want you to think about some things. Your mama, you want to see her, right? Your mother, your wife, your grandchildren, your retirement. Think about these things. You could take your last breath in the penitentiary. That's not what we want." Detective Luckett also says, Steve, you've got to clean this shit up now. This is for you. Your mom is sitting out there now. Prosecutor Young walks in the room from viewing the interview on the monitor. Prosecutor Young, nobody thinks you hurt her. Get back on the point. Take that out. You are frustrating me. And Prosecutor Young left the room to again watch on the monitor. Detective Luckett says, we got to bring this home tonight, Steve. Mr. Lawson, y'all are helping me tremendously, and I hope I've helped y'all. Detectives Luckett and Hardin both respond, you have. Mr. Lawson says, I don't want to get hemmed up and go to prison. Well, sir, yikes. Detective Hardin, I'm glad you're in the position you are in and not a different one to have the opportunity that you have. I just ask that you take full advantage of it. Now, there's a September 20th grand jury. Pretty sure this is the grand jury where they're trying to get the indictment for Brooks. At the direction of Prosecutor Young and Detectives Luckett and Hardin, working at the direction of Prosecutor Young, Mr. Lawson testified before the Nelson County Grand Jury on September 20th, 2023. Now, after the grand jury, Mr. Lawson continued to cooperate with the investigation as part of ongoing negotiations. Prosecutor Young refused to offer immunity and indicted Mr. Lawson for conspiracy to commit murder in December 2023 and had him incarcerated. Well, that's all very interesting. What do you guys think about that exchange there? I mean, obviously it's only snippets, but that's pretty interesting. I mean, it's been several months somewhat talking about an immunity deal. I don't know about you, but I want that in writing before I said anything. I feel like that's kind of his lawyer's fault, but what do I know? All right, so let's get into the argument of this motion. Number one, the defendant was granted immunity and his charges should be dismissed. Mr. Lawson was offered immunity on June 8th, 2023. Based upon that offer of immunity, he submitted to numerous interviews with detectives Luckett and Hardin, with Prosecutor Young looking on and participating at strategic times. All three of these men promised Mr. Lawson immunity over the course of several interviews. You know, that's the cops, they can say whatever they want. That's they can, right? So that doesn't okay, yeah, they'll go back on their word to get what they want. Fine. But the prosecutor being there and saying that sort of stuff, I wonder about that. That doesn't seem all right to me. But all right, so they all promised immunity over the course of several interviews. And because of these promises, Mr. Lawson not only sat through multiple hours of interrogation, but twice went to the Nelson County Grand Jury. Mr. Lawson said that Prosecutor Young and Detectives Luckett and Hardin wanted him to stay, yet he still got indicted. The court should not permit the Commonwealth to welch on its promise of immunity. Now, I do like reading some of the case law. It's not too wordy, but it's always interesting to learn about their cases. So in Workman versus the Commonwealth in Kentucky, this is from 1979, the Kentucky Supreme Court addressed whether the Commonwealth can break its word to a defendant. Ooh, interesting. In Workman, the Commonwealth attorney agreed to dismiss the defendant's charges if he passed a polygraph examination. The defendant passed, yet the Commonwealth attorney failed to live up to his end of the bargain. The Kentucky Supreme Court said, quote, if the government breaks its word, it breeds contempt for integrity and good faith. Yeah, totally. When, as here, our historical ideals of fair play and substantial justice do not permit attorneys for the Commonwealth to disregard promises and fail to perform bargains. It does not permit the judge to allow such inequities to succeed. The Kentucky Supreme Court ordered the indictment dismissed with prejudice. Ooh, that's interesting. That is very interesting. And I do agree with that statement there that when you cross lines like that, it makes people not believe in the system. It's going to make people not want to come forward for important cases if you're just like, you know what, take backsies. Don't get me wrong. There are plenty of people who have gotten immunity in cases that's really ticked me off before, right? But sometimes you got to do it. Jujuin says, stay wondering about this, trying to remember if this was videotaped and I've seen it. If you're talking about Steve Lawson's interview, I don't think so, but I do think they play it in one of the hearings. I'm not quite sure about that. We'll have to see. Let's see. So Workman requires the court to dismiss the indictments against Mr. Lawson. Mr. Lawson was offered immunity if he talked with the Commonwealth and its agents. Mr. Lawson talked in reliance on the offer of immunity. He relied on the government's promises and gave multiple statements upon their demand, and they welched on those promises and indicted him. This is not justice and should not be allowed to stand, and Mr. Lawson's charges should be dismissed. I mean, interesting points there. Now, second thing they wanted to complain about, B. In the alternative, Mr. Lawson's statements are not admissible. So Kentucky Rule of Evidence 410 specifically states that evidence is not admissible against the defendant who was a participant in the plea discussions, which includes any statement made in the course of plea discussions with an attorney for the prosecuting authority which do not result in a plea of guilty. Okay. So from June 8th, 2023, all of Mr. Lawson's statements were made as part of negotiations to secure Prosecutor Young's immunity offer. I mean, they literally said, this is a plea negotiation. So he did say that. Prosecutor Young himself acknowledged that none of Mr. Lawson's statements could be used against him. Prosecutor Young said, if you are 100% honest with us, I am going to help you. I'm going to help you. It's on the record. It's on tape. Whatever you say to me, I am not going to use against you. Interesting. Prosecutor Young also responded, let me give you this much. What you say today is considered plea negotiations. Once I arrive, the whole game changes, okay? And it's a rule. There is a criminal rule on it. I don't remember off the top of my head, but anyway, what you say today will not be used against you, okay? I can promise you that. If you are 100% honest with me, this all just goes away, okay? 100% honest with me, and that means all of it. You are. I'll take care of you, and I'll take care of Rebecca, all right? You hold the key to this. It is as clear-cut as it gets. Mr. Lawson's statements from June 8th on are not admissible for him per KRE 410. Now, in Roberts versus the Commonwealth, Kentucky from 1995, the Kentucky Supreme Court defined plea discussions as discussions in advance of the time for pleading with a view to an agreement whereby the defendant will enter a plea in the hope of receiving certain charge or sentence concessions. Now, in United States versus Robertson in 1978, in Roberts, the Kentucky Supreme Court established a two-pronged test. One, whether the accused exhibited an actual subjective expectation to negotiate a plea at the time of the discussion. I would say he did. And two, whether the accused expectation was reasonable given the totality of the objective circumstances. I mean, those two prongs seem kind of meant to me, but okay. In Roberts, the defendant struck a bargain that he would not be charged as a PFO if he gave a truthful statement. The defendant's statement was not truthful, so the court ruled that the Commonwealth was not bound by its agreement and could charge the defendant as a PFO. But the court also held that Roberts' statement was clearly made in the court's plea discussions with the prosecutor. Consequently, that statement was not admissible against him in trial. All of Mr. Lawson's statements were made in the course of plea discussions with the prosecutor. Okay. So all right, that makes some sense there, that, the Commonwealth can take that deal back if you're caught, being a liar, pants on fire. Oh, let me switch to my other copy. Okay. So in Krebs versus the Commonwealth from 2009, the defendant said he would be willing to provide a statement in exchange for reduced charges. Initially, the detective said he did not have the authority to do that, because they don't, but ultimately talked to the prosecutor, who said he did not have a problem reducing Class C felonies to Class D felonies. Afterwards, the defendant confessed. The Kentucky Supreme Court reversed the conviction, finding that the defendant's statement should have been excluded pursuant to KRE 410. Krebs makes it clear that the police, who represent they are acting with the authority of the prosecutor, also bind the Commonwealth. Okay, so if the police do say, oh, I talked to them, okay. All right. So Mr. Lawson clearly exhibited a desire to achieve the immunity promised by Prosecutor Young and the detectives acting on his behalf. I mean, it does seem like that's what he thought was going on. Mr. Lawson asked if what he said could be used against him. Mr. Lawson agreed to talk with the police after Prosecutor Young told him that his statement would not be used against him. Now, throughout the interviews, Mr. Lawson asked the police if he was telling them what they wanted to hear and telling him he wanted to be on their team. There is no question Mr. Lawson exhibited an actual subjective expectation to negotiate a plea at the time of the discussions. I mean, it does sound like that. And there is no question Mr. Lawson's expectation that he was negotiating with Prosecutor Young and his police agents from June 8th on was reasonable. Prosecutor Young and his police detectives all dangled the carrot of immunity and repeatedly told him that they needed more and said things like he has to come all the way. After June 8th, the undersigned was present for these interrogations. Undersigned means attorney. They were always about Mr. Lawson giving the prosecutor and the police what they wanted to hear to finalize the immunity deal. Mr. Lawson testifying in the grand jury was part of giving the prosecutor and the police what they wanted in the hopes of finalizing the immunity deal. Now, pursuant to Roberts and Krebs and the KRE 410, none of Mr. Lawson's statements from June 8th, 2023 to the present are admissible. Wherefore, defendant Steve Lawson respectfully requests that the court grant his motion to dismiss the indictments or, in the alternative, suppress all statements made by Mr. Lawson from June 8th, 2023 to the present. So that's the end of that document. Oh, we made it through. Yes. Oh boy, it's going to be a long day of reading these. Juju Beaton says, I don't even know the different classes of felonies. Glad I don't. Look, glad you don't know either. But yes, there are different classes and all sorts of stuff. Oh, Amy says, I've missed your voice, lady. Fangirling. Well, you are going to get so much of it today. Just to let you know. So that's a very interesting document there for me. It does sound, at the very least, that Steve was under the impression that he was going to get immunity. Why they let the attorney didn't get this all down in writing, though? Doesn't seem like a good idea at all. I don't know why that was to happen. And it did, the prosecutor was there the whole time. So I'm curious to see how these arguments pan out. See, I told you guys, court records, got some tea. So again, that was March 5th of 2024. So on March 6th, let me share this tab over here. There we go. Oh, no. Add you back to stage. There you go. So March 6th, the Kentucky Supreme Court denied a request to review whether Brooks Houck's bond should remain at $10 million cash while he awaits trial. That's right. Remember, that's not Brooks. Sorry, that's the wrong picture. There he is. In actual white and black jumpsuits, which I'll be honest, I don't think I've ever seen in any of the trials we've covered. I don't know if I've ever seen that before. Anyway, so in November, the State Court of Appeals ruled Houck's $10 million cash bond was appropriate, while agreeing with a lower court's opinion that Houck is a flight risk and could be a danger to potential witnesses. Houck's attorneys asked the state Supreme Court to review it, but the request was denied without explanation, and the order declining review was signed by Kentucky Chief Justice Lawrence Van Meter, who we brought up in the last one, who denied his last thing as well. He's like, no, we're not even doing it. Okay. So then, we got another document to read. March 7th, which is the day after that Supreme Court denial, Brooks Houck's attorneys file a change of venue motion. Yay. Okay. Let me, there we go. That's too big. Okay. So share this tab. Oh, boom, there we are. Why is it like that? I don't like that. Oh, that's too big. Okay, we'll just do that and we'll zoom it. There we go. Did it. Yeah. All right. So, all right. This again is Brooks' defense team submitting this. Hello. Good morning, Miss Behaven in Florida. Hope you're doing great. Good morning. We're just reading some court docs right now with some tea. All right. So this is defense saying they want to change a venue. So the defendant, Houck, by counsel, moves this court pursuant to KRS, whatever, to transfer the venue of this case to a neutral county. As Brooks cannot obtain a fair and impartial jury in Nelson County or any county in central Kentucky, including Fayette and Jefferson counties, due to the significant prejudicial pretrial publicity this case has received. The undersigned submits this memorandum in support of this motion. I mean, I agree. There's no way he was going to get a fair trial in Nelson County. No way. Absolutely not. And that's why they moved his theft one, because they were like, ooh, and it wasn't even related to Crystal Rogers. So, but they do say some interesting things in here. So let's read about it. So relevant background. Brooks has been charged with murder and tampering with evidence stemming from the disappearance of his then girlfriend, Crystal Rogers, in July of 2015. Shortly after Miss Rogers' disappearance, law enforcement myopically named Brooks as the sole person of interest in her disappearance. Nonetheless, Brooks cooperated fully with law enforcement, submitting to multiple interviews with the Nelson County Sheriff's Office, in which he denied any involvement in Ms. Rogers' disappearance. Yeah, this one has photos, guys. Inexplicably, local law enforcement made the decision to release portions of the police investigation into Ms. Rogers' disappearance to the media, which is very rare. Brooks' police interview has been played on national television because someone in local law enforcement made the unorthodox decision to release portions of an ongoing criminal investigation. Yeah, it's rare that they did that. Sorry, I'm going to attention. The Nelson County Gazette posted the entirety of Brooks' police interviews on its YouTube page. His July 8th, 2015 interview with Detective Snow at the Nelson County Sheriff's Office has been viewed 164,000 times. There's no way that's the highest watched video of Brooks's thing, but it's the local one. So the local news, 164K views. Good job, you guys. The decision to release information in an open case such as this one resulted in over 8 years of unabated media sensationalism that has increased exponentially with the passage of time. The Kentucky Standard, Bardstown's local newspaper, has published 237 articles about Brooks Houck. Brooks has become a pariah in Nelson County and the surrounding counties as a result of this constant media coverage. The footnote just explains that the police interview has been played on a documentary that Oxygen did. Oh gosh, and some other places. All right. Okay. Moreover, residents in Nelson County, and indeed throughout central Kentucky, are very likely to be aware of the tragic death of Tommy Ballard. In fact, the Commonwealth argued in Brooks' bond hearing that his brother Nick Houck was the primary suspect in the alleged murder of Mr. Ballard. The Commonwealth's assertion captured additional headlines in Nelson County and throughout central Kentucky. The spillover impact of this media coverage regarding the death of Tommy Ballard is unduly and unfairly prejudicial to Brooks and subjected him and his family to further intense public scorn. Well, that's facts. Facts. I'm sure it did not make things better for that family at all. As another division of the Nelson Circuit Court found back in 2019, Brooks simply cannot get a fair trial in Nelson County or any of the surrounding counties. Since 2019, media coverage of this case has only intensified, leading to the inevitable conclusion that such pretrial publicity is presumptively prejudicial and has tainted potential jury pools not only in Nelson County, but also any Kentucky county within the reach of the Louisville or Lexington media markets. As a result, for the reasons set forth below, Brooks moves the court to transfer this case to Boyd County or Daviess County. Now, here is their argument. So, Brooks Houck cannot obtain a fair trial in Nelson County or any county in central Kentucky because of the presumptive prejudice arising out of the publicity this case has generated. The KRS states that the judge shall order the trial to be held in some adjacent county to which there is no valid objection if it appears that the defendant or the state cannot have a fair trial in the county where the prosecution is pending. Further, Section 11 of the Kentucky Constitution provides that a defendant shall have a speedy public trial by an impartial jury, and the 5th, 6th, and 14th Amendments to the United States Constitution give a defendant the absolute right to due process and trial by a fair and impartial jury. Here, Brooks' state and federal constitutional rights to due process, a fair trial, and impartial jury would be nullified should this case be tried in Nelson County or any county in central Kentucky due to the nature and content of news coverage, which has contaminated the potential jury pools in those areas. I mean, I think we can all agree that, yeah, well, I'm probably going to need to move this. This isn't, I'm all about fair trials, right? And we ain't going to get one there. I mean, hell, the grand jury gave him a $10 million bond. So the grand jury, I think we cover some of the stuff that's come out from this grand jury, and it's wild. That might be Steven's trial, though. I might be getting confused. But anyway, so argument A. The pretrial publicity surrounding Brooks Houck in this case is so great that prejudice must be presumed. Kentucky's test to determine whether a fair trial is possible in cases with substantial pretrial publicity is derived from the United States Supreme Court decision in Shepard versus Maxwell in 1966, as adopted in Brewster versus the Commonwealth in 1978, and has been applied in nearly every Kentucky case analyzing pretrial publicity. The court should change venue if the defendant shows that 1, there has been prejudicial news coverage. Check. 2, it occurred prior to trial. Check. And the effect of such news coverage is reasonably likely to prevent a fair trial. Check. That's pretty easy. The court may find that pretrial publicity establishes the requisite level of prejudice reasonably likely to prevent a fair trial if there is evidence of either presumptive prejudice or actual prejudice. Now, presumptive prejudice is inherently found when pretrial publicity creates an inflammatory, circus-like atmosphere, which pervades both the courthouse and the surrounding community. If presumptive prejudice is established, a change in venue is warranted prior to voir dire examinations. Now, the United States Supreme Court has emphasized several factors to be considered in the analysis of presumptive prejudice, including, in relevant part 1, the size and characteristics of the community in which the crime occurred. 2, the nature of the news stories and whether they contained blatantly prejudicial information of the type readers or viewers could not reasonably be expected to shut from sight. And 3, whether the level of media attention diminishes in the time between the alleged crime and trial. Interesting. I did not know all of those things. In Jacobs versus the Commonwealth, 1994, which was overruled on other grounds by St. Clair versus the Commonwealth in 2014, the defendant, Clawvern Jacobs, Clawvern, that's an interesting name. Okay. Clawvern Jacobs was charged with the capital murder, kidnapping, and first-degree rape of an Alice Lloyd college student in Knott County. The trial court denied Jacobs' motion to transfer venue, despite the pervasive and prejudicial media coverage of the crime and Jacobs' prior conviction of a similar crime. Oof. On appeal, the Kentucky Supreme Court ruled that the trial court erred in denying a change of venue because, in looking at the totality of the circumstances, the pretrial publicity had been so inflammatory that it created a pattern of deep and bitter prejudice shown to be present throughout the community. During voir dire, the jurors displayed almost alarming knowledge of the crime. Wow. When such bias is found within a community, a change in venue is constitutionally required because prejudice is presumed. And, I don't think that says anything about the community, though. I mean, they're there. That's their life. They're going to hear all the things and they want to be up to date. I don't think just because a community is informed, there's anything wrong with that. But when it comes to trial time, it probably expect that trial to be moved. Right? And if you want justice for the victim, you're going to want the trial to be moved. So that way they can't appeal and get things overturned like what is happening in this story. Okay, where was I there? Let's see, I may stop before this, but I don't know. When such bias is found within a community, a change in venue is constitutionally required because prejudice is presumed. See also Irwin versus Dowd, 1961, holding that the defendant's right to an impartial jury was denied by a presumption of prejudice arising from extensive pretrial publicity consistently unleashed against the defendant in the year leading up to his trial, which led to the community pattern of thought that the defendant was guilty. In a recent distinguishable case, Hubers versus the Commonwealth, the Kentucky Supreme Court analyzed the impact of pretrial publicity. Oh, I know this case. In that case, Shana Hubers, you guys, if you don't know who Shana Hubers is, go Google that crazy lady. She's a crazy lady. Was charged with the murder of her boyfriend and convicted by a Campbell County jury. After discovering that a convicted felon served on the jury, Hubers was granted a new trial, which also resulted in a conviction. Hubers appealed her conviction, arguing in part that the trial court abused its discretion by denying her motion for a change of venue. In her motion, Hubers requested a change of venue from Campbell County and the surrounding areas in the Cincinnati, Ohio media market. Her case had been covered by local news stations as well as several national news organizations prior to the first trial. The trial court concluded that this was not a truly exceptional case in which the pretrial publicity was so great that prejudice could be presumed. The trial court found that Campbell County, a population of 92,211, was of such size that they should be able to seat 12 jurors and 2 alternates, and that most of the media coverage regarding the case occurred several years earlier, between 2012 and 2015. That's true. In addition, the trial court found that a significant period of time had elapsed between the height of the media coverage and Hubers' second trial, which occurred in 2018. I don't think either one of those trials were televised. I'm pretty sure they weren't, but man, do I wish they were. You should see her interrogation video. Oh my gosh. Her and Jodi Arias would be like besties. Oh yeah, she is a great singer. Such a great singer. She's so crazy. Oh my goodness. So given the size of Campbell County and the significant period of time that elapsed between the height of media coverage and the second trial, the Kentucky Supreme Court held that the trial court did not abuse its discretion in denying the venue transfer motion. The court noted it is not the amount of publicity which determines that venue should be changed. It is whether public opinion is so aroused as to preclude a fair trial. All valid points. Juju says, oh, was that the school counselor and her boyfriend was a law student? Was he a law student? She shot him in the face. I think he was dating Miss Ohio, Miss Kentucky. I don't know. She's wild. I think they were both students, or no, I think she was, but he was, I don't know. It's been a while. I just remember she then laughed and said, well, he wanted a nose job, so I gave him one or something. Crazy. All right. So where were we? So unlike Hubers, Brooks' case is the rare and truly exceptional case in which Kentucky law mandates a change in venue before attempting to seat a jury due to presumptive prejudicial pretrial publicity. Nelson County is not of such size to be able to seat 12 jurors and an alternate. Nelson County's population is approximately half of Campbell County's population, and unlike Campbell County, Nelson County is not part of a large metropolitan area. In addition, a quick Google search shows that the media coverage has only grown more intense, with each passing year. The Kentucky State Police, the Federal Bureau of Investigation, and other federal agencies have executed multiple search warrants at Brooks' personal residence, properties owned by Brooks or his family, and various other areas across Nelson County, as recently as December of 2023. Each of these searches garnered nearly nonstop coverage by local news outlets in central Kentucky. Many Nelson County residents display yard signs related to Miss Rogers' disappearance, some of which explicitly named Brooks long before he was ever charged in relation to this case. A billboard next to the Nelson County Judicial Center, within the clear line of sight of potential jurors on this case, prominently displays Miss Rogers' photograph and references that she was last seen with Brooks Houck, who is the main suspect in her disappearance. I love he says every time she says Brooks, I think Grams. All right. So a similar sign is posted at mile marker 14 on the Bluegrass Parkway, which is where Miss Rogers' abandoned car was found on July 5th, 2015. Countless cars bearing similar messages can be seen in the parking lot of the Nelson County Judicial Center every time this case appears on this court's docket. Presumably, these vehicles represent only a small fraction of cars with similar bumper stickers that drive around Nelson County and the surrounding areas every day to be viewed by potential jurors. You know, that's not great. It's not great. I mean, I'm not knocking them for having the bumper stickers. By all means, I think everything the community has done to raise awareness to find Crystal is amazing and wonderful. I don't think there's anything wrong with it, but it does mean that the trial needs to be moved. So, presumably, oh wait, no, I already read that part. In addition, in 2018, 3 years after Ms. Rogers disappeared, Brooks was indicted by a Nelson County grand jury, which charged him with 4 theft-related Class D felonies and 1 count of misdemeanor theft relating to alleged thefts from Lowe's. Brooks filed a motion to transfer the venue of that case away from Nelson County and its adjoining counties, based upon the negative publicity he received in connection with Miss Rogers' disappearance, which, importantly, is the basis of the charges he faces in this case. Notably, back in 2019, when venue was up for debate, the Commonwealth conceded and the court agreed the trial must be held elsewhere. The court granted Brooks' motion and transferred it to Warren County, noting as follows. Local news media and Louisville TV stations report events in these matters continuously and extensively. This is an excerpt, by the way, from that ruling. Local media and Louisville TV stations appear in force almost every time this case appears on docket. The case is the subject of intense social media scrutiny and other online chatter, especially locally. Crystal and Tommy's family members and supporters have placed yard signs and billboards throughout Nelson County. Some are also scattered around in adjacent counties. Family and supporters have also conducted well-publicized searches on foot and on horseback in Nelson and adjacent counties. So, yeah. The sheer amount of publicity this case has received in Nelson County and the surrounding counties is prejudicial in and of itself, but has also generated so much animus against Brooks that if venue were not transferred, members of a Nelson County jury would fear backlash if they voted to acquit Mr. Houck. Fair point. As indicated in the attached affidavits and letters, which have been filed under seal as Exhibit 2. I don't have those, guys. A number of Nelson County residents not only believe that Mr. Houck could not get a fair trial in the venue, but would also be afraid of retribution if they were to vote to acquit him. So it is hard to take a billboard down. Hello, raindrops and feathers. Hope you're doing great today. Oh, there's a little note here. It says, telling it was difficult to obtain affidavits in support of this motion without promising to seek to file the affidavits under seal in order to keep the identities of the individuals who submitted them confidential. They were saying a lot of people didn't want to talk about it unless we could promise that their names wouldn't be put there. Anyway, so they continue on. This is likely because anyone who speaks out in Mr. Houck's defense is publicly shamed by members of the community on social media. For example, a Nelson County resident and friend of the Houck family gave a brief and relatively benign statement to the media after the February 8th status conference in this case. Later that evening, an interested Nelson County resident posted a photo of the woman on Facebook in an attempt to identify her. Oh, you see that? Anyone know who this girl is? Yikes. Hello, Amy Beth. Hope you're doing good today, babe. Hello, hello, hello. Individuals commenting on the post use facial recognition technology to ascertain the woman's identity within 1 day of this post. Oh, wow. The post was shared nearly 90 times, and almost 150 comments appeared spewing messages of hate and vitriol toward the woman, with one commentator even going so far as to say she should be investigated by law enforcement for merely associating with the Houck family. Oh, wow. Oh, we get some unhinged Facebook comments, I'm sure. I love this. This is why I don't have social media, guys. It's crazy. All right, so somebody leaves a comment. Oh, this looks like Facebook. Oh, hell no. This woman deserves to go down with them. She's sticking her nose in something she doesn't want to be in. Seems to me she just wanted her 5 seconds of fame, but all it did was make her look ignorant. She needs to go back to Florida. She doesn't know a damn thing about this case. She only knows what the wife told her. If I was a detective, I would be investigating her. Ooh, okay. Because of the vast amount of media attention this case has gotten, the presumption of innocence no longer applies to Brooks in Nelson County. Fair. The below comments appear on a 2016 Kentucky Standard article about Brooks' grandmother exercising her Fifth Amendment privilege against self-incrimination. Ooh, more Facebook stuff. All caps, so you know it's good. Both brothers need to be shot and killed. They better watch their backs. Oh, these people. Fifth Amendment just shows guilt to me. They all should rot in hell for what has happened to Crystal. Okay. Wow. Yeah, that's something. Those are some comments. Yeah, people are very. It's rough. It's rough out there on the interwebs. Yikes. Nelson County residents have not been shy to express their opinions of Brooks since Ms. Rogers disappeared over 8 years ago. Although it would be impossible at this juncture to scour the internet for each and every comment threatening Brooks or stating that he should be killed or seriously injured. A sample of such comments are included below for purposes of illustration. Ooh, okay. I would never wish death on anyone, no matter the circumstances. So don't try to twist my words around. But it's crazy how Brooks has gotten away with murder and fucked over everyone he's come in contact with and hasn't gotten murdered yet. He's always out and about, so he's not hard to find. Just blows my mind. Then it's at the same comment. No, that looks like a different one. Somebody says, would somebody just do the town, society, and the world a favor and blow his effing brains out? I doubt he would be missed. Oh, wow. Oh, wow. It would be a damn shame if he disappeared like Crystal did, wouldn't it? If it was my daughter, Nick and Brooks would only have headstones for addresses. Jeez, that's okay. Wow. And it seems like someone should make that happen. These are sociopaths with no conscience. They did spell that right. They will never tell where Crystal is. Where Crystal is. Okay, those are okay. Those comments, not great. Not great. Although a criminal defendant's right to the assistance of counsel is enshrined in the Sixth Amendment to the United States Constitution and Section 11 of the Kentucky Constitution, the public's outrage at Mr. Houck has even turned towards his defense counsel. Facebook users have gone so far as to accuse defense counsel of being involved in Miss Rogers' disappearance, as illustrated in the post below. Oh, wow. Is the attorneys involved in the disappearance? No attorney in their right mind would defend Brooks. Sounds like he has a bunch of whiny baby attorneys beside him. No judge nowhere should put up with any of their crap. I know that's a common sentiment for a lot of people that like, oh, no attorney should ever represent this defendant. Like it's not, it's not what you think all the time. Everybody deserves a defense. Okay. Wow. Okay. And you know what? If I were him, I'd want this move too because yeah, I don't know if I would ever risk that. So unbelievably, some commenters have even accused the only female member of Mr. Houck's defense team of engaging in an inappropriate and unethical relationship with him after PLG TV 13, the local news station in Bardstown, posted photos of her merely sitting at counsel table with her client during the February 8th status conference. Oh, here's a post. Meetings with attorneys are not monitored, so it is very possible that they may have had a conjugal visit. Okay, guys, you see those all the time in trials. Oh, somebody's sleeping with it. Ain't nobody sleeping together, okay? With the exception of like one case that I know of. All right. And it's kind of another comment. Did anyone else feel like his brush up against the female attorney was inappropriate? I couldn't help but notice as he went around her to sit down. Also, she didn't seem to mind her personal space being invaded. I love watching crime documentaries, and this behavior is rarely seen. Oh, I got a comment for that lady. Also, the way he held his head unnaturally high feels like a circus to me. Good luck getting sympathy from jurors with your arrogance on full display. All right, so this poster who says, I love watching crime documentaries and this behavior is rarely seen. It's because they don't cover trials in crime documentaries, lady. All right, that's actually pretty normal behavior with defendants and their legal team. All right, it's not weird. Just calm down. Maybe watch some trials, okay? Because apparently you've never watched one if you think that this behavior is unusual. I mean, they have to have conversations. They have spent hours together on this case. Calm yourself, girl. Oh, goodness. Wild. There's a reason, again, why I don't have social media. It's because I'd spend all my time arguing, and that's not healthy for anybody. Polly Percy Pan says, good morning, everyone. What a terrible team member I am. I forgot you were live. Oh, no, you're not terrible. And good morning, babes. Juju Bean says, well, I understand how people feel. Of course. I feel the pig story really got to people. Again, no spoilers. No, I mean, I very much get people's outrage, right? I do. But at the same time, it's not helpful. And it's just... sometimes people talk about things that they don't know anything about. It's like, that's not, it makes it then really hard for me to take anything else they say seriously because it's like, no, but okay. Brendan and Bev might be doing it. I mean, anyway, furthermore, one only has to listen to the recordings of the 2023 Nelson County grand jury convened in relation to this case to see that the grand jurors had almost alarming knowledge of this case, similar to that of the jury in Jacobs. The questions the grand jurors asked of witnesses indicated they had extensive knowledge of the case, and several even made comments in support of the victim's family. While it is unfortunate that so many residents of Nelson County have prejudged the facts of this case and disregarded the presumption of innocence, it is unsurprising given the incessant and pervasive local media coverage of the disappearance of Crystal Rogers over the course of the past 8 years. Moreover, many, if not most, of these news stories contained blatantly prejudicial information of the type readers or viewers could not reasonably be expected to shut from sight. Law enforcement named Brooks as the primary suspect, so every single news article about Miss Rogers' disappearance reinforced the community's belief that Brooks is guilty. Further troubling is the connection the community believes exists between the Houck family and Mr. Ballard's death. Obviously, this connection was significantly and detrimentally reinforced during Brooks' bond hearing. Mr. Ballard's death and the alleged connection to Brooks' brother is exactly the type of blatantly prejudicial information that Nelson County and Central Kentucky jurors could not reasonably be expected to shut from sight. Now, as noted, sorry, my little llama's getting some breakfast. Good morning, little llama. Where was I? Okay, as noted by the Kentucky Supreme Court, the Commonwealth has the burden of establishing guilt solely upon the evidence produced in court and under circumstances assuring any accused, however worthy or unworthy, all safeguards of a procedure that is fair. These conditions are impossible when, as here, the minds of potential jurors are irredactably poisoned. That's not the right word. Whatever. Because there are some words I am not going to know, guys, and it's fine. Because the facts and circumstances in this case give rise to the presumption of prejudice against Brooks, the court must order a change of venue prior to voir dire. Now, argument B. There is no county adjacent to Nelson. Actually, you know what? Hey, little llama, will you come and refill my coffee, please?
Sure.
Please and thank you. You're the best. Isn't that nice of him? He's so nice. Hold on, while we wait for that, before I continue on with part B, let's look at some comments here. Jujubee says prayers for Crystal turned into the piranha feeding frenzy. Yes, yes. And oh yes, Juju. Tommy's death compounded the frenzy. Here you go, sweetie. Make sure you put some creamer in both of them, please and thank you.
Okay.
You got that? Thank you. Oh, my lovely assistant. All right. So, oh, I should have him put that. Oh well. So, argument B. There is no county adjacent to Nelson County or in Central Kentucky in which Brooks can receive a fair trial. Brooks cannot obtain a fair trial in any county adjoining Nelson County or any county within the reach of Lexington or Louisville media markets. KRS allows the court some leeway in making such a determination, stating, if the judge is satisfied that a fair trial cannot be held in an adjacent county, he may order the trial to be had in the most convenient county in which a fair trial can be had. The court has already carefully considered all adjoining counties in Nelson County as possible. Yes, honey.
What exactly do you want me to do, Tom?
Put coffee and creamer in them for me.
Sure.
That's all. Thank you. This court has already carefully considered all adjoining counties to Nelson County as possible jury trial locations for a case involving Brooks and found a fair trial could not be obtained in any adjoining county. Reasoning. Courthouse facilities and security are not sufficient in a bunch of other places. All have extensive family, business, social, and social media contacts with Nelson. Many persons from these counties work in and frequently travel through Nelson, and all adjoining counties are in the Louisville TV market, whose reporters cover these matters most intensely. Yes, they do. And it is because of all of them doing their amazing journalists that we've been able to tell this whole story. So, now further, as this court has previously recognized, if the trial is held in a county within, where's the lid, sweetie?
There's coffee and creamer. And those are given one.
There's what?
There's no more coffee and creamer.
There's no more coffee and creamer.
No more coffee and creamer.
Are you sure?
You know?
Okay. All right. Well, thank you, sweetheart. Oh, I have the latest right here. I could have drank all my coffee already, but okay. All right. So if the trial is held in the county within the Louisville media market, it would be difficult for jurors to avoid news accounts of the trial during the trial itself, either from seeing television accounts on one's own or hearing about it from family or friends. The media coverage has only intensified since the time of the court's 2019 order and today. Louisville's two largest news network, WDRB and WHAS 11, have published countless stories about Brooks. I know because I've read all of them, in addition to regularly running stories on the local news. Lexington media coverage is not any less exhaustive. A cursory search of Brooks Houck on the Lex 18 website generates over 1,000 results. I don't know if that's entirely true, but it's a lot. Oh, never mind. There's a picture. 1,059 results. This was in 2024, so I'm sure it is worse than that. Juju Bean says, thanks for reading all this. I lived in one of those counties listed in the document you are reading. You're welcome. I find this stuff very interesting. So it helps explain the more trials you go to watch, why certain decisions are made and the reasons behind it that aren't always argued, in front of a camera. It's another reason why I like documents. Good morning, Angie. Good morning. Hope you're doing good. No, Jojo B, we're never tired of anybody chatting here. Chat away. All right, so it says the media coverage has been so ambiguous, in fact, that even those who most vehemently believe Brooks is guilty question how difficult it will be to seat a fair and impartial jury. Ooh, we got more Facebook comments. The only way they would find an impartial jury is through sheer luck that some people don't know the case, or if they know of it but don't know all the facts. And somebody says, go overseas. Okay. Another person says the whole state of Kentucky knows about this story. They will have to pull people from other states. That's not how that works. I have followed this story from day one and have always believed what the truth will prevail in court. It just doesn't add up that she went missing and her boyfriend knew nothing. I have watched thousands of Dateline cases, and one day this story will be on it. Praying for Sherry Ballard, and they tag Sherry. Someone said, unfortunately, that's not true. I deal with lots of people in southeastern Kentucky, and no one knows anything about Crystal or Tommy. I tell it to anyone that will listen. Now, as a result, in accordance with KRS, Brooks requests the court order a change in venue in this matter from Nelson County to Boyd County. Boyd County and Nelson County are demographically similar, and Boyd County is located outside of the Louisville and Lexington media markets, making it a suitable location for this trial. Boyd County's local news stations are based in Huntington and Charleston, West Virginia. Okay, so that side. All right. In addition, Boyd County is convenient for the parties, counsel, and witnesses, as it has at least 8 hotels, with numerous others located a mere 20 minutes away in Huntington, West Virginia, which is a larger metropolitan area. In addition, Boyd County is less than 3 hours from Nelson County. Oh, that's pretty far. In the alternative, Brooks requests the court order a change of venue to Daviess County. Yeah, I think Boyd sounds way too far away. That's pretty inconvenient on the family and witnesses. That sounds like a logistical nightmare. Although Daviess County is a bit larger, it is otherwise demographically similar to Nelson County. Owensboro is less than 2 hours from Bardstown. Okay, a little bit more reasonable. Yes, as Lady and Grace says, we love all of our chatters, lurkers, members, and replay crew. Hello, we like all of you. Linda 4OK. Hey, I haven't seen you. I hope you're doing great, babes. I guarantee you there are plenty of people left in Kentucky who are completely clueless, who pay zero attention to the news. Find a lot of them for juries, and it's sort of a shame. Yeah, I mean, it, yeah. I mean, that's the thing, right? It was like people are like, oh, but everybody knows. And no, there are people that literally don't know anything. And there are people that still don't know anything about Karen Reed. Okay. I was just at a wedding where nobody knew what I was talking about. I was like, okay, well, I guess I'll just sit here and drink by myself some more. Now, some members of the veneer in Boyd or Davis County will inevitably have knowledge of this case. But given the location of these counties outside of the Lexington and Louisville media markets, that is less likely. Moreover, it is even less likely that such knowledge would be derived from pervasive and prejudicial media coverage that would render potential jurors biased against Brooks from the outset. There is no pattern of deep and bitter prejudice against Brooks present in Boyd or Davis County. Now, those are just statistics on their demographics there on the footnotes. Wherein before, Brooks Houck respectfully requests that the court grant his motion to change a venue and move it out of Boyd County or in Davies County. Look at that. We got through another one. Oh my goodness. Okay. So what do we have to go back now to? Okay. So we did that, the change of venue. Okay. So we're now on, what do you guys think after we've read that? Do you guys think that a change of venue, they made a good argument for a change of venue? Or do you guys feel like no matter what, they should have stayed in Nelson County? Spoiler alert, they are not in Nelson County, but how do you guys feel about that ruling? I thought it was a pretty good, fair argument. All right, so March 14th. Nope, that's not him. Special Prosecutor Shane Young files motion to consolidate trials. Young argues the facts and evidence in the case are identical, overlapping, and would be admissible if the three men were tried together or separately. He accused the men of killing Rogers and disposing of evidence to conceal the crime. A joint trial will ensure a jury be given the complete picture of what occurred on July 3rd or July 4th of 2015 and the involvement of each defendant, Young said in his motion. Young said if the trial is moved to another county, it would be another reason to hold a joint trial. Quote, requiring multiple trials is another venue would certainly be a waste of judicial resources when the cases involve the same facts surrounding the same events, he concluded. I don't know how trying all these together is a good idea. Oh, but okay. Just a second, because I was getting a bunch of phone calls. Sorry, I'm about to read another long document. Just a second. I got a one. Okay, you guys. So I'm about to read another 24-page document. Okay. Can we just chill here for like a few minutes? I have to return a phone call real quick and use the bathroom. I promise it will not be longer than a few minutes. So hold on just a second. You all go take a bathroom break. Don't go anywhere. Don't go anywhere. And I will be right back in just a few minutes. Okay. Okay, guys, I'm back. Sorry, back kind of frantically. Thank you for being patient and entertaining yourself. Sorry, I had a phone call I really had to make. It was very important. And it kind of sucks when I'm in the middle of just reading and not having a video to show you guys. So I do apologize for that. But everybody back from the bathroom now, feeling all refreshed for our other document. All right, so let's pull up this document. And we're going to share this. Ooh. How do I get rid of this side? I did that last time. I think that one. Yeah, there we go. And we'll make it bigger so everyone can read together. All right. Oh boy, that's so bright on my face. All right. So who do we got here? This is Houck's attorney submits a response in objection to the Commonwealth's motion to consolidate. Right? Okay. So the prosecution's like, we want to try both the Lawsons and Brooks together. And this is Brooks' defense team being like, yeah, no, we don't want to do that. We want our trial to be separate. Okay. And by the way, there was plenty of coffee left, but I'm also out of creamer, and that makes me sad. Oh, Buffy, if you're listening. All right. So the defendant, Houck, Brooks, by counsel, and in response to the Commonwealth's motion to consolidate this matter with pending criminal cases involving Steven Lawson, which they spelled wrong, and Joseph Lawson's hereby objections. In support of this response, the undersigned states as follows. So factual background. Let's see why Brooks and them are like, yeah, no, we want our separate. On or about July 4th, 2015, Crystal Rogers disappeared. On July 5th, 2015, her family located her abandoned car on the Bluegrass Parkway. In the days and weeks after Ms. Rogers' disappearance, Brooks cooperated fully with the investigation. He submitted to interviews with the Nelson County Sheriff's Office and the Kentucky State Police. He gave law enforcement permission to search wherever they needed to search. And despite his meaningful cooperation, local law enforcement named him as the main suspect and, unbelievably, went so far as to release significant portions of their ongoing investigation, including Brooks' voluntary police interview to the media. As a result, the media attention and sensationalism surrounding this case has risen to a level rarely, if ever, before seen in the Commonwealth. Okay. Public curiosity has been amplified further by social media, as we learned with the last document. The outsized media coverage of this case led to intense mounting pressure on law enforcement to charge someone in connection with Ms. Rogers' disappearance. As a practical matter, the appointment of a special prosecutor to investigate this case was not a mandate to investigate Ms. Rogers' disappearance, but to charge an attempt to convict Brooks Houck. Police interviews of Joseph Lawson and Steven Lawson clearly indicate that they became collateral damage in law enforcement's effort to fulfill their mandate. Oh. So they're saying that none of this was actually about solving what happened to Crystal. They just wanted to blame this on somebody and prosecute somebody regardless. Okay. The Commonwealth lacks dispositive proof that Miss Rogers is deceased. If Miss Rogers is deceased, the Commonwealth can do no more than guess at who killed her, how she died, why she died, and where she died. There is no crime scene, murder weapon, or realistic motive for the alleged crime. Ms. Rogers' body has never been found. And while the Commonwealth will surely represent to a jury that it does not need a crime scene, a murder weapon, or even the body of the alleged deceased to proceed in a murder case, the nearly 9 years law enforcement has spent digging up subdivisions and farmland across Nelson County tells a different story about what they know is important. Oh, and they have done so many searches for so many years. Desperately needing to solve this case, the Commonwealth sought to mask their evidentiary problems by targeting the Lawsons with the goal of getting either or both to cooperate against Brooks. The intense pressure and astounding promises required to achieve the goal of obtaining the testimony necessary to indict and arrest Brooks is simply unprecedented. By way of example, Kentucky State Police Detective BL, these are the people that Steven's lawyer referred to as well, told Steven Lawson, "You have a blanket to get out of murder." Unsurprisingly, given the amount of pressure brought to bear of these two men, the coercive tactics implemented, and the incredible promises made to obtain their cooperation, law enforcement was able to elicit multiple inconsistent statements from Steven Lawson and Joseph Lawson. Some combination of these statements enabled the Commonwealth to indict and detain Brooks. Understanding the prosecutorial and investigative bias that laid the foundation for these statements is crucial to the analysis as to whether consolidation is appropriate. Okay, so they're going to bring attention to Steven Lawson. So the Commonwealth subpoenaed Steven Lawson to testify before the Nelson County Grand Jury on May 10, 2023. His testimony did not incriminate Brooks and was generally consistent with his 2015 grand jury testimony, as well as previous interviews he had given with the FBI and Nelson County Sheriff's Department. As a result, he was indicted on May 24th, 2023 for tampering with physical evidence. Steven Lawson was arrested on June 8th, 2023, which is when negotiations began to obtain an incriminating statement against Brooks. Steven Lawson was promised immunity. The detective told Steven Lawson that he was being offered the opportunity of a lifetime and that these charges can disappear. The special prosecutor advised, "I have the power today, okay? I done talked to the judge. You can roll on home tonight." Of critical importance, the prosecutor stated, "Let me give you this much. What you say today is considered plea negotiations. Once I arrive, the whole game changes, okay? And it's a rule. There is a criminal rule on it. I don't remember off the top of my head, but anyway, what you say today will not be used against you, okay? I can promise you that. If you are 100% honest with me, this all just goes away, okay? 100% honest with me, and that means all of it. You are. I'll take care of you, and I'll take care of Rebecca, all right? You hold the key to this." Hello, Kelly P. Hello. Hope you're doing great today, babes. It was clear from the beginning that everything Steven Lawson said was part of ongoing negotiations to achieve the ever elusive carrot of immunity being dangled by the prosecutor. As noted in Steven Lawson's motion to dismiss, or in the alternative to suppress statements, the following is a timeline of key statements made by the police and the prosecutor of Steve Lawson. It looks like these might be the same as what was in the other one, but we're just going to read them regardless, just in case. And maybe some others that are just joining us didn't hear our other document that we read. So there we go. So Detective BL says, "My goal is to have you home this evening." Detective BL also says, "Our goal is to not ruin your life. We do have a prosecutor on hand today, okay? If you was to want some kind of deal, there could be some kind of immunity, depending on what you say. You benefit us. We are wanting you to work with us. We want your cooperation. I don't want you to worry today that if you divulge something, you are going to get time. If that's a worry for you, we have the Commonwealth attorney on hand on the property to where we can make you an offer. Now, the other detective stated, we are offering you the opportunity of a lifetime. You can say whatever you want, as long as it is 100% the truth, regardless of the incriminating nature of what you say, and you can walk out of here today. Then the other detective walked in the room and stated, I was just talking to the Commonwealth attorney. We are good to go. And now Detective TH repeated his statement that Steven Lawson could say what he wanted, regardless of the incriminating nature, and still go home that day. Detective BL says, I want you to be comfortable that anything you say, it's not going to be held against you. Detective BT repeated what Detective BL said and advised that the Commonwealth attorney is on his way. How much you want to bet the detectives, their first names are Brian. Oh, wait, we learned what their names was in the other thing, but I forget now. Special Prosecutor Shane Young walked into the room and advised Steven Lawson that he is the prosecutor on the case. Mr. Young says, if you are 100% honest with us, I'm going to help you. I'm going to help you. It's on the record. It's on tape. Whatever you say to me, I am not going to use it against you. I have the power today, okay? I done talked to the judge. You can roll on home this evening. Steven Lawson says, I want that in writing. Whatever I say is cool. Mr. Young, let me give you this much. What you say today is considered plea negotiations. Once I arrive, the whole game changes, okay? And it's a rule. There's a criminal rule on it. I don't remember off the top of my head, but anyway, what you say today will not be used against you, okay? I can promise you that. If you are 100% honest with me, this all just goes away, okay? 100% honest with me, and that means all of it. You are, I'll take care of you, and I'll take care of Rebecca, all right? You hold the key to this. Steven says, okay, I'll talk to these gentlemen then. Mr. Young, if you need me, I'll be right out here. Mr. Young walked out to watch the interview on a monitor. Detective BL, this is important, the big one. For you to get immunity, it has to be 100% honest. We are going to give your son the same deal. Mr. Young comes back into the room. I've been doing this 25 years, and I've never extended this offer to anybody ever. I've never done it. I've identified people who are involved, but low enough involved that I'm willing to give them immunity. You're it for me. Then Mr. Young re-enters the room, says, I'm listening to this. I'm going to call bullshit on this. Why the fuck would you tell that story? You need to cut the bullshit and you need to come fucking clean. I'm giving you blanket immunity. Take advantage of it. Detective BL says, this is your life. You and your wife's freedom is in your hands. You have a blanket to get out of murder. And Mr. Young says, I don't care what your role was. I don't care Joey's role. You go home. Tell 100% of the truth. He also says, you're telling most of the truth. It's getting late. In order for you to not go to jail, I got to call a judge. Detective BL says, you're going to have to come back to the grand jury and tell the truth this time. Steven Lawson said, I'm confused again. And Mr. Young stated, no, you're not confused. If you walk out of here, I'm treating you as a witness, not a defendant. Mr. Young also says, I think you have been about 70 to 80% truthful with me. At this point, you don't have immunity. Mr. Young stated, here in the next couple of days, we're going to have to come to the rest of the way for you to get this. Then June 14th, Steven testifies before the grand jury. This is like pretty much the same, but that's okay. Whatever. We'll keep going. It's fine. All right. So June 14th, another interview involving the prosecutor, the two detectives, and Lawson. Detective BL. We are going to try to straighten a few things up. You are here based on an agreement between your attorney and the Commonwealth attorney. That's a full cooperation agreement. The other detective says, the more you tell us, the more you help, Steve. Steven Lawson said, I don't want to get things backwards. I will get into trouble. Detective TH says, if you want us to go to Shane, the prosecutor, and tell him you are good, you need to make us believe everything you say. Detective BL, you are facing 20 years. At one point during the interview, Steven Lawson, what do you all want me to say? Mr. Young again said that he is offering immunity, but that everything has to be truthful. This makes a lot more sense to something that we'll talk about later. This document, I mean, not necessarily what they're saying, but oh yeah, they're not wrong. Detective BL says, when we leave here today, if we uncover something else, I don't know that you will get this deal. Then we have the August 22nd, 23 interview, same players. Detective BL, we're going to kind of start back from the beginning. We're going to get it all on tape. And we're going to get a good statement. Your attorney is present. The prosecutor is both present and observing in a separate room. There has been some discussion worked out as long as you are honest and truthful. TH says you are at a crossroads. You are going to have to come clean. BL says you are going to have to come clean. We are trying to save your ass. Detective BL says the more stuff you say, the more truth you say, the more freedom. This is a gift like I've never seen. Steven says, I put myself on your side of the table. I want to be on your team and your team more than you will ever know. That's a fact too. BL says, this is the rest of your life. TH says, you got to take this all the way home, Steve. BL says, you're going to have to get real about this, Steve. Steve, I don't want to send you to the penitentiary. I'm getting ready to walk out, and you know who's going to be going to the penitentiary. Steven says, you all act like I don't want to be a part of your team. So then they have the September 12th interview. Detective BL, man, before we get started, I want you to think about some things. Your mama, you want to see her, right? Your mother, your wife, your grandchildren, your retirement. Think about these things. You could take your last breath in the penitentiary. That's not what we want. Steve, you got to clean this shit up now. This is for you. Your mom is sitting out there right now. At the time, Mr. Young walked in the room viewing the interview on the monitor. Mr. Young says, nobody thinks you hurt her. Get back on point. Take that out. You are frustrating me. And then Mr. Young leaves the room. BL says, we got to bring this home tonight, Steve. Steve says, y'all are helping me tremendously, and I hope I've helped you all. Both the detectives say, you have. And Steven Lawson says, I don't want to get hemmed up and go to prison. So then on September 20th, Steven testifies again in front of a grand jury. And after the grand jury, per Steven Lawson's previously filed motion, he continued to cooperate with the investigation as part of ongoing negotiations. In December 2023, the Commonwealth indicted him for conspiracy to commit murder. Steven Lawson was arrested and has been detained ever since. None of Steven Lawson's statements from June 8th, 2023 to the present are admissible. They were all made as part of ongoing plea negotiations. Now, let's get into Joseph Lawson. Like his father, Joseph Lawson was initially charged with tampering with physical evidence in a sealed indictment. On June 21st, 2023, Joseph Lawson was arrested and taken in for an interrogation by the Kentucky State Police. If anything, Joseph Lawson's interview was even more troubling than law enforcement's multiple interviews of Steven Lawson. Oh, interesting. So, to provide some context for some of the statements outlined below, Joseph Lawson has paraplegia as the result of a motor vehicle accident. As outlined in Joseph Lawson's bond reduction motion, he cannot voluntarily move the lower half of his body and is confined to a wheelchair. The interview began with Joseph Lawson's clear invocation of his Sixth Amendment right to counsel, which was blatantly ignored. Interesting. Constitutional niceties are secondary to solving this case. As they did with Joseph Lawson's father, law enforcement dangled the carrot of immunity with the prosecutor on hand and with his express authorization. Joseph Lawson's interviews with the Kentucky State Police and the prosecutor were also part of plea negotiations and represent an effort to concoct a sufficient story to secure an immunity deal. So look at that. Joseph's trying to get immunity too. Interesting. The lengthy interrogation on June 21st, 2023 started with police ignoring Joseph Lawson's clear invocation of his constitutional right to counsel and included Joseph Lawson telling law enforcement, with the prosecutor listening from a parked vehicle yards away and periodically joining the interrogation, that he had urinated on himself because he did not have a catheter or a diaper. Oh. At one point in the interview, Joseph Lawson advised law enforcement that they had kept him so long that he had not only urinated on himself, but also defecated on himself. Oh, that's in this footnote here, footnote 10. It says, interview with Joseph Lawson, body cam 2. The interrogation went on for several hours after Joseph Lawson invoked his right to counsel. The conduct of law enforcement during a subsequent interview of Joseph Lawson that occurred on August 28th, 2023 in the Grayson County Detention Center was argued. Can you guys just hold on for a second? I'm sorry. I do have to take a phone call that just came in. Sorry, guys. Okay, sorry about that. Oh, so I'm just busy today, apparently. Everybody wants to call me. Usually nobody calls me. And today they're like, oh, I forgot you do this thing where you stream and aren't just readily available at all times. Anyway, thank you guys for being patient. All is well. Okay. Let's see some of these comments before I get back to constitutional niceties, right? Lady in Gray says, who can be bothered with that pesky Constitution? I know. Pesky little thing. Kelly P tried to start some trouble in the chat. LWP says, these detectives are wild, ignoring civil rights, calling them niceties. That's scummy behavior. And then they will hide being qualified immunity That crime drama attitude is what's wrong with policing. And Kelly P says, sounds canon adjacent. You guys, you're not even prepared for all the bananery from here on out. Okay, it's wild. I think it might be worse than Karen Reed stuff. I'm just saying, it's wild, but we're going through it together and then we'll see. All right, so let me start this back over here. The conduct of law enforcement during a subsequent interview of Joseph Lawson that occurred on August 28th, 2023, in the Grayson County Detention Center was arguably even more shocking than in the June 21st, 2023 interview. The representations law enforcement made to Joseph Lawson strain credulity. That's a hard word. Credulity. Okay. Credulity. Okay. Anyway, desperate to indict Brooks, Detective BL told Joseph Lawson, whether you killed her or not wouldn't be our concern. Detective BL further stated, we are trying to get you out of a crime. Oh. The following is a timeline of key statements made by the police and the prosecutor to Joseph Lawson. Ooh, we have not read any of these yet. All right, so June 21st, 2023. This involves, again, the prosecutor, detectives BL and TH, and Joseph Lawson. I don't think he has counsel. Oh, no, he doesn't. All right, so BL says, we already have with the special prosecutor from the Attorney General's office who has been assigned to this case. We have permission to set aside your warrant based on your cooperation. It does me no good for you to go to the penitentiary. If we call the Attorney General this evening, he will be here and he will make arrangements for you to go home. Joseph says, I'd rather have a lawyer present. Oh, thank you, Kelly P, for gifting 5 memberships. Thank you so much. I appreciate you and your support, and congrats to all the new members. Thank you so much, Kelly. Appreciate that. BL says, you want to talk to us, we can call the Attorney General and get you a deal, or you can talk to an attorney. Joseph Lawson says, I have urine in my pants right now because I don't have a catheter or diaper. BL says, you're fighting with us and we are not fighting with you. We are offering you something. Joseph says, I'll take your offer. Joseph says, I'm not trying to go to jail. And BL says, this is a forever life changer. Mr. Young, prosecutor to Lawson, got a chance for you and me to get something worked out, but you have to tell me the truth. Here's what I'm telling you. I want to help you. Need 100% truth. You have a chance to go home tonight. Already cleared it with the judge. I'm not the police. I'm just the prosecutor, and I need you to talk to these guys. TH says, we can help you. Get on your side. We can help you with these charges. Joseph asks, what's that thing they offered last time, the FBI? BL says, immunity in response to Joe's question. TH says, it's got to be balls ass honest. Oh, that's a new phrase I've never heard before. Balls ass honest. Okay. Adding that to our favorite phrases. You tell the truth, I promise you will go home. Joey says, you heard me say I wanted my lawyer. Again, questioning did not cease. Mr. Young, who was listening from a vehicle in the parking lot, approached Joseph Lawson and they began cussing at each other. Detective BL, you're going to the penitentiary. Young, while walking away, yells, roll his ass in there, the jail. Mr. Young returned from listening to the interrogation and told Joseph Lawson he called the judge. He, the judge, told me I can let you go if I want to. I'm leaning towards letting you go. If you help me, I will take care of you. I don't lie, Joey. I need to connect the dots. Joey says, I pissed and shit myself. BL says, there's a clause. You can have whatever you want as long as you tell the truth. Young says, don't be hiding from us after he decided to release Joseph Lawson from custody. Detective BL, in the presence of Mr. Young, do not make us look for you or the deal is off. Joey, this deal is with your full and honest and complete cooperation, which means we are probably going to have to call you in multiple times to come in and talk to us. At the conclusion of this lengthy interrogation, and after Joseph stated multiple times that he had urinated and defecated on himself, Detective BL says, you need him to take you to a hospital or anything, Joey? The only reason you are here is because of your attorney at the time. Joseph Lawson says, what can y'all do for me? TH says, oh, I'm sorry. This is an August 28th, 2023 interview. So this is, right? Different than the one we just read. Yes, that was in June. I'm sorry. So we're in August 28th, 2023. The only reason you are here is because of your attorney at the time. Joey says, what can y'all do for me? TH says, we can talk to Shane. Long term, we can get you out of here. BL says, Steve Lawson is already cooperating, and it would help us if somebody would tell us what Steve has already told us. BL says, need you as a witness. Joey says, I'll be your witness. BL says, whether you kill her, Crystal Rogers, or not wouldn't be our concern. TH says, nothing you say will be used against you. We are trying to get you out. It doesn't matter what you tell us. We are trying to help you. Shane Young set up the meeting at the jail here for us and you. We're trying to get you out of a crime. Now, likewise, none of Joseph Lawson's statements from June 21st, 2023 to the present are admissible. They were all made as part of ongoing plea negotiations. Okay. Okay. Their argument. Kentucky Rule of Criminal Procedure authorizes the court to join for trial two or more defendants if they are alleged to have participated in the same act or transaction or in the same series of acts or transactions constituting an offense or offenses. However, it also requires that trials be severed or defendants not joined if it appears that a defendant or the Commonwealth is or would be prejudiced by the joinder. In this matter, Brooks would be unfairly prejudiced by consolidation. So the Commonwealth cites Commonwealth v. Rogers from 1989. Oh, that's interesting. In support of consolidation. So Rogers requires a defendant to prove that joinder would be so prejudicial as to be unfair or unnecessarily or unreasonably hurtful. As outlined below, a joint trial of Brooks, Steven Lawson, and Joseph Lawson would meet the standard of prejudice set forth in Rogers. The Commonwealth's motion to consolidate fails to acknowledge any of the complex evidentiary issues at play with regards to these three defendants, likely because doing so would be a public admission that its case against Brooks is based in large part upon the inconsistent statements elicited from Steve Lawson and Joseph Lawson after subjecting them to hours upon hours of coercive interrogation tactics and promising them a get out of jail free card if they say what law enforcement needed to charge Brooks. If the Kentucky rules of evidence and the Sixth Amendment are applied appropriately in this case, There is no way for the Commonwealth to present its case against Brooks at a joint trial while still complying with the Sixth Amendment. The reality is that the Commonwealth has used statements elicited from Joseph Lawson and Steven Lawson to attempt to tie together circumstantial, at best, evidence and innuendo to build a case against Brooks. If that were not the case, Brooks would have been charged in connection with Miss Rogers' disappearance years ago. Tellingly, he was not indicted until after statements were extracted from Steven and Joseph Lawson. That's a fair argument. Liz mom says, working and lurking, your voice is keeping me out of trouble. Oh, thank you. You're going to hear it a lot today, so thank you. So a joint trial in this case would violate Brooks' Sixth Amendment rights. He has a right to expose the investigative bias that led to his charges and impeach the inconsistent statements Joseph Lawson and Steven Lawson gave to law enforcement. Further, he cannot mount a meaningful defense without showing the jury, the tactics law enforcement employed to elicit statements from the Lawsons. Oh, now I'm all burpy, that's fine. Given the interplay of the Kentucky Rule of Evidence 410, it would be impossible to do so in a joint trial, since those statements are inadmissible against Joseph Lawson and Steven Lawson. In addition, even if the Lawson statements were properly redacted to remove any reference to Brooks, given the landscape of this case and the distinct role he is alleged to have played, such statements would inculpate him in violation of his right to confront adverse witnesses. For these reasons, Brooks should be tried separately from Joseph Lawson and Steven Lawson. Number one, exposure of a myopic and biased investigation. Ooh. The interviews of Steven Lawson and Joseph Lawson demonstrate a get Brooks mentality that colored every decision made by law enforcement in this investigation. Police represented to both Lawsons that they were not concerned whether either of them murdered Crystal Rogers, as long as they agreed to cooperate against Brooks. Joseph Lawson and Steven Lawson were told that it did not matter what they admitted to, as long as they helped the police get Brooks. The prosecutor said, quote, "I don't care what your role was. I don't care Joey's role. You go home." Police repeatedly told both Joseph and Steven Lawson that they were reporting directly to high-ranking officials. The bias and pressure to charge Brooks demonstrated throughout these interviews is palpable. Brooks has a right to defend himself against these allegations and has every right to expose the bias in this investigation. The issue, however, is that none of these interviews are admissible against Joseph or Steven Lawson. KRE 410 specifically states that evidence is not admissible against the defendant who was a participant in the plea discussions, which includes any statement made in the course of plea discussions with an attorney for the prosecuting authority which do not result in a plea of guilty. On June 8th, 2023, the prosecutor told Steven Lawson, "If you are 100% honest with us, I am going to help you. I am going to help you. It's on record. It's on tape. Whatever you say to me, I am not going to use against you. Let me give you this much. What you say today is considered plea negotiations. Once I arrive, the whole game changes, okay? It's a rule. There is a criminal rule on it. I don't remember off the top of my head, but anyway, what you say today will not be used against you, okay? I can promise you that. Now, Detective BL said, we are going to give your son the same deal. Steven Lawson's testimony before the Nelson County Grand Jury on June 14th, 2023, and September 20th, 2023, were also part of plea negotiations. Detective BL made that abundantly clear during Steven Lawson's June 8th interview when he said, in the presence of the prosecutor, you're going to have to come back to the grand jury and tell the truth this time. The goal of this condition on Steven Lawson's promised immunity deal was, of course, for him to provide enough information to the grand jury to ensure Brooks was indicted. Every interview or statement Steven Lawson gave and Nelson County Grand Jury appearance he made after June 8th, 2023, are part of the continuing course of plea negotiations with Lawson attempting to secure an immunity agreement. Now, Joseph Lawson's interrogation began with Detective BL stating, we already have, with a special prosecutor from the Attorney General's office who has been assigned to this case. We have permission to set aside your warrant based on your cooperation. Later in the interview, the prosecutor reiterated to Joseph Lawson that you got a chance for you and me to get something worked out, but you have to tell me the truth. It was equally clear from Joseph Lawson's interviews that he is likewise attempting to finalize an immunity agreement. Pursuant to KRE 410, none of Steven Lawson or Joseph Lawson's statements from June 8, 2023 to the present are admissible against them. In Roberts versus the Commonwealth, 1985, the Kentucky Supreme Court defined plea discussions as discussions in advance of the time for pleading with a view to an agreement whereby the defendant will enter a plea in the hope of receiving certain charge or sentence concessions. In Roberts, the court adapted a two-pronged test to be applied in determining whether a conversation should be characterized as a plea discussion. Oh, Steven's lawyer mentioned this, but we'll do it again. The two prongs are, one, whether the accused exhibited an actual subjective expectation to negotiate a plea at the time of the discussion, seems like it, and two, whether the accused's expectation was reasonable given the totality of the objective circumstances. Now, in Roberts, the defendant struck a bargain that he would not be charged as a persistent felony offender, a PFO, if he gave a truthful statement. The defendant's statement was not truthful, so the court ruled that the Commonwealth was not bound by its agreement and could charge the defendant as PFO. But the court also held that Roberts' statement was made in the course of plea discussions with the prosecutor. Consequently, that statement was not admissible because against him at trial. This is so interesting. You guys don't know why this is so interesting, but you will. Once we get to August, you'll be like, oh, what? Because I didn't see it the first time I read these, but I am seeing it now. In Krebs versus Commonwealth, 2009, the defendant said he would be willing to provide a statement in exchange for reduced charges. Initially, the detective said he did not have the authority to make such an arrangement, but ultimately talked to the prosecutor, who said he did not have a problem reducing Class C felonies to Class D felonies. It's very interesting how this document's like almost verbatim to the other one. Afterwards, the defendant confessed. The Kentucky Supreme Court reversed the conviction, finding that the defendant's statement should have been excluded pursuant to KRE 410. Krebs makes it clear that when police officers represent to a defendant that they are acting with the authority of the prosecutor, they can also bind the Commonwealth, as the Kentucky State Police detectives interviewing Steven Lawson and Joseph Lawson did here. Both Lawsons exhibited a subjective expectation to achieve a resolution where they would not go to jail. Stephen Lawson agreed to talk with police after the prosecutor told him that because they were engaged in plea negotiations. Nothing he said would be used against him. Joseph Lawson inquired about immunity in his discussions with police and the prosecutor. Both Lawsons sought to avoid jail time by saying whatever they needed to say to obtain the immunity offer that was dangled in front of them. Moreover, the expectations both Lawsons had that they were involved in negotiations was certainly reasonable. I'm going to have to agree there. The prosecutor was not only present, but actively involved in these interrogations. The prosecutor and the detectives acting at his behest offered immunity. The prosecutor and the detectives acting as his direction made statements that nothing either defendant said in their interviews would be used against them. It could not be clearer. The statements made by Joseph Lawson and Steven Lawson from June 8th, 2023 to present are inadmissible against them, pursuant to KR 410. Law enforcement's myopic focus on Brooks demonstrated throughout these interviews is not only relevant, but crucial to Brooks' defense. However, introduction of any portion of these statements in a trial involving Steven Lawson or Joseph Lawson would be improper. Denying Brooks the ability to question law enforcement officers about statements they made in these interviews would improperly curtail his right to defend himself and demonstrate to the jury the level of bias that has tainted this investigation since its inception. As such, Brooks cannot be tried jointly with Steven Lawson and Joseph Lawson. 2. Brooks is entitled to impeach Joseph Lawson and or Steven Lawson with all of their statements. Brooks has a constitutional right to probe and expose methods by which law enforcement extract statements from Joseph Lawson and Steven Lawson, in addition to the inherent bias of these witnesses and the inconsistent statements they made. This poses a problem if all three defendants are tried together, since such statements are inadmissible against Joseph Lawson and Steven Lawson pursuant to KR 410 and potentially other evidentiary rules as well. The exposure of a witness's motivation in testifying is a proper and important function of the constitutionally protected right of cross-examination. Now, Davis versus Alaska in 1986. That's where that came from. My apologies. The United States Supreme Court has deemed it reversible error when the trial court excluded evidence that a key prosecution witness's criminal charge had been dismissed after he agreed to talk with investigators about a murder. Steve Lawson testified in the Nelson County grand jury in 2015. He was interviewed by the FBI in 2020. Moreover, the FBI utilized a confidential informant to surreptitiously record Steven Lawson. Ooh. Likewise, Joseph Lawson was interviewed by the FBI in 2020. Ooh, we got some footnotes here. Let's read these. So, footnote 23, importantly, in the recording obtained by the confidential informant, Steven Lawson did not implicate himself or Brooks. In fact, he affirmatively stated that he did not think Brooks had anything to do with Miss Rogers' disappearance. The other footnote 24 says, the FBI's interview was conducted as part of a proffer agreement in the presence of an assistant United States attorney. Pursuant to the federal proffer rules, the statements cannot be used against the defendant unless the defendant later testifies inconsistently with his proffer statement. Okay. Additionally, a couple of individuals who admitted to being actively addicted to heavy drugs at the relevant points in time, claim in interviews with law enforcement that Joseph Lawson or Steven Lawson made incriminating statements to them as well. Oh boy. Steven and Joseph Lawson's pre-June 2023 statements, with the exception of Joseph Lawson's federal proper examination, may be introduced against them through federal agents, testimony of lay witnesses, and testimony of a confidential informant. Steven Lawson's and Joseph Lawson's subsequent inadmissible statements are not only frequently inconsistent with each other, but wholly inconsistent with their respective statements prior to June 8th, 2023. The problem with trying these defendants jointly is that while the Commonwealth should not be able to introduce any of Steven Lawson's or Joseph Lawson's statements made after June 8th, 2023 against them, Brooks has a right to probe into the inconsistency of their statements as part of his defense. In fact, to deny him the right to cross-examination about these inconsistencies would effectively obviate his right to confront the witnesses against him in violation of the Confrontation Clause of the Sixth Amendment. In short, statements Steven Lawson and Joseph Lawson made on June 8th, 2023 and thereafter, and Joseph Lawson's 2020 interview with the FBI, cannot be introduced as evidence against them. However, Brooks must be able to probe into the inconsistencies of these statements in order to attack the veracity of statements Steven and Joseph Lawson made prior to June 8th, 2023. The only way this can be effectively accomplished while preserving the constitutional rights of all three defendants is to try Brooks separately from the Lawsons. While separate trials may be inconvenient, the inconvenience does not outweigh each of these defendants' constitutional right to a fair trial, especially when such gravely serious charges are involved. Number 3, redactions would not protect Brooks' Sixth Right Amendments. The Confrontation Clause of the Sixth Amendment, extended against the states by the 14th Amendment, guarantees the right of a criminal defendant to be confronted with the witnesses against him. The right of confrontation includes the right to cross-examine witnesses. As such, the government cannot admit statements made by Steven Lawson or Joseph Lawson against Brooks unless one or both elected to testify. To do so would violate Brooks' Sixth Amendment rights. In Brutton v. United States in 1968, the Supreme Court ruled that a defendant is deprived of his Sixth Amendment right of confrontation when a facially incriminating confession of a non-testifying co-defendant is introduced at their joint trial, even if the jury is instructed to consider the confession only against the co-defendant. Typically, the way around this quandary that arises often in joint trials is to redact the statement of the non-testifying co-defendant to remove any reference to the defendant. Nevertheless, a redaction that is vastly valid may still amount to a Sixth Amendment violation if it can only be reasonably interpreted as inculpating the defendant. Ooh, you can tell I've been reading a lot. Should the court admit any or all of Steven Lawson and Joseph Lawson's post-June 2023 statements, or Joseph Lawson's proper interview with the FBI, those statements cannot be redacted in a manner that adequately protects Brooks' Sixth Amendment rights. Both Joseph Lawson and Steven Lawson have given statements littered with inconsistencies. Because of the distinct roles they are alleged to have played in Miss Rogers' disappearance and the myriad of inconsistencies in their statements, practically speaking, there is simply no way to redact any of their statements without implicating Brooks. We're almost done with this for you guys. As stated in Gray versus Maryland, a jury will often react similarly to an unredacted confession and a confession that is not or cannot be properly redacted. For it will realize that the confession refers specifically to the defendant, even when the state does not blatantly link the defendant to the deleted name, because people aren't dum-dums. It's pretty obvious. Moreover, Steven Lawson and Joseph Lawson's statements cannot properly be redacted to eliminate not only Brooks' name, but any reference to his existence. Oops, excuse me. Oh, hello, Kathy. Hello, and welcome. All right, so in a joint trial, the confrontation clause ban applies even to hearsay statements offered as evidence against the co-defendant declarant himself, if the declarant does not testify, and if the statement either expressly or by immediate implication tends to incriminate another defendant. Now, this case is distinguishable from the cases finding that redaction is sufficient to protect a defendant's Sixth Amendment rights at a joint trial for a number of other reasons. The sheer number of times Steven Lawson and Joseph Lawson gave recorded statements, the length of those interviews, the multitude of inconsistent statements, and the time period over which those interviews occur. By way of example below is a list of interviews, testimony, and statements given by Steven Lawson in this case, not including recorded statements he made to a confidential informant. So here's all the interviews that Steve has given to law enforcement. 9/26/2015, a few months after the disappearance. Went to the Nelson County grand jury. 8/6/2020, FBI interview for 5.5 hours. June 8th, 2023, KSP interview, approximately 6.5 hours. June 14th is Nelson grand jury appearance. Also on the 14th, he does a KSP interview for 3.5 hours. Then June 19th, another KSP interview for 30 minutes. Then in August 22nd, 2023, another KSP interview for 4.5 hours. September 12th, 2023, a KSP interview for over 2.5 hours. And 9/20/23, Nelson County grand jury appearance. That is a lot of interviews. So that's interesting. So Steven Lawson alone has given over 20 hours of statements, interviews, and testimony for the Commonwealth to sanitize of any reference to Brooks. All 20 hours from start to finish are full of inconsistencies, later admitted lies, and responses to leading questions aimed at implicating Brooks in the disappearance of Crystal Rogers. The required redaction of this overwhelming amount of material cannot be accomplished without materially altering the content of the statements in a way that would inevitably prejudice Brooks or Steven Lawson, or both. Any attempt by the Commonwealth to claim that the statements made by Joseph Lawson or Steven Lawson are truthful is laughable. I love when they get snarky and their write-ups, as it will be simultaneously argued that the Lawson statements were not truthful, and as a result, they are not entitled to immunity. I mean, it's a very, very good point. As previously noted, without the statements of Joseph Lawson and Steven Lawson, there is not and was not sufficient evidence to indict Brooks for 8 years. Even if the large number of statements given by Joseph Lawson and Steven Lawson can be properly redacted to remove any reference to Brooks, which is unlikely, there is no way for the Commonwealth to make a case against Brooks without using the testimony and statements of the Lawsons against him. To do so in a joint trial would violate Brooks' Sixth Amendment rights. In Peacher, the co-defendant's statements were properly redacted and not admitted against the defendant. However, both the prosecutor and co-defendant's counsel urged the jury to use co-defendant's redacted statement in evaluating the evidence against the defendant. Preacher argued on appeal that this violated his right to confront adverse witnesses and undermined the rationale of Richardson. The Kentucky Supreme Court noted that Peacher's concern was legitimate, but the error was not properly preserved because Peacher's counsel did not object to this aspect of counsel's argument at trial. It cannot be emphasized enough that it would be impossible for the Commonwealth to tell a coherent story in an opening statement about what it believes happened to Miss Rogers without using Stephen and Joseph Lawson's statements to attempt to tie together circumstantial evidence that the Commonwealth believes may be incriminating against Brooks. Trying these men together will not only violate Brooks' Sixth Amendment rights and unduly prejudice him, it will create a trial circus regarding what evidence is admissible and against whom. In conclusion, simply put, there is no way for the Commonwealth to introduce evidence against all three defendants at a joint trial without violating the Kentucky ruled evidence, violating Brooks' Sixth Amendment rights, or both. And for these reasons, the Commonwealth's motion to consolidate should be denied. Oh, wow. I mean, okay, so what they're saying is listen, the Lawsons, they couldn't get their story straight ever, okay? And Brooks needs to be on trial separate from them, so that way he can call out all of their shenanigans, the police shenanigans, the prosecutor shenanigans about these immunity deals and whatnot. And you know, they're one point of like, hey, these guys messed up their immunity deal. Why should anybody believe anything that they say? Or the prosecution tells us what we should and shouldn't believe when, again, they couldn't even get an immunity deal. Anyway, so now we're back over here to this one. All right, so that was March 15th, by the way, you guys, of 2024. We're still only in month 3. Don't worry, there are down moments in this. So let's see, we did that. So March 21st hearing, Brooks and Steven Lawson walked into the courtroom in shackles while Joseph Lawson appeared over video from jail, because remember, he's in prison. Despite several motions on the table for discussion, the hearing only lasted 20 minutes with no decisions being made. Typical court hearing. Now, special prosecutor, this guy, Shane Young, agreed with defense attorneys that the February 2025 trial should be taken out of Bardstown due to the attention the case has received in the media and the community. The venue should be changed, he said. I've talked to defense counsel. We're all three going to get together and talk, then make a proposal to your honor. If we can make an agreement. If not, we'll let your honor tell us where to be. So prosecution's like, yeah, we're going to need to move this whole thing. We're not going to argue about that. Now, Judge Sims requested attorneys find a courtroom large enough for public viewing and has a separate entrance for jurors. Now, Willie Downs, a friend of Rogers' family, doesn't believe the miles will make much of a difference. Quote, it's nationally known you ain't going to be able to sweep it underneath the floor. There is still a lot of unanswered questions. Oh, Willie, there sure are. Now, attorney Ted Lavit said he's eager to ask the judge to dismiss the charges against his client, Steve Lawson. He claims Lawson talked to police under a shield of immunity. At no time was my man never promised immunity, he said. At all times, he promised immunity. In my presence and outside my presence, before I got involved and after I got involved. There's no question about that. Now, according to Lavit, Lawson told police and prosecutors the truth, but it wasn't the truth they wanted to hear. Quote, he said, "This is the truth. This is all I know. I can't say what you want me to say. I'm telling you all I know." And he did, he said. Lavit also described an inappropriate scene in the interrogation room, accusing investigators of mistreating his client. Quote, they hollered at him, they yelled at him, screamed at him, they spit in his face. I watched it on video. He asked me to come in and stop it. We returned it several other times for meetings and they badgered him, but he cooperated. Oh, so, I mean, these interrogations seem a little coercive, just a little intense. All right, so now we're into April 2024, and Joseph Lawson's attorney, April 19th, my apologies, April 19th, 2024. Joseph Lawson's attorneys filed a motion to sever his case from his father, Steve Lawson, and Brooks Houck. Everybody wants their own separate trials. The main reason Lawson's attorney is pushing for this is because they're worried that the other two defendants may try to point the finger at Joseph Lawson for certain aspects of the crime in out-of-court confessions. Basically, the same arguments Houck made regarding his Sixth Amendment right. They're all being like, hey, we have the right to, cross-examine witnesses and all that. So then, we do have news clip time, which is so great because I know to use the bathroom. So it is, let me get this. So April 21st, okay. As we know, April 21st is, is the 10-year anniversary of Kathy and Samantha Netherland murders. Now, in this 5-minute news clip, the sister of Kathy is going to speak out with some new information, which is interesting. So let's see. Hopefully this doesn't have any music because the music got us in trouble last.
Has been left wondering who
go.
brutally murdered Kathy Netherland and her teen daughter Samantha. The murders adding to the darkness encompassing the city of Bardstown.
The two were killed exactly 1 decade ago, but the case, it's cold. No arrests and no named suspects.
Wave News troubleshooter Natalia Martinez reports on a new piece of information that police had never said they had, and she joins us with what she found out.
This picture right here is the only thing that KSP had released after a couple of years of the murders. But now Kathy's sister says that there's a lot more than just a pic.
Driving by this home in Bardstown, you would never know the heinous mystery it was witness to.
If it were a perfect world, that house wouldn't exist.
One that destroyed a family and forced people to lock their doors.
I'm, wondering if somebody's gonna knock on my door or try to break in or whatever.
I love to sit outside and watch the traffic, but now, you kind of feel afraid.
Urgency seemed at a peak. A teacher, Kathy Netherland, shot to death, and her 16-year-old daughter, Samantha, beaten, stabbed, nearly decapitated. The oldest daughter, Holly, was away at college.
Why? There just is not a good answer. There's nothing seems to make sense.
Kathy's sister, Stacy, met us by the home, now frequented by renters after it was auctioned off for 40 grand. 10 painful years have gone by without a single arrest or even a named suspect. The lead agency, Kentucky State Police, releasing nothing in an entire decade but this picture. A Chevy Impala they said they believed was involved, though they never specified how.
We're looking, as you all know, for a newer model black Chevy Impala that was seen in the vicinity of the Netherlands home.
But now we've learned they knew the Impala was way more connected than being in the vicinity. Hibbard says KSP had also gathered video of the car pulling into the back of the Netherland home, something KSP didn't tell the public.
There is footage of the car where the car drives past Kathy's house, coming from Bardstown going towards Springfield, and then within a minute or two comes back, which would make you think they looped around a Botland loop that's just down the road.
Hibbard says the video was taken from the wine and liquor store across the street. She says once the car disappears behind the home, a dark figure walks across the porch to the front door. A few seconds later, someone appears to let that person in. The video is just one piece of evidence Hibbard hopes can be re-examined with new technology.
Maybe there is an advancement either now or in the future that's going to give them information that they didn't have.
The car then leaves in less than 15 minutes. Hibbard believes Kathy was shot first in the living room. Samantha brutally attacked moments after coming out of her room.
Do you believe that it was random?
It would seem odd that if it were random, why were they killed in such different ways?
So who are the killers and why? The conspiracies soared in a town enveloped by a cloud of 3 other unsolved murders that happened not long after the Netherlands were killed.
We have no reason to believe that Kathy and Samantha, their deaths were related in any way to Officer Ellis, to Crystal Rogers, or to her father, Tommy Ballard.
Hibbard believes Samantha may have been the main target, though she can't imagine why.
For the way that she was attacked, you have to think that in some way it was directed at her. It was particular to her.
She also dispels one other circulating theory, that the killings were part of a gang initiation.
Okay, so if that's true, why have you seen no other crimes committed in a similar fashion?
The rumored list has included those closest to the mother and daughter.
Unless the police have told me with 100% certainty you did not do it, everyone is a suspect.
The teen buried in the prom dress she'd bought just days before she died, now buried next to her mother.
Oh.
She and Kathy both are, big holes in our life where they're not there anymore. We miss them, every day.
KSP declined to release any video, any new information, and they also declined to be interviewed for this story. They said that they're still actively working the case.
Interesting.
Though it's been a decade. They said they provided an update last April, gave me a link to a news article, which had no new information. Natalia Martinez, Wave News.
I love how even the newscaster is just like, I'm calling all my bullshit. Oh, Juju Bean, are you sure that it's live on your phone as well? Because sometimes you can get behind the screen. If you see where it says live, just click that and it'll like fast forward you to real time. Sometimes that happens to me a lot. Anyway, so there was an update about the Netherlands, which was, oh my. So let me go back over here because we'll end up doing this one next. Now, on April 25th, the attorneys for all parties, Lawson and Houck, selected Christian County as a potential location. Now, the county seat there is in Hopkinsville, which is about 150 miles away from Bardstown. So that's still like 2.5 hours, something like that. All right. Now we're on to May 6th. So May 6th, the prosecutors submit Brooks, Houck's, and Nancy Grace video into evidence for all 3 defendants. people need to stop giving interviews. They're suspects or have been charged in the case. It will be used against you in court, no matter what you say. Oh, goodness. And then on May 17th, my apologies, prosecutors file new court documents in response to the defendant's request to try the cases separately in 3 individual trials. Quote, the jury in this case deserves a complete picture of the conspiracy to murder Crystal Rogers and to cover up that murder by tampering with evidence, prosecutor Shane Young wrote. And I think we need to hold prosecutor Shane Young to that quote because it's true. The case does deserve a complete picture, but we'll get to that later. Young's response disputes Houck's claim that prosecutors and detectives showed bias toward him throughout the investigation, claiming they worked with a get Brooks mentality. All of the information gathered has repeatedly led investigators back to Brooks Houck, he wrote. Houck was considered the main suspect in Rogers' disappearance as early as July 8, 2015, when then lead detective on the case, John Snow, told him, quote, currently, you are the most likely suspect. You are her boyfriend, and you were the last person to be with her. He also reiterated that Houck's lack of timeline was a concern. Young also accuses Houck and his legal team of quoting small snippets of over 20 hours of interviews to put the best spin he can on witnesses who disclose information about Houck's involvement in a crime. Quote, yet by doing so, Houck leaves the court with an incomplete picture. In fact, Houck's entire response is premised upon doing just that, leaving jurors with an incomplete picture. And he points this out. So let's read this real quick and what it says. It says, Mr. Young re-entered the room. I'm listening to this. I'm going to call bullshit on this. Why the fuck would you tell that story? You need to cut the bullshit and you need to come fucking clean. I'm giving you blanket immunity. Take advantage of it. That statement is not only inaccurate, but it lacks context. At the same time the statement was made, detectives were asking Steven Lawson about a call Houck made to him from an interview that occurred on July 8th, 2015. Young actually said, this is what the prosecutor actually said, Mr. Young re-entered the room. I'm listening to this. I'm going to call bullshit, okay? I'm going to call bullshit, all right? Here's why I'm calling bullshit. You sat here and you told us that Joey called you and asked you to call Brooks. You're shaking. You know what the problem is. You sat there and Joey asked you to call Brooks and tell him that the job is done, right? So why the fuck would you, when Brooks calls you, you go, I was calling you looking for an apartment. Why the fuck would you tell that story? You need to quit the bullshit and you need to come fucking clean. I'm giving you blanket immunity. Take advantage of it. So that's the apparent context of where defense was pulling that from. Now, Young argues it is incredibly important for the jurors to hear the cases together because the 3 men allegedly worked together to cover up Rogers' disappearance. The Lawsons told investigators all about Houck's desire to get rid of Crystal, that Houck recruited his family for help, that Houck got the Lawsons to move her vehicle the night she disappeared, and that the explanation offered by Steve Lawson for the July 4th, 2015 phone call between him and Houck was a lie, Young said. Now, prosecutors allege that the conversation had a much more sinister message. According to court documents, Steve Lawson told detectives he called Houck early on the morning of July 4th, 2015 to tell Brooks, quote, the job is done. referring to Roger's car being moved. He told detectives his son Joseph had told him to make the call after he picked him up on the side of the Bluegrass Parkway. Quote, Steven Lawson could not explain why, when he was called by Houck on July 8, 2015, while Houck was in an interview with Detective Snow, he made up a story about the July 4th phone call. Another set of court documents filed addresses Steve Lawson's motion for his charges to be dismissed or his statement to be excluded on a claim of immunity. In response to that motion, the prosecutor alleges Steve Lawson was denied immunity because of his inability to tell a consistent narrative of what occurred on July 3rd into July 4th, 2015. Prosecutors allege large periods of time were unaccounted for, and his story about those periods of time consistently changed. It became apparent that Lawson had a larger involvement in Crystal Rogers' murder than he was willing to admit. Okay, so prosecution's like, he's a liar, 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 pants on fire, but we still kind of need him for this case. So we're going to decide what we think is truthful to us. I mean, I'm assuming they would have evidence to back that up, though, right? We'll find out. The documents say, quote, Lawson is very aware that he lied. He admitted this in a phone call he made from jail in December 2023, shortly after he was arrested. And in this call, it says, Steve Lawson, yeah, you was right about a lot of things. Let me tell you, you was. The called party says, what do you mean? Steve Lawson says, well, you know, you said when I lied, I fucked up my deal up. Called party says, I know. When confronted, Lawson finally admitted that he was recruited by Brooks Houck to move Crystal Rogers' car. Lawson further admitted that Brooks Houck was trying to find someone to get rid of Crystal Rogers. Prosecutors say they believe these claims are true because it matched both their evidence, and several witnesses have corroborated the same details that in the days before Crystal Rogers' disappearance, her ex-boyfriend Brooks Houck asked his employee Steven Lawson to kill her, or at least find someone else who would carry out the deed. The prosecutor alleges it is Lawson's responsibility to prove he is telling the truth that would have entitled him to immunity, and that would be done in an evidentiary hearing, and that hearing has not been requested. Oh, we have another news clip. Let me get that up and going. We can get rid of that one. Oh, actually, I don't know this one. I think this channel is the wonky one. Oh, there we go. All right, so here we have, let me just move this over here so they're all on the same. Oh, no, that's not my one. Oops. No, it's coming. There we go. Okay, so May 25th is the 11-year anniversary of Officer Jason Ellis's murder. And I do have a news clip for us to watch. It's only 2 minutes, so it's not very long at all. Let me boost.
11 years after Officer Jason Ellis wrapped up his final shift, pulling out of this parking lot for the very last time, dozens returned here, honoring not just his sacrifice, but his legacy.
Our memory of Jason serves as a constant reminder of the sacrifices made by our brave men and women in law enforcement.
A wreath at the memorial bearing his name, a salute, and tears that fall as easily as they did more than a decade ago. On Friday, officers, loved ones, and community members once again gathered to honor Officer Jason Ellis.
This memorial service is more than a ceremony. It's a vital act of remembrance and respect. It's a time to reflect on the bravery and selflessness that Jason embodied every day.
The murder of Ellis remains one of Bardstown's darkest chapters. He was gunned down at exit 34 of the Bluegrass Parkway when he stopped to remove debris. In an instant, Amy Ellis Brown was a widow, left alone to raise their 2 young sons.
It's hard not to reflect every May on those last days that we had with Jason. I will forever remember it like it was yesterday, seared in my memory until the end of time.
While final days were precious, the years that followed brought heartache.
As I look at our boys, I can painfully see how much time has passed, and it breaks my heart thinking about all the milestones that he has missed. 11 years ago, they were graduating kindergarten.
Oh. Now they're like all grown up.
And this year,
Look at
they
him.
are
That's
finishing
them all
up their
grown up.
junior year and becoming young men themselves. I know Jason would be so proud of them. It's hard to believe so much time has passed without him and without justice.
But those here are confident there will be justice one day.
While it's a grave sorrow that no one has yet been charged with this unthinkable crime, we hold firm in our trust that justice will prevail.
In Bardstown, Lauren Adams, WLKY News.
Oh, the story makes me so sad. Oh, I lost my whole presentation there. Whoops. That many years and no answers, no updates. I don't want there we go. Okay. All right. So, hold on just a second. My little llama is getting ready. Sorry, little llama. Are you just gonna wait outside?
Yeah.
Will you hold on? Give me just a second, guys. Let me give him a hug and a kiss before he leaves. Hey, come here. Okay. Okay. All right. Sorry about that. Had to say bye before he leaves for his dance for a couple of days. All right. So, Officer Jason Ellis's memorial service. So now we're in June. Okay, June 3rd. I think this is the last document. And it's a long one. Okay. But June 3rd, Houck's attorneys submit a SIR reply in opposition to Commonwealth's motion to consolidate. Ooh, and it's juicy, guys. It is. All right, so let's pop over here and read this one. It's a long one. Actually, I'm just going to open my Red Bull because I'm going to need it. Let's see what tea we get from this one. Oh, ooh. He's not prepared for that after drinking coffee all morning. You know, Juju being, I hope justice will prevail for Jason Ellis and the Netherlands as well. Gosh, well, I don't know. I don't know. I'm just so skeptical right now about all that. Lady in Gray asks, why do they think his death is related to Crystal and her dad? I believe that it's kind of speculation, I think, at this point. So, well, also not. So in Brooks, so it was speculated for a long time that everyone believed Jason Ellis and Tommy Ballard's deaths were related because of the similarity of the two of them. Both of them kind of were assassinated pretty much, you know, shot in a distance off a highway. It was set up and premeditated ahead of time. You know, Jason Ellis had the branches that were on the road that he was picking up. And then in Tommy Ballard's situation, the branches were cut off some trees that led people to think that they did that on purpose so they would have a clearer shot. So that was a speculation. But then in Brooks' arraignment that we saw in October of 2023, the prosecution said in that hearing that they are in possession of the gun they believe killed Tommy Ballard, and an undercover officer had bought it from Nick Houck, who was using a fake name when he sold it to him. All right. And that this gun has apparently been tested by everybody numerous times, as we saw in that one footnote. I'm not so sure about this gun, you guys, but Anyway, it had met 4 out of the 5 criteria of being the gun that killed Tommy Ballard. So, and then you were like, the speculation before was, was it a cop that killed Officer Ellis? Because it had to be somebody who knew his schedule. And guess who he usually worked with on the night shift? Nick Houck. So that's where people are making the connections. And that's really all we know that's ever come out about it thus far. So, all right. So let's get into the defendant Brooks Houck's SIR reply in opposition to Commonwealth's motion to consolidate. They're like, no, we want a separate trial, please. And thank you now. All right. So the defendant Brooks Houck, Brooks by counsel, and in SIR reply to the Commonwealth's motion to consolidate this matter with pending criminal cases involving Steven Lawson and Joseph Lawson, states as follows. Under the government's ideal scenario, Brooks, Steve, and Joey, I'm just going to do Steve and Joey and forget the Lawson part, would be tried jointly, and the jury would hear redacted versions of Steve's 2023 grand jury testimony and jail calls to his mother and now ex-wife, during which he regurgitates the same story he concocted at the behest of law enforcement in hopes of obtaining the immunity he was once promised if he told the truth. Neither of the Lawsons would testify, and Brooks would have no ability to cross-examine either of them. Everyone in the courtroom would know that their redacted statements are incriminating Brooks. Critically, as the government candidly admitted in its brief, no matter what type of cautionary instruction is offered by the court, given that the Lawsons are directly discussing the facts of the case, it will be impossible for jurors to follow such an admonition. Hold on, let's read this little footnote here. The footnote says, some of the most important details in the confession Steve gave law enforcement differ significantly from those relayed to his mother during his jail calls, further demonstrating that he has fabricated the entire story of his involvement. For example, in an interview on September 12th, 2023, Steve said he dropped off Joey at Bluegrass Feed and Seed to pick up Crystal Rogers' car. During a jail call with his mother, he said they picked up her car in the Woodlawn subdivision. So they're just like, doesn't seem to be matching up. In a joint trial, the reality is that the two primary witnesses against Brooks would be Steve Lawson, through his prior grand jury testimony and jail calls, and Joey, potentially through his prior statements. None of these statements would technically be admissible against Brooks because, assuming neither Steve nor Joey testify, he would not have the opportunity to cross-examine either of them in violation of his Sixth Amendment rights. However, jurors would hear the statements, and even if they are properly redacted, certainly use them against Brooks. As the government knows and stated, it would be impossible for a jury to follow any cautionary instruction. Simply put, Brooks cannot possibly receive a fair trial if tried jointly with the Lawsons. To compound the injustice of a joint trial, the government seeks to prohibit Brooks from even defending himself at a joint trial. The government wants the jury to hear the sanitized final version of Steve's story without any context as to how the version came about, which was through countless hours of interviews during which Steve was subjected to threats, promised leniency, and fed information by investigators. Let's go to the footnote real quick, shall we? The footnote says, the government also wants to introduce recorded jail calls with Steve's mother and ex-wife after his arrest, which began with the disclaimer that the calls are being recorded and subject to monitoring. Steve knows that the government is monitoring those calls, and it is in his best interest to regurgitate the same story he told investigators in the hopes of convincing the prosecutor he is telling the truth and has earned the immunity he was repeatedly offered. So he's just saying this, so it stays the same, and he's trying to get out of jail. Okay. In sum, the government wants to use KRE 410, which is supposed to be a shield for the Lawsons, as a sword to keep Brooks from exposing how Steve and potentially Joey's statements developed, while being permitted to introduce the fruits of law enforcement's coercion. Trying Brooks alongside Steve and Joey without Brooks being permitted to demonstrate how their statements were developed denies Brooks the ability to mount a defense and violates his rights under the Confrontation Clause of the Sixth Amendment. It is hard to envision a more grossly unfair scenario, and one that would almost certainly lead to a reversal of any conviction. A. Redaction under these circumstances cannot protect Brooks' Sixth Amendment rights. I know a little bit of this is repetitive, guys, from the one we just read, but there is also lots of other things in here besides that. So don't worry, it is not verbatim the same of what we just read, I don't think. All right, so Steve and Joey's statements are not admissible against Brooks, as the admission of those statements would violate Brooks' Sixth Amendment right to confront the witnesses against him. Absent a joint trial, jurors in Brooks' trial would never hear the Lawson statements unless one or both of them resolved their cases with the government and agreed to testify against Brooks as a condition of a plea agreement. Under that scenario, Brooks would be able to cross-examine the witnesses against him. In a joint trial, the jury would hear the Lawson statements, but Brooks would be denied any opportunity to cross-examine them, or, under the government's proposed scenario, even introduce the fruits of law enforcement's coerced statements and use KRE 410 as a shield to prevent Brooks from exposing how these statements, which so obviously incriminate Brooks, developed. Oh, it's on my eye. Oh, I'm fine. Redactions of Steve and Joey Lawson's statements cannot possibly protect Brooks' Sixth Amendment rights. As the government correctly noted in its reply, no matter what type of cautionary instruction is offered by the court, given that the Lawsons are directly discussing the facts of the case, it will be impossible for jurors to follow such an admonition. So the prosecution said too, redacting is not going to work. Okay, it's not going to be helpful at all if we do that. It is simply fanciful to believe a jury could hear the Lawson statements discussing their account of their activities and movements on July 3rd and July 4th, 2015, which clearly and unequivocally incriminate Brooks, and be able to follow an admonition to use those statements only against the Lawsons. The government intends to use the Lawson statements to tie together its case against Brooks, and, redacted or not, such statements incriminate Brooks in direct contravention of the Sixth Amendment of the United States Constitution. So, oh, thank you, Juju Bean, a retired teacher. Oh, thank you so much. I love that. By way of one of many examples, the Commonwealth will introduce evidence that Stephen called Brooks at 12:07 a.m. on July 4th, 2015. Ooh, stuff about the phone call. Brooks gave a voluntary interview to Detective John Snow of the Nelson County Sheriff's Office on July 8th, 2015. And it was a weird phone call. We all watched it and heard it. It was weird. During that interview, Brooks denied remembering who called him at 12:07 a.m. on July 4th. Brooks called the number in Detective Snow's presence to assist the investigation. And Steve advised Brooks and Detective Snow that he called Brooks regarding a rental property. Steve's story about the purpose of this 12:07 a.m. phone call evolved and changed over time as law enforcement coercion and suggestion intensified. Also, in that phone call, he forgets Crystal's name. He's just like, oh, Katie? Oh, no, that's not her name. Like, it was weird, but okay. Maybe it was a butt dial. Right? Now, I don't know. Things are weird in Kentucky, too, is all I'm saying. So it's Commonwealth states. I don't know what's going on with the Commonwealth states, but oh boy. All right. So Steve's story about the purpose of this 12:07 a.m. phone call evolved and changed over time as law enforcement coercion and suggestion intensified. Although Steve's explanation of the phone call, oh, I just lost my place. It's my eye. Oh, there we are. Remained consistent throughout 2 interviews with Detective Snow, an interview with the FBI, and a grand jury appearance in 2015. His story suddenly changed after 8 years once he was subjected to at least 8 hours of coercive interrogation tactics, indicted for tampering with physical evidence, taken into custody, and promised that the prosecutor had a judge standing by to let him go if he cooperated. As a result, when he testified before the Nelson County grand jury on June 14th, 2023, Steve Lawson's new explanation for his 12:07 a.m. phone call to Brooks was that he called to tell Brooks that the job of moving Crystal Rogers' car was done. So, that same story about the apartment thing up until the previous year, which is okay. Stay out of the Commonwealth. It's wild. Oh, I cannot wait till we get to these trials, you guys. Oh my gosh. Freaking wild. Juju being right. Keep Kentucky weird. Ain't sure about that expression. A lot of people say it. Girl, I'm from Ohio. Okay, we're weird too. All right? It's fine. We're all weird. All right. The government's position is that it can play Brooks' interview with Detective Snow, including the portion concerning Brooks' call to Steve to ask about the purpose of the 12:07 a.m. phone call on July 4th, and introduce Steve's most recent Nelson County grand jury testimony, where he testified that the purpose of this 12:07 a.m. call to Brooks was to tell him the job of moving Ms. Rogers' car was done. The government proposes that it will protect Brooks' Sixth Amendment right to confront the witnesses against him by simply substituting Brooks' name for another person. That's not helpful. We've already talked about this. It's not helpful to do that at all. People are not stupid. They can figure it out based on context clues. My goodness. Anyway. All right, we're down here. Of course, it will be abundantly clear to everyone that another person is Brooks. After all, it was the Commonwealth that acknowledged, quote, no matter what type of cautionary instruction is offered by the court, given that the Lawsons are directly discussing the facts of the case, it will be impossible for jurors to follow such an admonition. Look at them being like, I brought the receipts, Mr. Young. Okay, I brought the receipts, and you said it was impossible, and now you're saying, oh, no, we can do it. It'll totally be fine. Okay. Oh, hello, Haley Wood. How are you? Hope you're doing great. We're doing great. We're reading a lot today. So happy to see you. We've been deep diving Crystal Rogers' case, and it's wild. All right. So where was I here? Okay. This case is one in which redaction would be wholly insufficient to protect a co-defendant's Sixth Amendment rights. Similar circumstances existed in the United States versus Taylor, circum to 2014, in which 4 individuals rode together in a car to rob a pharmacy. Taylor, Vasquez, Rosario, and Miller. All but Miller were later charged, and Taylor confessed. The Second Circuit found the following redactions to Taylor's confession to be inadequate because the redactions suggested that Taylor's original statements contained actual names, which, paired with context clues, made it obvious that the redactions referred to Vasquez and Rosario. This is from this case, not the one we're talking about. Luna Miller and 2 other individuals. The person waiting with Luna Miller and Taylor. The robbery was the idea of the person who waited with Luna Miller and Taylor, Luna Miller and 2 other individuals. Yeah, it's not very sly. All right. In addressing the inadequacy of the redactions, the court held that it had explicitly left open the possibility of a neutral word substitution being so conspicuously awkward that the alteration becomes obvious, and that this case involved obvious redactions that made it likely that the jury inferred the reactions referred to Vasquez and Rosario. The court further explained, once it becomes obvious that the names had been pruned from the text, the choice of implied identity is narrow. The unnamed persons correspond by the number to and by role to the pair of co-defendants. This obvious redaction confession points directly to the defendants, and it accused the defendants in a manner similar to a testifying co-defendant's accusatory finger. I mean, come on. We've all played the what's in the redacted game. Sometimes I think that can be way more dangerous than anything. So the same is true here. Given the context clues, the alleged role of Brooks compared with the alleged roles of his 2 proposed co-defendants and the number of individuals allegedly involved compared with the number of defendants in a joint trial, introduction of redacted statements of Steve Lawson in a joint trial would be no different than Steve testifying at trial and accusing Brooks of murder. They're saying it's the same thing. Might as well be on the stand. It's crazy. Because Steve almost certainly will not testify in his own defense. Oh boy. However, Brooks loses the opportunity to cross-examine him and expose the lies he was coerced into telling law enforcement. Curiously, the government cites Bratcher versus Commonwealth, 2004, to illustrate how a joint trial of these 3 defendants should play out. Bratcher, a case prosecuted by the undersigned counsel over 20 years ago. Oh, that's interesting. He was like, I prosecuted this case. Okay. Has almost nothing in common with the facts of this case. Although Bratcher and his co-defendant and brother Philip were tried jointly, Philip had reached a pretrial agreement with the Commonwealth whereby he waived his Fifth Amendment rights in exchange for significant concessions and agreed he was available to be called as a witness. Philip did testify at trial, and Bratcher did have the opportunity to cross-examine him about his motivations to testify. As the government points out, the Confrontation Clause guarantees an opportunity for effective cross-examination. Unlike in Bratcher, Brooks will not have the opportunity for effective cross-examination. The government knows that under the facts of this case, that it would be impossible, again, using their word, for jurors to follow the court's admonition that they cannot use Steve and Joey's statements directly discussing the facts of the case against Brooks. The government also knows that the chances that either Steve or Joey testifying are remote, So the government will be able to use the Lawson statements to incriminate Brooks without Brooks having the ability to cross-examine either co-defendant. In a joint trial, Brooks' Sixth Amendment right to confront the witnesses against him will be forfeited, and his chances of conviction will unfairly and unconstitutionally skyrocket, notwithstanding the reality that any such conviction will likely be subsequently overturned. Now, you guys might be like, Llama, why are we reading all this stuff? I promise it's going to be relevant later, I feel anyway. Then I think it's going to be relevant. All right, so B, the exclusion of statements made pursuant to KRE 410 supports Severance, not the show. You're like, oh, sorry. Oh, could you imagine Severance and then like your innie is the one going through all this? That'd be wild. Anyway, off topic. I love the show Severance. If you haven't seen Severance, please go watch it because it's amazing. All right. The government's tortured arguments in support of joinder are unpersuasive and illustrate precisely why it is critical that these three defendants remain severed. First, the government agrees statements by both Steve and Joey to law enforcement beginning in June of 2023 are inadmissible pursuant to KRE 410 because they were made in the course of plea negotiations. Oh, we got a footnote. Footnote 10. The government accuses Brooks of cherry-picking portions of these interviews that are most favorable to him and leaving the court with an incomplete picture. That is simply not the case, given the defense counsel tendered the entirety of the relevant interviews to the court before the status conference on March 21st, 2024. Similarly, the portions cited in Brooks' response were included for the sole purposes of showing instances when law enforcement made promises and offers of leniency to the Lawsons. Oh, timestamps were included for reference. Okay, interesting. All right. The government argues that Steve's grand jury testimony, however, was not made in the course of plea negotiations, despite admitting in response to Steve's motion to dismiss that the testimony was provided while Steve was seeking to negotiate a deal. So they're like, by the way, you literally just said this in another thing, and now you're saying, no way. It's not like that. Gaslighting is what's going on here. So the Commonwealth seeks to try the three defendants together and allow the jury to hear redacted versions of Steve and Joey's statements predating June of 2023, 2, Steve's 2023 grand jury testimony, and 3, Steve's recorded calls to his mother and now ex-wife in 2024. The government argues at various points throughout its brief that because the Lawsons did not accept the immunity deal, i.e., were unable to concoct a story that satisfied the government's version of the truth, throwing some shade, that the statements that would be inadmissible pursuant to KRE 410 in a joint trial are irrelevant, and that Brooks could not even use the promises law enforcement made repeatedly throughout the interviews to impeach the Lawsons if one or both opted to testify. That argument has no basis and is entirely illogical. Simply because the Lawsons have not accepted the deal does not mean that at the time of the interviews at issue, they were not trying to concoct a story to curry favor with the government. Of course, the government does not want a jury to see the tactics law enforcement employed during their interviews of the Lawsons that ultimately resulted in false confessions. But Brooks must be able to expose those tactics if he is tried jointly with the Lawsons. So, they're like, yes. Why would, Mom, if you're listening, why did you just message me on Discord? Ask if I'm streaming instead of just checking the channel and seeing if I'm here. Oh my goodness. Anyway, ironically, the government accuses Brooks of wanting to leave jurors with an incomplete picture, despite seeking to introduce only the sanitized statements Stephen made, which were nothing more than a byproduct of countless hours of coercive interrogation tactics. In fact, introducing the final versions of Stephen's story without showing the jury all of the efforts law enforcement went through to extract it leaves jurors with an incomplete picture. So I like how they were like, you're saying we're the incomplete? Well, what about you guys? The following two examples demonstrate why it is so important that Brooks be able to show the jury the evolution of alleged bad facts extracted from Steven Lawson. Ooh, some examples. I love those. All right. 1. Steve Lawson's claim that he called Brooks at 12:07 a.m. on July 4th, 2015, to tell him, quote, the job is done. All right, let's see. If the government gets its way, the jury will hear that in 2023, Steve finally admitted that the purpose of his 12:07 a.m. phone call to another person, they're so snarky in this. I do love it. On July 4th, 2015, was to tell him the job was done. Of course, the government will play Brooks' July 8th, 2015 police interview where he calls Steve regarding the 12:07 phone call, and the government will introduce the phone records showing Steve called Brooks at 12:07 a.m. The government will also seek to introduce expert testimony that Steve left Bardstown after this phone call and traveled east in the direction of where Crystal Rogers' car was found, on July 5th, 2015. Oh, that's interesting. Obviously, when viewed in context with the phone records and Brooks' police interview, it is impossible that a cautionary instruction would prevent a jury from using Steve's statement to incriminate Brooks. So here they're saying that the phone call happened. He said the job is done. And then Steve heads out to the area where the car was found. Okay, that's interesting. All right. What the jury will not be able to see in a joint trial are the countless hours law enforcement spent strongly suggesting to Steve what the phone call was supposedly about, where it took place, and why he made the phone call in the first place. Jurors will not see the investigators get so confused by their own fabrications that even they forget what they are supposed to be telling Steve about his location at the time of the phone call. Oh, wow. Jurors will not hear investigators suggesting that they take a smoke break so Steve can jog his memory. They will not hear the evolving explanation Steve gave of the 12:07 a.m. phone call over the course of many hours of interrogation. Steve started with his original explanation for the call, that he had been calling Brooks to inquire about an apartment for his stepdaughter, which I agree, that's weird. Why are you calling somebody at midnight? It's weird. Jurors will hear that. What they will not hear are the wide variety of explanations made before investigators were satisfied. Jurors will not know that Steve also said the purpose of the call was to let Brooks know he fixed the lots he had messed up while working with the skid steer, or to tell him he had picked up Joey, or to tell him the car had broken down. Under the government's ideal scenario, the jury will only hear that Steve finally admitted that the purpose of his 12:07 phone call to another person on July 4th, 2015 was to tell him the job was done. Okay. The below portions of Steve Lawson's 2023 law enforcement interviews, which are admissible in a joint trial because of KRE 410, show how Steve's account developed. These statements, which are critical to Brooks' ability to mount a defense, would remain hidden from the jury. Ooh, okay, so we got what we got over here comment-wise. Let's see. Oh, hi, sweetie. Hello. Oh, I love that. Hello. Hope you're doing well. I think I might have missed you coming in. Oh, thank you. Look, Jojo says, good job, Llama. We all overlooked Lawson calling Brooks during the interview early on. A lot of people did, but it's interesting. All right. So June 8th, 2023. Oh, you guys. I just realized I have not been sharing this document with you the whole time so you could read along. Have I not had this on screen? Oh, my apologies. You just seen my face. I like it when you guys can read along. That way, I know I follow better when I hear somebody talk and can read along as well. So that's okay. We're all besties here. It's fine. All right. So June 8th, you like to be read to, though, Kelly? Well, then you pick the great day to watch the show because there's a lot of reading. Now, June 8th, 2023, Detective BL says, immediately after that, you called Brooks Houck. Steve says, okay, and I told everybody. That was to tell him I got the job done. Oh, you got a footnote. When he interrupts the first interview of Steve Lawson on June 8th, that's where we're on, 2023, the prosecutor is adamant that the call in question takes place before Steve Lawson leaves Bardstown and heads east on the Bluegrass Parkway. And later in that same interview, one of the detectives questioning Steve accidentally asked him if the call occurred while he was on the Bluegrass Parkway or once he got home. Interesting. All right. So Steve says, okay. And I told everybody that was to tell him I got the job done. Well, that doesn't sound great. You see it like that, no matter what you're talking about. Not going to be great with this context, but okay. Detective BL. Hey, Steve. I'm talking about whatever you call it, the skid stuff. BL says, I'm telling you right now, you may have something else going on here. That wasn't the conversation you had with Brooks. How? Steve says, what do you mean? That wasn't the conversation? BL says, that's not the conversation. Did Joey ask you to call Brooks Houck and tell him something? Steve says, wait a minute, hold on now. Let me think. BL says, we are going to give your son the same thing we're giving you. The same thing, referencing immunity. BL says, Joey is out on the parkway by her car, where her car is. Steve says, well, somewhere in that vicinity. BL, right there. Okay, I mean, it's right there, okay? He's out there. He calls you. You call him back. He calls you. You call the man who was last with her right then. Do you see? Okay, but this is the problem. Listen. We have you, brother. I got you. I'm not going to throw you under the bus. I've got you. This is common, okay? Put yourself in this is common sense. What this phone call is. We need the specifics and the truth, okay? I mean, we have to have it. This is part of it, all right? This is part of immunity, what you want. This is part of it. I want you to have a good life. I don't want to burn you, and I don't want to expose you. SL says, honestly, I don't know if Joey did or not told me to call him. I don't know. Steve says, Brooks, told me to call the next day. Crystal, did he not tell me this? BL says, here we sit. So what? You have to be totally honest about what that conversation was. So look, I don't know if it was Joey had run into a problem here, what it is that Joey had asked you to tell him, or whatever it is that you're in the middle of. Steve says, I'm telling you, and I think you think I'm crazy, but I know this was some of the conversation. BL. The conversation was 13 seconds, just to keep you on track here. Steve, that I needed to rent an apartment or whatever the hell. BL. No, this has already been debunked. That didn't happen. Steve, what do you mean that didn't happen? Ooh, new other detective comes in. TH. Not that conversation. Then unintelligible crosstalk, because apparently they do that a lot. TH. The thing is, we're in the fourth quarter now. Fourth quarter right now. Okay, we're close. But without this information, I'm telling you, it can't happen. BL. Luckett hitting Steve's arm as he says, please, 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 please. Steve says, can you just give me a second? I appreciate your patience here. I'll call it. I'm trying to think here exactly everything that I have said. Steve says, what time was that again? Can you give me that? That the thing took place. TH. It was right after Joey called you for a ride. Okay. TH. Right after, Steve. Then I called Brooks right after that. TH. Yes. Steve. I did? Joey didn't? TH. You did. Steve. I did. TH. And I know you're wrapped up in this and don't want to be. I get that. But you're going to have to come off this conversation. You still have your deal, Steve. Steve. Sir, I know that. I trust you. You got to understand that I trust you. TH. Okay. You've got to understand that it's hinged upon this piece of information. Steve. Y'all have got to let me think for a minute, sir, of exactly what was said and why what wasn't said, if y'all can do that. Then they cross talk about coffee. BL says, I know you're in a hard place, man. Steve. Not really, sir. Not really in no hard place, sir. You think I'm in a hard place? But I'm not. Because I'm going to tell you right now, and I know I'm going to get in trouble again when I say what I'm about to say, but I did give you my word. My son put me in this effing mess, evidently, because now 2 and 2 means 4 to me for what happened at my house. That somebody came to my house and said, I got money for fixing up that damn house out there when it got drawn out of her 401k. Now, shit, 2 and 2 is 4 to me. Oh, that's interesting. Ooh, sorry. I'll make us tired. Okay, Steve says, I'm trying to. Damn it to hell. I'm not sure if that's what was said or not, but I'm going to tell you what I recall. Is that fair enough? TH, we'll start there. Steve, I either says I got him or the job is done. Now, it don't take long to say that, sir. BL, what did you mean by that? Steve, well, I'm pretty sure Joseph had called. Now, don't quote me on that. Like I said, it's been a long time. BL, well, we need to be very specific about that. This has played out in your mind a million times. As a no, actually, it hasn't. BL, because you've been asked this before, you know what I'm saying. And you've had to come up with a reason. So this has been played out. Steve, I'm thinking that was exactly the way it was said. BL, what did that mean to you? Steve, well, I don't know. When my son asked me to something, most of the time I done it. I don't know what y'all do with y'all's kids. BL, so Joey asked you to call Brooks and say what? The job is done? Steve, I'm pretty sure, or I got it, or whatever. BL, the gist of it is, Steve, the gist, TH, can we think? I mean, specifics is important. Steve, I understand that. TH, to your knowledge, what did you say in that 13-second conversation? This is important, not the gist of it. So what did you say to Brooks? Steve, that he said that he's got it. I'm pretty sure that's what I said. When I said he, I was talking about Joey. TH. Joey has got what? That's what, Steve, that's what I was told to say to the best of my memory, that he's got this. I didn't ask, what did you got? What did you have? Because this is hearsay. So I don't know whether to say it or not. I heard Brooks was dealing dope at one time. Whether he was or not ain't none of my damn business. So how do I know my son wasn't running dope for the mother effer? Oh, that's interesting. TH. Shane was in here and he told you, I think his words were balls ass truth. Right? Balls ass truth. Steve, something like that. TH, that's not a term I usually say, but he's a man of his word and I trust him with my life. What I'm trying to tell you with the situation you're in today, Steve, I understand what you're trying to tell me. TH, where I think we're struggling now, this is just a small piece, but we just need to clean it up. Just listen. That conversation, Joey calls you, you don't answer. You call him, he doesn't answer. He calls you back and you guys have a conversation. Okay. All right. Joey, then what you're saying is Joey asked you, to the best of your memory, that Joey asked you to call Brooks Houck. Is that correct? Steve, well, he said Houck or Brooks or whatever. TH, and you know Brooks, right? Steve, well, I don't know him like that, but I know him, yes. TH, so you pick up the phone, you have your phone, and you call Brooks. When Brooks answers the phone, to your best memory, what were the exact words that Joey asked you to say? Steve, I'm telling you, I think that was it, that I've got the job done. TH, okay, so the exact words are, he's got the job done. And then at that point, what do you remember Brooks saying? Steve, I don't. BL, you get a phone call from Joey. You miss the phone call. Looks like you call him back. What does Joey say? Steve, come and get him. I told you that. BL, what else? Steve, told me where he was at. BL, at any other phone call or any other point, does he say something else to call someone else? Steve, not at that point in time, no. BL, when does he say to call? Because around that time, there's a call from you to Brooks. Steve, that's after I get down there, referring to the Bluegrass Parkway. BL, no. Steve, what do you mean no? Had to be, sir. BL, no. Steve, it had to be. BL, no. Steve, well, see, now I'm confused because prosecutor Young burst into the room. That's bullshit. Sorry, I'm going to have to get a little bit dramatic over here. Steve, no, sir. I'm trying to tell you. Prosecutor, I've got the fucking phone records, okay? I've got your phone moving, okay? Steve, that's fine, sir. Prosecutor, you weren't down there when you called Brooks, okay? Steve, well, where was I then? Because I'm not trying to be a smartass. Prosecutor, no, man, I can't. I can't give you answers. Here's what, listen to me. I can tell you timing, okay? I can tell you that Joey called you. There was a missed call. Then you ended up talking to Joey. You immediately called Brooks. Then at that point, you begin to move. Steve, okay. Prosecutor, and you go down the Bluegrass. Steve, well, maybe that was the first phone call, sir. I'm not for sure. Prosecutor, that's why I'm helping you, okay? Steve, thank you. Prosecutor, but you have, man, this is a significant event, okay? You have played this through your mind thousands of times. So at this point, you've already called Brooks, right? Before you left the house, you called Brooks. Steve, I guess. Young, Steve, Be honest. Steve, I'm trying to be honest, sir. I'm trying to think of the events. Prosecutor, why did you call Brooks? Steve, to tell him I was going to pick up Joey, I guess. Prosecutor, no, not I guess. Why did you call Brooks? Steve, that's why. Okay, does that? Prosecutor, okay, so why would you call Brooks? BL, to tell him you were going to pick up Joey? Prosecutor, to tell him you were going to pick up Joey? Why would you call Brooks to tell him? BL, be honest, man. Prosecutor, just be honest, man. I have watched so many interrogations. I can imagine exactly what they're doing. Just be honest. I bet at this point he put his hand on his knee. Just be honest, man. Steve, I'm sitting here trying to tell you, sir. Prosecutor, okay. Steve, thank you. Like you said, why did I call Brooks? I called Brooks because I knew. Now, don't look at me like that, shaking your head. Prosecutor, okay, say it. Steve, they was trying to involve me in this mess. Of course, you already know that. Prosecutor, I do know that. Steve, okay. Prosecutor, but we need you to tell us how they were involving you in this mess. That's what's important. Steve, okay. That's like the car deal. All right. I knew my son was pretty much going to take the fucking car, but I thought he was going to steal it. And that's a fact. So, I call Brooks, the job is done. Well, that didn't make a whole lot of sense to me. Oh, all right. So, June 14th, 2023. Another interview. See, guys, another reason why court docs are great, because I don't even know if this was brought up in trial. And if so, we wouldn't have been able to see it anyway. But I love when they release little tea stuff for us. All right. So, June 14th, 2023, KSP interview. In reference to what occurred after he supposedly picked up Joey Lawson from Crystal Rogers' car on the side of the Bluegrass Parkway. So this is after he picks him up. Steve, I'm not for sure if I called Brooks right after that or not. I'm not totally sure. The job is done, or what the hell else ever. I'm not for sure. I'm just being honest with you. By that time, I was a nervous motherfucking wreck. How's that? Does that make any sense to y'all? Steve, tell Brooks it's done. I done just that. Maybe he had to tell Brooks it's done to make it so, or what the hell ever. That one I truly ain't got no answer for, and I'm sorry. TH, let's talk about the phone call real quick. Okay, Steve says. TH, you call Brooks. Steve, okay. TH, what are the exact words you tell Brooks on the phone call? Steve, it is what I just told you. The job is done. TH, okay. And what is Brooks' response? Steve, I'm thinking it was okay. TH, nothing other than Steve. No, not fuck you. None of the crapola. But I mean, I don't know if that's helpful to you or not. I don't know. Okay. August 22nd, 2023, KSP interview. What is this? His third one? And what's here? BL. You just need to think and come clean. Do you need a smoke break? Steve, we can smoke if you want to. That's fine. Yeah. BL, because you really need to think here. I want you to jog your memory and think, like I said, total honesty. Unrecorded smoke break, which goes from an hour and 5 minutes to them coming back an hour and 47 minutes. That is like 3 or 4 cigarettes. BL. So then some point around there, you call Brooks. Steve, I call Brooks. Maybe I did. I just don't. Maybe I told him I got the car moved. It's done. I'm not going to say I did or didn't because I don't remember calling him. But if I did call him, I can tell you that's exactly what I would have told him. I know at one time I called him, and I told you that I called him. Detective BL, What did you tell him, Steve? That's when I called him at the police station, BL, to talk about the conversation that evening. Steve, I told him I was like, need an apartment. And he was like, wait a minute, or whatever he said. I don't know exactly how he said it. BL, and that conversation was staged. Steve, and we all know that. I done that or admitted to that or whatever you want to call it. Oh, so he's saying, yeah, that was staged. BL, okay, all right. So at some point you called Brooks on your way to say what? Steve, I don't remember if I told him the job is done or the vehicles broke down. I don't know, but that's going to be my guess on either one of them. Steve, what transpired? Does that work? BL, when do you call Brooks that evening? Steve, I don't know. BL, was it shortly after? Was it on the way on the parkway or right when y'all got home? It's within the time frame. Steve, well, I mean, I don't know. It could have been going up the parkway. It could have been as soon as I was getting off the parkway. I mean, I can't say exactly when I picked up the phone to call somebody. I'm sorry. So they go for another hour-long smoke break. They come back. BL, it should be noted that outside that we weren't really talking about specifics. We were talking about not admitting stuff. Oh, interesting to bring this back up now that you're on the record again, but okay. Steve, I'm not for sure exactly when the phone call took place. I'm not going to say on the BG, off the BG. I'm not going to say because I'd be lying either direction. Job done. Well, however you want to phrase it. BL, you call who? Steve, that's Brooks. BL, was it your idea to call or who? Steve, I think Joey asked me, but I mean, regardless, either way, he got a call. Whether it was me or Joey or whoever that said that we got the damn car. Okay. All right. So then September 12th. All right. So Detective BL to Detective TH. You want to continue on or take a smoke break? TH to CL. You want to smoke? Steve, that's fine with me, sir. So they go on another hour-long smoke break. Okay. To come back. BL, out there, we were kind of talking about the phone conversation. Oh, were you? That's a horrible time to be talking about that, but okay. Just in a chronological order is how we like to do things. Okay, that's interesting. BL, about shortly after midnight, you make a phone call to Brooks, Steve, to say the job was done. BL, okay. Steve, I got an okay or whatever, I'm not for sure exactly. That was pretty much the end of that conversation, Oh, all right, that's done with that role playing. Oh my goodness. Oh, did the XP thing start? Oh, I love that. I don't really know what it all means, but I'm glad it's happened. Yeah, hello, Angela Halo. Hello, hope you're doing well. It's a read-along day. All right, let's get back to this motion here. So obviously, Steve's statement that he called Brooks at 12:07 a.m. to tell him the job is done is extremely important evidence for the government as evidenced by the investigator's conduct. It contradicts Brooks' interview with police, where Detective Snow was told that the purpose of the call was about rental property. Brooks' inability to expose the tactics and promise of immunity that caused Steve to change his story would unquestionably deny Brooks' due process. I mean, how do you guys feel about that little exchange there? It does sound like he doesn't really know shit at all. There sure was a lot of guessing in there, and I don't think that's how strong of a witness he is to base most of your investigation off of. I'm more likely to take a smoke break, Llama, than wear a tiara crown. I mean, I'll be right there with you, girl. All right. So 2. Steve Lawson's claim that Brooks solicited him for the murder of Crystal Rogers. Okay. So, in a joint trial, as the government proposes, the jury will hear that after years of denying any involvement, Steve came clean to law enforcement and told them that in the days leading up to the disappearance of Rogers, another person solicited him to carry out her murder. Jurors will hear that on September 20th, 2023, Steve appeared before the Nelson County grand jury and testified that another person told him that he wanted his wife gone. I love that they keep putting this in quotes. Jurors will hear Steve's testimony that he responded by telling another person that he's looking at the wrong person. They will hear him say that another person then asked him to point him in the direction of someone who could kill Crystal Rogers. It's proving the point that it is very silly to switch out Brooks for another person. What jurors will not be able to hear, of course, are Steve's initial repeated denials to detectives during his initial interview, or the hours of suggestion, coercion, and convincing that led to Steve's Nelson County grand jury testimony, which was the final product. Jurors will never know that miraculously, Steve gave the clearest account of the alleged solicitation after taking an unrecorded 64-minute smoke break with the 2 detectives who were actively interrogating him, who also said in that thing that, they were talking about chronological things outside what they were smoking. Oh, we got a footnote here. It says, Steve testified that this conversation happened in Valley View or Pleasant View or something like that. Later in his testimony, the prosecutor clarifies and it becomes evident that Steve was referring to Glenview, meaning Glenview Drive, the street on which Brooks lives. In his interview with investigators, Steve said the conversation took place in the Woodlawn subdivision. The government would seek to hide this inconsistency from jurors by using KRE 410 as a shield. And you guys remember, Woodlawn was a very, very multi-day search that they did, I think, in 2023 or 22. Yeah, either way, it wasn't that long ago. All right. Oh, yay, we have another role play. Okay. The below portions of Steve's 2023 law enforcement interviews, which are inadmissible in a joint trial because of KRE 410, show how Steve's account developed. These statements, which are critical to Brooks' ability to mount a defense, would remain hidden from the jury. Okay. Lady in Gray says, these interrogations make me question the Commonwealth's evidence, even the good stuff. I mean, when they're relying on somebody like this, it tells you a lot. But we shall see. We shall see. All right, so August 22, 23, interview with Kentucky State Police. So Steve gets there. They're 4 seconds in, and Steve asks for a smoke break before they start and says, whatever you need to tell me, you can tell me out there. Is that fair enough? So they go out there, and they're out there for about 13 minutes, an unrecorded smoke break. They come back in, and a half hour. BL, there was a point when you got out of his Brooks truck, okay? Steve looks puzzled and says, are you sure about this? BL, yes. Steve, I don't remember. BL, I'm trying to help. Steve, I know you're trying to help, but I don't remember getting out of the man's truck, and that's a fact. BL, Stacy asked you, okay, what was he, Brooks, talking to you about? Steve, now run that by me one more time. BL, Stacy asked you what you were talking to Brooks about. Steve, I don't even remember Stacy being there. BL. Okay. Stacy asked you what you were talking to Brooks about. Okay. She says you say, quote, I have to take care of a woman with 5 kids who's hooked on meth, end quote. Okay. And Brooks might have led you to believe to kind of minimize, you know what I'm saying? What's going on? Because if you think, okay, I'm helping because the kids are better off, Steve, I understand what you're, BL. Do you know what I'm saying? Steve, I understand where you're going. If somebody's on dope, the kids are better off being without such and such. BL, yeah, so you're helping with just the car part, okay? But I want to make sure we're all in the clear and you're telling the complete truth. Steve, well, I'm trying to think because BL, this is very important, because it wasn't Red that we're talking about. Red has 2 kids. This was a woman with 5 kids, and this was reported immediately. And like I said, unfortunately, well, I can't go into details. Steve, I never asked you to. You know I didn't. BL, but this, Detective TH steps in. This is where you're at the crossroads, Steve. This is where you're going to have to come clean with this. Steve, well, I'm trying to think of if I said that or not. You don't want me to say I said that if I didn't. TH, no, correct. I want you to tell the truth. BL, but I don't want. Oh, let's read this book now before we keep going on. A witness reported seeing Steve talking to Brooks Houck in his work truck outside of a house in the Woodlawn subdivision around the time Crystal Rogers disappeared. She said after Steve got out of the truck, she asked what they were talking about. And he responded by saying he had to take care of a woman with 5 kids who was addicted to methamphetamines. The detective's line of questioning stems solely from that tip. At previous points in this interview, Steve explains that he must have been talking about a previous girlfriend of Joey's, who he called Red. He claims that Red was a methamphetamine addict and had a number of children he helped support financially. Oh, okay. All right, back to the role playing. Let's see. All right. Steve, you don't want me to minimize it, but you don't want me to say, yeah, I said it if I didn't neither, because then that's just BL. Correct. But remember, we know more than BL. This has to be straight up between all of us. I mean, you've got to come totally clean. Steve, I'm just trying to remember if I did say that. BL, we're trying to save your ass. TH, and maybe you remember this conversation going at a different location. Steve, that's where me and you are on the same page there. TH, where do you remember this conversation happening? Steve, the bar. TH, with who? Brooks? Steve, no. I never seen Brooks at no bars. I never even knew that he went to bars. TH, what I'm saying is, Steve, at some point you're with Brooks. Stacy asked you after your conversation with Brooks what that conversation was. And your answer was, I've got to take care of a woman who is addicted to meth and has 5 kids. Steve, and that's what I'm telling you. I think that was said at the bar. I swear I do. BL, where did this conversation between you and Brooks take place at? Where this was mentioned? Where did Brooks tell you this at? Steve, the only place that his truck would have been that I would have ever been would have been at the house right here. And he points at something. At that house, Steve, there's the house here, the lot here, and then they're building this house up here. TH, we have to quit talking in hypotheticals here. Steve, I'm not talking in hypotheticals. He asked me where the truck was. The truck was here. TH, so you were in the truck with Brooks there. Steve, that's the only place I could have been. That's the only place the truck was. TH, so what was this conversation? Talk to us. Tell us. Steve, I don't really remember. That's what y'all don't understand. BL, okay. Well, do you remember telling that? Do you remember saying that to someone? Steve, I'm still saying I said that at the bar. BL, okay. So was this like the night before, the day of, what? Steve, I'm going to say the night before. BL, the night before? Steve, this is what I'm going to say. BL, okay. So you're saying the night before, but don't say, what do you recall, Steve? And that's what I'm trying to say. When y'all said that I got out of the vehicle and said that, I never recall saying anything like that. BL, okay. When did you say it? Steve, and I could have swore it was at the bar. BL, okay. So did she ask you there what you all were talking about while you were on the job site? Or how did this go? Steve, I'm trying to think back. That's been a long time ago, and I still don't remember her being at the bar. Steve, somebody had asked me, who in the hell had asked me where I was going or what I was doing or what the hell I was talking about. I can't remember who the hell it was, but it seems like to me that, and this may sound stupid to y'all, but I'm thinking it was a man. I don't think it was a woman. I swear I don't. BL, this is a very important event. It has to come to you. Steve again says he is trying to remember. BL, the more stuff you say, the more truth you give, the more freedom. The more truth and totally wiping the slate clean, the more your slate is wiped clean. This is a gift that I ain't ever seen. Oh, we saw these quotes earlier. Steve, I understand that, but I can't remember if I said that to Charlie because, like I said, Charlie was there at one time. Or if somebody else walked up to me. BL, do you remember saying it? Steve, yes, I already told you that. BL, and were you talking about Crystal is that where you got that from Brooks? Steve, yeah. Let me say this. This way it don't seem like y'all are leading me through nothing here. BL, okay. Steve, I said I got to take care of a woman, maybe young lady. I don't know how I phrased it. That's got 5 children. I said that. BL, because the person who says it in their statement, okay, says that they understood it, that the person was going to be dead and that you were doing the world a favor because they were hooked on meth. Did Brooks ever mention the fact that she was hooked on meth? Steve, not that I could ever recall that he ever said she was hooked on meth. TH, what was your conversation with Brooks? What prompted you to make this statement to someone else based upon your conversation with Brooks? What was that conversation? Steve, well, let me think before I spout my mouth off and say something wrong, muttering to himself while trying to think. Let's see. Brooke asked us to move the car. I'm thinking that was all the same day. Don't quote me on that, but I'm thinking it was. Oh, Steve. TH, listen, you had a conversation with Brooks. Steve. Okay. TH, we know that. By your own admission, you had a conversation with Brooks. From that conversation, you felt the need to tell someone that you had to take care of a woman who was addicted to meth and had 5 kids. Listen, stop. Shh. This is where you're at a crossroads. This is stuff that's hard for you to hear come out of your own mouth, okay? I get it. But listen, you can't tell me, I'm not calling you a liar or nothing, okay? But you can't tell me that you remember telling somebody about the conversation, but yet you don't remember the conversation. That doesn't work for me, okay? So what I'm saying is, if you need to think whatever it is, that's fine, but we need the details of this conversation. Steve, sure. TH, this is important. What was the conversation between you and Brooks? Steve, I don't know. And this is facts now. I don't never remember him ever saying nothing about meth. Maybe I throw that in there. I don't know. Now that's a fact. TH, tell us about the conversation. You were there. You know. What was the conversation? Steve, well, like I said, we was sitting in the truck. We got to that point. And if you'll give me a second, I need to think because I don't want to tell you something that ain't so, and then you'd be pissed off. TH, correct. BL, tell us exactly what happened. 1000% honest. You've got to be all the way. Steve, I need to see exactly how he said whatever he said. Steve appears to be thinking out loud. What did he ask me? I think the conversation started out, and don't quote me on any of this, sir. You are always being quoted on everything you say. What would you do if you had what I'm going to call womanly issues? That maybe isn't what he called it, but that's how I'm going to phrase it. A womanly issue that you don't know how to handle. I'm like, well, I don't know what you mean by a womanly issue. That could be 1,000,000 different things. Evidently, the whole county evidently knew they didn't get along. The whole county. BL. Yup, it was no secret, Steve. It was no secret to nobody. And that's what I just asked about. That's what I just about asked him. Y'all can't get along. Is that what you're telling me? Y'all are always fighting with one another. And I knew it was a fact. Everybody did. And he said, yeah, personally, me, I would leave my wife and be done with it, you know? BL, there's a time for that, especially with the kids around. Steve, and I think, now don't quote me on this, his exact words were, well, I just like her gone. Well, to me, gone means gone. That don't mean, I'm going to divorce you and you're going to go your way and I'm going to go my way. Gone means gone. BL, yes, Steve. And I'm pretty sure it means the same thing to y'all, correct? TH, are you saying dead? Steve, well, he didn't say dead. He said gone. TH, but that's what Steve, that's what I'm insinuating. TH, let's just talk. Steve, yeah. TH, let's quit. Let's just talk. BL, he wants her, Steve, out of the picture. That's the best word I can use. Steve, and I'm like, I don't really know how to help you with that. I ain't got those kind of connections. I ain't got that kind of reach. I know y'all, gesturing to the detectives. No, I don't. TH, okay, so I'm going to stop you there. Steve, yeah, go ahead. TH, what did he ask of you? Steve, basically, again, could you move a car if I need you to move a car? So that means it ain't what he said. It's just my opinion that basically he was, I don't know if he personally was going to do something that he needed the car moved. TH, but you just said that you didn't have that kind of reach or have that kind of connection. So why would you say that? What did he say that would prompt you to say you don't have that kind of reach? Steve, well, when you tell me you want her gone, I mean, why are you telling me this? Why are you telling me? Because I ain't got that kind of reach to make something like that happen. Or maybe he was just, how do I say it? Maybe he thought I was trustworthy. Or maybe he thought this is a good man to set up with the whole fucking deal. BL, correct. Bill, why do you think he thought you were the most trustworthy? Steve, he might not have thought that. I said maybe. Bill, obviously he came to you. Steve, I thought, and again, maybe he thought I was the stupidest one to get set up. Maybe. BL, that doesn't make sense, Steve. I think he thought you were the right man for the job. BL, let me ask you this. Did he ever think you were associated with any motorcycle gangs or anything at the time? Steve, well, I always rolled with motorcycle gangs. Everybody knows that. That ain't no secret. BL, well, do you think that's why? Steve, it may be. Everybody's seen me ride with some. Detective BL told Steve he is missing some major steps in his alleged account of the days leading up to the disappearance of Crystal Rogers. Then they go on another 64-minute unrecorded smoke break. Oh boy. TH, I think we've got to clear it all up. We've been all over the place. Sorry, that's actually me stretching, which I imagine is probably what they were doing as well. Oh, excuse me. All right, let's just pause while they're on the smoke break before we come back. Say hello to people in the chat. All right. Let's see. Oh, Angela's packing for 6 for vacation. Oh my. Good luck with that. Hope you have a wonderful time. Juju Bean, I would love to know the Lawson's definition of a job site. Seriously, I'm very confused about all of that as well. But okay. And Lady Gray, poor Steve. No wonder he couldn't keep his story straight. This is a mess. All right, this is a mess. Oh my goodness. Wild. Juju says the Lawson liars. I mean, oh my goodness, this is wild. I object to 1,000,000 issues. You know us and our womanly issues. By the way, many of them are very sexist down there in Bardstown. Okay? I'm just saying. Kelly, I don't have 1,000,000 issues. I have 1,000,001. I love that. I'm trying to encourage people to come on and role play. Yeah, a lot of this that's why court documents are my favorite things. Yes, nothing is confidential ever when you go to talk to the police. I don't want you to twist my words around. So they're going to do that. Okay. They're going to do everything in their power to do that. The theme for today is lurking work. That's fine. I love that. Juju says motorcycles. Paraplegic Lawson due to a motorcycle, right? Correct. Yeah. A motorcycle accident in 2021. Yes. That's true. Llama is always entertaining me, Amos. Yes. I'm here all day for you. Because I haven't even talked to you this week. It's been horrible. I love all the unrecorded smoke breaks. So many of them. All right, we're almost done with this document here. Okay. All right, where were we? So they took an hour-long unrecorded smoke break. TH. I think we've got to clear it all up. We've been all over the place, Steve. Just like I told you outside there a minute ago, Joey had been working for Mr. Brooks. Steve said that Joey told him Brooks needed some bobcat work done. He explained that he met with Brooks the following day to discuss the job. I don't remember if it was that day or the next day. You told me 2 or 3 days. I can say that we walked over to the house. Oh, wait. I'm sorry. I screwed up. Referring to a house under construction in Woodlawn, Steven says there was a hole in the attic. Somebody fell through it. It was me, Joey, and Brooks. And he wasn't worried about the hole or nothing else. He asked plain and simple, would y'all help me move a car? Steve, Brooks' truck is all the way parked up at this house, indicating a spot on the table in front of him by this time. Most of the time, it stayed parked wherever he was framing at in the Woodlawn subdivision. Have a conversation with them. You know, I don't like the bitch. We don't get along. He never called her a whore, but that's what I'm going to use. What? Oh my gosh. I want her gone, plain and simple. That's what he said. I want her gone. Okay, you want her gone? I did tell him straight up, I will help you with the automobile. I did tell him that. He said, will you help guide? I may be getting something wrong here. Is that a good way to phrase it? Not great. This is not great. Detective BL. He wanted you to help guide him in the direction of getting a homicide done, Steve. Yeah. Oh boy, that's something. All right, so September 12th, 2023. Another KSP interview. Steve, let's see. How did he phrase? I want to try to get it perfect here. Steve, like I said, I think I was just up there by his truck and he said, hey man, let me talk to you. I said, oh, okay. What's going on? I'm pretty sure he said, sit down, but I'm not for sure about that. I'm like, what do you need? He said, you know, me and Crystal, we're not getting along, or we've had words, or whatever he called it there. I mean, it's all the same thing. They're not getting along. I said, I hate that you and your old lady aren't getting along because I don't get along with my old lady. So I wish somebody would say that to me. Well, that's not what I mean. I'm like, well, what do you mean? He said, basically, I hate her. How's that? I said, well, okay, that's not a good thing. And he said, I'd like to see her gone. I think that's the way it was phrased. I'd like to see her gone. I think that's exactly the way it was phrased. Steve, I said, you'd like to see her gone? And he said, yeah, gone. I think he done that. Gone. Gesturing with his arm. I don't know what he's gesturing as. Maybe this. Oh, I don't know. Or this. Steve, to me in that instance, that's the way I interpret it. Just like you just said, meaning the detectives, that he wants her deceased, dead. However you want to say it there. Steve, I'm like, no, you've got the wrong motherfucker here. You know, I ain't no killer. I don't kill people. I don't kidnap people. And I don't kill people. And I don't hurt children. That's something I do not do. Now, okay, enough of that role play. Oh my. All right, so jurors will not know that the clearest version of this account came about after Steve took an unrecorded smoke break with investigators for over an hour, nor will they hear him reference what he spoke with investigators about outside, which clearly shows that the interrogation did not cease once Steve and the detectives left the interview room. Jurors will be entirely unaware that his accounts of the location and timing of the conversations he supposedly had with Brooks about moving the car and about Brooks wanting Ms. Rogers gone are inconsistent in each retelling, and that at various points the order of events switches back and forth. I mean, I'm just going to say those interviews are shit shows. Okay. Shit shows. Oh my goodness. Wow. All right. Jurors will not know that even the finished product of law enforcement's efforts, his testimony recounting the alleged solicitation before the Nelson County grand jury, contains details inconsistent with his final version of events as told to investigators 1 week prior to appearing before the Nelson County grand jury. For example, on September 12th, Steve Lawson told investigators this conversation occurred in the Woodland subdivision. As the grand jury, he said it took place on Glenview, which would mean he had this discussion outside of the residence Brooks shared with Crystal Rogers. Jurors will not be able to visualize Steve at this fabrication is extracted during hours of interviews to see his obvious fear of getting the facts wrong and efforts to come up with the right version of events to appease the investigators. Most importantly, jurors will not see investigators literally feed Steve what they wanted him to say. Jurors would only hear the final product that investigators fed to Steve. Although the government has accused Brooks of trying to hide the complete picture from the jury, what will actually be hidden from the jury are the unsavory tactics law enforcement employed during their interviews of the Lawsons that ultimately resulted in false confessions. But Brooks must be able to expose those tactics if he is tried jointly with the Lawsons. Brooks does not want to hide the complete picture. He simply wants due process and the opportunity to mount a defense. And we already covered what that was. If Brooks were to be tried alone, both he and the government agree that none of the statements either Lawson has given to law enforcement would be admissible. As a result, he would have no need to question the veracity of such statements at trial. Avoiding the obvious evidentiary issues with the Lawson statements is precisely why Brooks is requesting that these defendants remain severed. At a joint trial, the court is faced with the insurmountable obstacle of admitting either, one, all of the Lawson's statement in violation of KRE 410, or two, only their statements predating 2023, along with Steve's 2023 grand jury testimony and or his 2024 jail calls in violation of Brooks' Fifth Amendment right to due process and his Sixth Amendment right to confront the witnesses against him. If the court joins this case over our objection, the court must make the Hobson's choice of either preventing Brooks from effectively attacking the veracity of the Lawson statements in violation of his constitutional rights, or allowing Brooks to mount a defense, which includes introducing the Lawson statements, which are protected by the KR 410. Basically, this is a pickle, okay? Of course, the obvious way to avoid the due process and confrontational clause violations at issue is to deny the government's motion to join these defendants. Simply put, the case must be severed. And C, the oh my goodness, we're not going to read all that stuff there. That's all court stuff. The underpinnings of KRE 403 for support severance. It is undisputed that Steve Lawson and Joey Lawson's statements cannot be used to incriminate Brooks without Brooks having an opportunity to cross-examine them. It is further undisputed that given the intertwined evidence and that the Lawsons are directly discussing the facts of the case, it will be impossible for jurors to follow such an admonition. In a joint trial, Brooks would have no choice but to delve into impeaching Steve and Joey's statements subject to the aforementioned Hobson's choice the court will have in choosing between Steve and Joey's rights pursuant to KRE 410 and Brooks' constitutional rights under the Fifth and Sixth Amendment in the United States Constitution. What is crystal clear is that all of this serves to confuse the issues, mislead the jury, and cause undue delay as prohibited by KRE 403. We're almost done, guys. In a separate trial of Brooks Houck's, none of Steve's or Joey's statements are admissible. In a separate trial, Brooks will not be forced to delve into the numerous inconsistent statements of Steve or Joey. Brooks will not need to expose law enforcement's coercive interrogation tactics against Steve and Joey. Those realities only matter when Brooks is forced to defend against these coerced statements in a joint trial where he will not have the opportunity to cross-examine Steve or Joey. In sum, a joint trial absolutely confuses the issue about what evidence is admissible against whom, misleads the jury about what it can properly consider as evidence of guilt, and will inevitably make this trial substantially longer than a trial of only Brooks would need to be. Severance puts the government in exactly the position it should be. It can plead or dismiss Steve and or Joey's case and use one or both of them as witnesses against Brooks. Then Brooks would have the opportunity to cross-examine Steve or Joey with all of their statements, including those made as part of their plea negotiations. Instead, the government wants to try Brooks jointly in violation of his Confrontation Clause rights by using the Lawson statements to incriminate him without the benefit of cross-examination, all the while knowing it would be impossible for a jury to follow a cautionary instruction under these circumstances. Finally, it is worth noting that Brooks did not create this situation. The government did. The government promised immunity to Steve and Joey and used the carrot of immunity to coerce these statements. Yet, the government reneged on its promise of immunity and indicted and jailed Steve and Joey Lawson. The government made an already unmanageable Brunton issue impossible and unsolvable absent Severance when the prosecutor inserted himself directly into the police interrogations of the Lawsons, which triggered KRE 410. Brooks was fully prepared to cross-examine Steve and expose his lies, but the government indicted Steve to prevent that from happening. That's a very interesting way to think about that. Interesting. Due process does not allow the government to introduce these statements in a joint trial and hide the tactics that led to them. The interplay of Brunton and KRE 410 distinguished this case from nearly all other cases in which Brunton issues arise. The government turned what would have already been an incredibly complex Brunton case into an unsolvable evidentiary and constitutional quandary. The only way to solve the problem the government created is for these cases to remain severed. D. If the court would otherwise grant the government's motion to consolidate, in the alternative, Brooks will agree to waive his confrontational clause rights as it relates, to Steve and Joey Lawson in order to preserve his due process rights in a separate trial. Okay. As made clear in his multiple pleadings, Brooks objects to the government's motion to consolidate, and noting stated herein should be interpreted as a waiver of that objection. However, if the court would otherwise grant the government's motion to consolidate over Brooks' objection, and despite the clear constitutional and evidentiary issues at play, Brooks will be left with no choice but to reluctantly take the government up on its offer to try him separately first in exchange for his agreement to waive his confrontational clause rights. A criminal defendant in the United States of America should never be forced to forfeit one constitutional protection in hopes of preserving another, which is exactly what Brooks would be forced to do if Brooks would otherwise be joined in trial with Steve and Joey Lawson. Brooks cannot mount a meaningful defense in a joint trial where he is prohibited from exposing how the Lawsons' incriminating statements were coerced by investigators dangling a promise of immunity. The only possible way for him to mount a meaningful defense at trial would be to take the Commonwealth up on its offer, agree to trade his Sixth Amendment right to confront Steve and Joey Lawson, and agree to the admission of all of their statements in order to preserve at some level his Fifth Amendment right to due process of law. Brooks would not have to make this inconceivable choice, to the extent it is a choice at all, if the court denies the government's motion and Brooks' case remains severed. But Brooks would prefer a separate trial, even if it means waiving his right to confront Steve and Joey, to a joint trial where Steve and Joey's sanitized statements are admissible, but he is prohibited from mounting a defense to expose how those incriminating statements were manufactured. Conclusion: there is no way for the government to introduce evidence against Brooks, Steve, and Jay Lawson at a joint trial without violating the Kentucky rules of evidence, Brooks' Fifth and Sixth Amendment rights, or both. And for these reasons, the government's motion to consolidate must be denied, and Brooks' case should remain severed. In the alternative, if the court is inclined to grant the government's motion to consolidate, despite the aforementioned issues, Brooks would have no choice but to agree to waive his constitutional right to confront Steve and Joey and agree to the admission of all of their statements in a separate trial in order to attempt to preserve some semblance of his constitutional right to due process by allowing him to expose Steve and Joey Lawson's lies by cross-examining law enforcement about all of their statements. Whew. That was a long read. But we did it. That one had role playing though. That one was very interesting to read. Let's see what some of our stuff on over here on the side is going about. All right, let's see. Okay. Juju being asked, all of these trial witnesses suspect need more provision than me. Let's see. Amos says, does this info come in on the current trial? Honestly, I don't think so, but I'm not 100% sure because I'm still putting together all of the details just still from Steven's trial, and I'm already at a ridiculous amount of sources need to like piece together the complete stuff from the trial. So I don't know. So we'll have to see. Juju Bean says, I've never seen these court documents, even though I followed this case for 10 years. I've said that for 10 times today. I mean, that's just how they are. These were hidden in some news articles. That's where I got them from. So, yeah, the things jurors won't know. That's why I always find these very interesting ahead of time. Because it's like, oh, that's interesting. Oh, Angie left. Well, bye, Angie, in case you're part of the replay crew later. Juju says, we all know Brooks is the ringleader. His subordinates are the bottom feeders, the Lawsons. Due process, it's the food chain shit show. Well, I mean, I don't know. This is not great. That is not great. Okay, is exactly right. I think the government has messed it all up. The government is, it's interesting. We'll find out more. Oh yeah, the violation of the Sixth Amendment is why the yogurt shop convictions were overturned. Just saying, yeah. That's why usually they just do separate trials to avoid this mess, to avoid it all. It's crazy. All right. Oh goodness. Okay, good, because I need this little bit of a break here because I gotta go to the bathroom. But up next, so that was June 3rd, 2024, by the way, in case you guys were wondering how far we've gotten, which is not as far as I thought we would get by now, but that's okay. I did say we were going to spend most of the days together. So I think it'll go, I don't even know if I'm going to be able to finish all this today, to be quite honest with you. Hold on. I'm waiting for this video to come up. So June 7th, which is like a week, 2 weeks after Jason Ellis's anniversary, his family speaks out, and I'm trying to get that to work because we haven't seen his mother and sisters speak out. So I thought this was very interesting to share because I always want to give these families that do decide to say something, just as much time as we've given, the Ballards and all of them, because their cases are important as well. Oh, geez. Hold on. Okay. Let me switch here. And when this happens, I'm going to go use the bathroom. All right. This is only like 3 minutes long. 3 minutes and 48 seconds to be exact. Okay.
Somehow still walking free. There are still so many questions surrounding the 2013 murder of Bardstown police officer and tri-state native Jason Ellis. Questions his family desperately wants answered. I sit down with them in a story you will see only on Local 12 News.
Jason was a fun-loving kid ever since he was little. And he grew up to be A fine young man.
A fine young man whose life was senselessly cut short.
We do a good job of trying to keep his memory alive. I mean, anytime we're together, we talk about him or talk about situations because there's always something that comes up that reminds us of him.
Knowing as much as he valued family and valued all of us being together, like that's when you really notice that he's missing.
The Bardstown police officer and Glenesty High School graduate was driving home from a shift when he was ambushed, shot, and killed as he got out of his car to remove debris from the road, which was blocking his exit ramp. 11 years later, his family is still left with more questions than answers.
We just want to know why, but we want to make sure that everybody responsible is held responsible.
If you are holding on to information, what are you scared about?
How can you take somebody's life? I don't understand it.
Those questions run deeper than Jason's murder. His was the first of 5 in the span of 4 years in the quaint Kentucky town, each killing, puzzling, each one still unsolved. First, Jason in 2013. In 2014, Kathy Netherland and her daughter Samantha were killed in their Bardstown home. Then came the high-profile disappearance of Crystal Rogers in 2015, followed by the shooting death of her father, Tommy Ballard, a year later. So far, authorities have only arrested 3 people in Crystal's case, including her boyfriend, Brooks Houck.
And we definitely count that as a win. Like a progression in one case is 100% good news in the other cases because we hope and have thought for a while that they could all possibly be linked. So it's only just further information for us to possibly find out if there are, answers in other cases.
It's a commonly shared theory among many who've closely followed the cases, especially those in Bardstown, who aren't as willing to openly say it.
What are your thoughts?
I pretty much keep the thoughts to myself on that one. Don't want to open my mouth and something I really don't know, but just like the whole town, pretty much something everybody thinks, pretty much already knows, but
You won't say what that is.
No.
Neither are investigators. We reached out to both Kentucky State Police and the Commonwealth Attorney's Office. Both declined to comment on the ongoing cases. Still, Jason's family believes they are closer than they've ever been to justice.
I feel really confident, and every year I feel a little more confident just because I know how hard they're working. So there's always things that they're following up on, and so they're still actively checking every single tip, which is why it's important for people. If they see something, say something.
While they are still far from getting closure, more than a decade after Jason's death, there is one sense of comfort for this still grieving family.
I know where my son is. We're Christians, and I know my son is with his Lord. That's my peace. That's what gets me through. Like Callie said and Lacey, we just want to know why.
Oh, they seem very sweet. Oh, okay, that was the end of that. Okay. So we're going to go back over to this one. So yeah, that's one of the first times that his mom and sisters had spoke out that I was able to find anyway. So I wanted to share that with you guys and give me just a couple minute break. All right. So June 12th, 2024. There's a hearing regarding the motion to dismiss Lawson's charges. Steve Lawson, by the way. Judge Charles Sims said he has listened to recordings provided by the prosecutors, including a jail conversation between Lawson and his ex-wife. Young confirms that there was no immunity agreement ever in writing, only an oral agreement that Lawson was 100% truthful and no omissions in his story. Sims asked Lavit if that's the case, and he denies, saying that wasn't the understanding. Lavit offers to give the judge a flash drive with interviews of those conversations and a record of when those interviews occurred. Quote, the prosecution can't just cherry pick one particular interview and say that was the deal, Lavit argues. He asked the court to consider everything in all interviews to determine what the agreement was because nothing was in writing. Quote, they had complete control. But sir, why did you not demand something was in writing? I don't understand. It's weird. Judge Sims said he's reading what Lavit submitted in a memorandum on June 8th. Quote, I don't see anything that's a different agreement, he said. Sims said he had dozens of cases to look over and doesn't have time to look through all the footage on Lavit's flash drive. He said he would hope Lavit would be able to point where a different agreement was made. Quote, I don't have the time to go through enormous discovery, he said. It's a burdensome for the court for someone to dump a bunch of interviews on them and say, hey, go find it. Sim asked if Lavit is willing to put out any evidence, including witnesses, showing a different agreement was made. Quote, I think that my client agreed to be truthful. That's the extent of it, Lavit says. And then Lavit just walks right up there and wants to submit the flash drive, which he hands to Judge Sims. Now, Commonwealth attorneys say Lawson didn't do what he was supposed to do in the agreement. Lavit calls the oral agreement between prosecutors and Lawson an artful and informal agreement between parties. He reads the conditions of Lawson's immunity. But the whole basis of this agreement was that Lawson told the whole truth, Prosecutor Young tells the judge. Lavit needs to tell us what statements were truthful. Young said the problem with Lawson's testimonies was that he was minimizing his role. Quote, he told us he was involved in the helping of the eventual murder of Crystal Rogers, Young said. But said Lawson was telling the truth in some statements. He said they have evidence and witness testimony supporting his alleged minimized role. That's to be desired. Okay. Young said Lawson told someone over a jail call that he, quote, lied and messed up his deal. He said the immunity was a blanket immunity on June 8th, and on June 12th, it was immunity as long as Lawson didn't kill or hurt Rogers. Quote, we have examples when he's saying the exact opposite of what he said in a previous interview, Young argues. Lavit said there were many smoke breaks in the police interrogations, implying there were many distractions. Quote, did he tell the truth? Sims presses. When I was there, he told the truth, Lavit said. When I read the discovery they sent me, I think he was trying to tell the truth. That needs to be examined by the court. Judge Sims raises his voice, says, I want to get to the hearing. I don't want to keep talking. Oh, spicy judge this morning. So then, excuse me, prosecution plays portions of videos. The first clip is an audio recording from the jail where Lawson tells another person on the phone he messed up his deal. The second clip from when he was being transported is played. Both audios were difficult to clearly make out in the courtroom, but Young begins to explain both clips to the judge. Young said Lawson was asked whether Lawson's ex-wife was with him on the Bluegrass Parkway when he was there with Joey, as Crystal's car was allegedly being moved. Young said Lawson's ex-wife has knowledge of what happened and believes she was involved in the crime. Oh, but she passed away a few years ago. So a third person, I think that's Rebecca that they were talking about in that motion. And I think we brought her up in the last one too. She was charged and then her charges got dismissed. All right. So another clip from a police interrogation where Lawson is questioned about his ex-wife's role, Ted Lavit moves closer to the television screen. Quote, why was Tammy on the Bluegrass? A detective questions Lawson. She wasn't on the Bluegrass with us, Lawson responds, repeating he would be able to recall if his wife was there with them. Young said prosecutors were asking Lawson's knowledge of whether Crystal's car was being taken to the Bluegrass Parkway on June 19th, 2023. What was the plan to do with the car? Someone asked. Young said Lawson acknowledges he knew it was going to the Bluegrass Parkway. Another interview with Kentucky State Police on September 22nd is played, again about discussions about what Lawson knew about Crystal's car being taken to the Bluegrass. Lawson now says that he had no idea about the plan. He stated he did not know Joseph Lawson was taking the car to the Bluegrass, Young argues. He said prosecutors are trying to determine who was involved and in what sequence. Another clip is played where detectives discuss the use of a bobcat, also referred to as a skid steer, which Young believes was to be used in the crime. In the same interview, another clip is played, and Lawson said the bobcat was left under a tree, but when he went to get it, Joseph had stolen it. One more clip from an interview is played, and this time, when Lawson is questioned about the phone call he made to Brooks Houck around midnight over the 4th of July weekend. Initially, he said he was questioning about an apartment, and Houck says Crystal is asleep. Young said that story has many different interactions over the years. Lawson tells investigators he hasn't seen the bobcat in 5 years. Young gives the judge a transcript of an unrecorded interview with Lawson, which Lavit reportedly has also been made aware of. In it, Young said Lawson said the bobcat was being used on Thompson Hill Road around July 4th, 2015. That was the last place they searched, right before Steve got arrested. Where was I? Oh, he said they were burning and digging, adding that there is only one skid steer or bobcat. In another conversation, Young shows a clip where Lawson was questioned about his work with Brooks Houck. Lawson tells police he wouldn't do any work with him outside of saying hi in passing. Young claims Lawson also deleted 24 phone calls between him and Houck from May and June, which Houck had also deleted. He presents the phone records to Lavit and the judge. Quote, "Our agreement was 100% truthfulness and no admissions, which I think in those 4 examples you see that the defendant was not truthful," Young argues. The prosecution rests and Lavit begins his response. "We assert that he told the truth in all 4 cases," Lavit said. He said Steve Lawson did some jobs for Houck occasionally, but was never an employee. Lavit adds that Lawson did not take the bobcat or use it either. To say he lied and broke the agreement is not how the law looks at it, he said. Lavit said he was there when Lawson told authorities about the phone call was just about finding an apartment. Young interjects and says there is a game of charades between Lawson and Houck that's been going on for the past years. He said Lawson testified to a grand jury that it was about informing Houck the job was done. "What are we doing here?" Young questions. "Going in circles," Judge Sims said. Lavit said phone calls in the jail with Lawson's ex-wife were not contradicting his testimony. It was all consistent, he argues. Quote, "We did everything the Commonwealth was asking for," Lavit says. "It led to the charges against Brooks Houck and Joey Lawson." Attorneys now discussing what testimony will and won't be used in trial, and the judge questions Lavit about his objection to combining the cases. Says there are inconsistencies because the objection wants some of the testimony to not be included, but he plans to also use it. This lawyer is a hot mess. Judge Sims will review the evidence heard in court and make a final decision on what evidence can be kept, and the motion to dismiss Lawson's charges soon, and court is finished for that day. All right, let's get over here and see what y'all are saying. Juju says, if people have a big enterprise, anyone is a target. Given that fact, you never know what all 5 knew. The man on this interview was smart to state, I am keeping my mouth shut. Smart. It's true. Keep your mouth shut. Oh, Jujubee, SMFH, this case. Thanks for all your hard work, Llama. Of course. I mean, I am very invested in this case. If you can't tell, I said I was going to dive deep, and I am diving deep and giving you all the deets. Lady in gray lesson. Always, always, always get a lawyer, and not negotiable. I know, right? Well, he had a lawyer. We'll learn more about Lavit later, that guy. Oh my goodness. Jujubee. Daddy Lawson has an ex-wife, passed away. Yes, good job. She is dead, you think? Yeah, I'm pretty sure she's passed. Tammy. Because there's Tammy and then there's Rebecca. And I think Tammy is the one that passed away. But Rebecca, I think is all right. Did they both pass away? I don't know. That's a good question. Everybody there has like the same names. It's very weird. Oh. Turquoise Kitten, hello, and welcome. It says 2 trash families, 1 rich, 1 poor. I mean, you know. Okay, all right. Let's see what we got next, you guys. All right, June 14th, 2024. A newly released document confirms that a search on December 6th, 2023, which is the few days before Steve Lawson got arrested, was for a possible location for the body of Crystal Rogers. Remember, they said, oh, it could be any one of these 3 cases, hers, her father's, or Officer Jason Ellis. Excuse me. The document, which was unsealed, says Steven Lawson told detectives in November 2023 that he saw his son. Oh, it's train time. Train time. That he saw his son, Joseph Lawson, and another man named Jeremy Thompson digging and burning at the site in Cox Creek with a skid steer, which is a type of excavating equipment. Steve said Joey Lawson and Jeremy Thompson were burning large amount of woods in the hole at the request of David Thompson. And this happened within 5 days of Rogers' disappearance. By the way, Dave Thompson is Jeremy Thompson's father. Now, Jeremy Thompson, who apparently was allegedly burning wood with Joey, actually died November 20th, 2022. So there's another person gone. However, the document goes on to say that Steve Lawson had previously denied that a skid steer was ever on the property in prior interviews. This document says Lawson could not explain the change after being questioned. You know what else? Another thing I just thought of was in Brooks' interrogation video that we all watched, right? He's going on and on talking about everything but Crystal being missing. He sure does bring up that skid steer a lot now that I think about it, because I didn't know what that was when he was talking about it. And I was just like, oh, well, I mean, I thought it was like farm stuff or whatever. But I do remember him talking a lot about a skid steer. So that is interesting. All right. So next we're in July 2024. And July 3rd, which you guys, today is July 3rd. Today is the 10th anniversary of Crystal Rogers' disappearance. By the way, I don't think I said that at the beginning, and I meant to. But yeah, today marks 10 years since she disappeared. So, the 9-year anniversary of Crystal Rogers' disappearance. This anniversary is different than the rest because the 3 men are in jail in charge of killing her. Now, also on this day, July 3rd, Judge Sims denies Steve Lawson's motion to dismiss charges. He was like, nope, yeah, those are sickening. The court found there was never a written immunity agreement between Lawson and the Commonwealth, adding, quote, Lawson failed to call any witnesses about an alternative immunity agreement, including his attorney, who was present for most of these discussions and or statements. The court said the Commonwealth's offer of immunity was based on Lawson being truthful when talking with police and investigators, but found he lied in interviews, despite being aware of the requirement and Lawson's counsel saying he did not deliberately lie. The judge's order indicates that Lawson never denied lying to authorities. The court also said a lot of information Lawson provided to authorities was inconsistent with the investigation, such as his relationship with Brooks Houck, Roger's boyfriend at the time of her presumed murder, the placement of Roger's vehicle on the Bluegrass Parkway, and an earlier morning telephone call between Lawson and Houck on July 4th, 2015. Quote, these recordings clearly establish that Lawson provided wildly inconsistent information about matters that are material to the Commonwealth's investigation and prosecution, the court said after reviewing all its interviews and grand jury testimonies. All right, what time is it? 3:30? Okay. Well, you guys, up next, hold on, I'm scanning through my thing here. Do I have a video there? Oh, that's later. Okay. All right. How you guys feel about going kind of late today? Anybody? All right, because what I have next is a 2-hour hearing. I have Brooks Houck is in court fighting to keep his trial separate from Lawson. That's right. We actually have an actual Tate hearing of this. It's 2 hours. So just a second. Oh, hold on. I gotta switch accounts so we don't get any commercials. There we go. Okay. All right. You guys ready for some court? Yes. All right. Yeah, lady in gray. Those state witnesses are wow. Oh, it is wild. Okay. All right. So again, this is Brooks Houck's attorney fights to keep Crystal Rogers' murder trial separate. Let me turn on closed caption there. We got those. Check the volume. There we go. Are we over here? Okay. Let's see.
Thank you. Please be seated.
Thank you. Please be seated. I love the way the judge talks, by the way.
Good morning. At this time, let the record reflect we're taking up an action that is styled Commonwealth of Kentucky versus Brooks William Houck. It's 23 CR 309. Present is Mr. Houck with counsel, Mr. Butler, Mr. Shoring, and Ms. Jackson.
There we go.
Also present on behalf of the Commonwealth is Mr. Young, Ms. Young, and Mr. Lasowski. This matter is before the court today in regard to a motion to consolidate. I have reviewed all memorandums in regard to this prior to today's hearing. On behalf of the Commonwealth, are you all going to submit any evidence today or just argument?
Judge, I'm sorry. Judge, we're just going to be submitting argument this morning. I think when I say we're not going to submit any evidence, that may depend on what the defense counsel submits in this case, but whether we need to show the court something in response to that.
I have not watched this, by the way.
So
we are watching this together for the first time.
Mr. Butler, about the defense, any evidence that or testimony, anything you wish to present today, or is it argument also?
Judge, we're not going to present any witnesses, but we do have a transcript of September grand jury for the court that we're going to submit. We also have a pleading that is different points that Mr. Lawson made in his statements and how they developed. And we're going to use some clips as well from different points. And of course, we would incorporate the disc, I guess the flash drive we gave you previously, Your Honor, which I believe is all Joey and Steve Lawson's statements. So that would be the evidence we intend to present. Oh, sorry.
Okay. I guess it's the Commonwealth's motion, so are you ready to go forward, Ms. Young?
Yes, sir.
Proceed when you're ready.
Judge, I'm just going to address a few points regarding joinder first, and I would like to have reserve some time for us to address whatever the defendant is going to bring up in his evidence that he's going to present and in his argument. But as far as joinder is concerned, there's some general principles regarding that, and I think the court is very familiar with it. But I wanted to give the court something that we didn't put in our brief, which is the issues that were raised in Samia. Samia, everybody knows, is a case about redaction and statements. But Samia offered the court something else, the U.S. Supreme Court, and what he said is, well, if you just sever these cases, then you don't have to worry about it. And you preserve my confrontation right, and we don't have to worry about whether the co-defendant's statement implicates me. And here's what the court had to say to that. The court said that was too great a price to pay when someone's statement implicates the other individual. They went through all the reasons that joint trials are favored. They said joint trials encourage consistent verdicts, and they allow jurors to make more accurate assessments of relative culpability. They went on to say that joint trials preserve government resources and allow victims to avoid repeatedly reliving trauma. And finally they noted that separate trials favor the last trial defendant, who always has the advantage of knowing the prosecution case before they are tried. So in that case, the court went to great pains in order to keep the cases together. Kentucky also favors joint trials when any of the charges arise from the same set of facts, and that's what's going on here. All the co-defendants are charged out of the same set of facts and the same set of circumstances, the murder of Mr. Rogers. It's not enough for a defendant just to show some prejudice in order to sever the cases. They have to show it's unduly prejudicial if you join together. And it's not enough to show there's antagonistic defenses. In fact, that's a good reason for joinder. It's only when those antagonistic defenses mislead the jury that joinder is not appropriate. In this case, I don't think we have antagonistic defenses. At least that's what's been presented in the pleadings that we have so far. In fact, I think what we have are collaborative defenses between Steve Lawson and Brooks Houck, because the pleadings that we have in these two cases have the same misquotes, the same mistakes in them. There's obviously some form of collaboration going on in those pleadings as to a joint defense. And then in Mr. Lawson, Steve Lawson's joinder pleading, in which he adopted Mr. Houck's pleading on the joinder issue, it was completely directly opposite to what he had represented to the court on his other motion. So I think we have some collaboration going on here. I'm not even sure we have antagonistic defenses at this point. I'm going to let them argue whatever they're going to argue regarding the severance issue. I'm not sure what it is at this point, because initially it was the 410 issue, and that they needed to be able to show the statements that Steve Lawson gave and the interviews with Steve Lawson and Joey Lawson in order to present the defense of investigative bias, or this get Brooks mentality that they said they had to be able to present. Then in the second pleading that they filed, they said, we don't need to get into any of that. If the Commonwealth agrees not to present any of the statements made by Steve or Joseph Lawson, and that included, I assume they were arguing all the statements, whether they were part of the 410 or not. So I'm not sure what they're going to argue regarding that. So we'd ask some time to readdress that at the end. I think I can clear up one issue, and that's the one regarding the grand jury and Steve Lawson's grand jury. The defendant in this case has argued that Steve Lawson's grand jury, the second and third, I'm sorry, I'll take that back. The third and fourth grand jury that Steve Lawson had, because he had one in 2015, they've argued that those are a product of coercion. and that his testimony in the grand jury is a product of coercion. Steve Lawson himself has not argued that. And I don't know of anything that gives them standing to suppress Steve Lawson's statements in front of the grand jury when he hasn't even argued that they're a product of coercion. But if they do in fact have some standing to argue that, there are cases that talk about this type of situation. One is called U.S. versus Galistino. It's 617 F. 2nd 677. And that case cites Brady v. United States, which is 397 U.S. and I have the page site, which is 754 Judge. But both of those cases talk about if you're in a coercive situation as a defendant, what dissipates the coercion is advice of counsel. We use that all the time, whether it's entering a plea agreement or deciding to testify in front of the grand jury. Those are things that make that statement voluntary, including if you're giving a statement to police. That shows the voluntariness of the statement when it's given on advice of your own counsel. When Steve Lawson appeared back in front of the grand jury that third time after he had interviewed with the police, that was on the record that he was appearing that day on advice of his counsel. Now, there's something else they've raised as the grand jury that I think we can address and that may help the court with some of the issues they've raised in their pleadings. And one of those is they argued that we are going to seek to use this redaction in which we put the words other person in Steve Lawson's grand jury for when he refers to Brooks Houck. We have no intention of doing that. Those are testimonial statements. We understand our obligations under redaction, and in spite of the fact that Samia gives you some leeway on that, I think in Samia is distinguishable in the sense that Stillwell's statement in that case was necessary to show the conspiratorial relationship. We have other evidence to show that conspiratorial relationship, and I don't think that it would be necessary at all to bring up statements that Steve Lawson made in the grand jury about Brooks Houck. Now, Steve Lawson's statements about himself are coming in that he made in the grand jury. So if that helps the court resolve some of those issues, and then if we could address what they're going to argue is the reason against the severance afterwards, I appreciate it.
Thank you. Mr. Butler, you handled this for the defense.
Thank you.
Oh, it is a shame. Don't worry, I got rants later about it. Also, look at the circus happening in the courtroom. Look at that circus in Nelson County. Keep that in mind for later. Look at all this media. Is that Shay McAllister? I think that is Shay. She does a lot of reporting. We've watched numerous interviews she's had with family and everything like that. I think that is her right there. But look at the circus going on in this Nelson County courtroom about this hearing. Because the judge said something I do not agree with later about the whole thing. And I'm like, oh, sir. Suspicious. Oh, I forgot we can zoom through these. All right. Zoom, zoom, zoom. Oh. Okay.
Just to start out, where we believe this is, I think the court has really three parts that you have to look at in making this decision. The first part, and Ms. Young addressed it, is outside of the 410 issues, whether this case should be joined or not. Because obviously the court has issued an order on July 3rd, and that decision appears to rest with Steve Lawson as to whether or not those 410 issues are disqualified. Obviously, you can go through those. It may come to pass that that issue also lies with Joe Lawson. He has not filed some of the same pleadings. So where that stands, I don't know. Teresa's right. There is a preference for a joint trial. But I think we start with this. Prior to the rule being that we currently have, every defendant in Kentucky had an absolute right to demand a separate trial. And the rules that we deal with now came into effect and gave a preference for a joint trial. When I say a preference, that's exactly what it is. It's a preference. It doesn't mean it's required. It means the court is required to look at each individual case separately and make a determination of whether a joint trial would be unfair. The typical case that you have, in my experience with co-defendants, is you may have a 30-minute interview. I say, Mr. Shoring helped me do the robbery. Mr. Shoring says I helped him do the robbery. And we see those redacted out. And while there's certainly prejudice to that, theoretically, that other person, Steve Shoring, could be anybody in this room. It could be anybody in the world. This is different. And I hope I can walk you through why it's different. Number one, Brooks has a constitutional right to present a defense. Our defense is Mr. Houck did not commit this crime, and Steve Lawson is lying. And he has to be afforded a meaningful opportunity to present a complete defense. Switch to the next one. RCR 831 says that it appears the defendant is or will be prejudiced by joinder of defendants for trial. The court shall order separate trials. Now, going back to my first point, and that's an important one, while there is a preference, as Ms. Young said, for joint trials, if there's prejudice, the court doesn't have discretion. The rule says that they shall. Next slide, please. This is the state of the law in Kentucky. In a joint trial, the confrontation clause plan applies even to hearsay statements offered as evidence against the co-defendant declarant himself. If the declarant does not testify, and if the statement either expressly or by immediate implication tends to incriminate another defendant. Again, coming back to the first point I made. In my example, what we typically see, where I say, to get out of trouble, Mr. Shoring, I did the robbery, it's all his idea. And he says, to try to get out of trouble, well, I was there, but Mr. Butler, he's the one that came up with this idea. It could be anyone. In this case, as we're going to show you, there's no way that any of this can be redacted without incriminating him. And if Steve Lawson doesn't testify, we lose our confrontation clause rights to cross-examine him. That's why we even referenced in our brief that if the court was going to otherwise join these cases, we even had a discussion with him about whether it was better to waive his confrontation clause rights or his due process rights. That's how important I think it is in this particular case. Go ahead, please. Here's what we believe we're talking about. So, and I think this court's very aware of this when I go through. You have Steve Lawson, who testifies once or twice in a grand jury back in 2015, 2016. And in those grand juries, I can't remember it's one or two, it doesn't matter. He says, I have no role in this, don't know anything about Mr. Houck's role. There's even a FBI FBI sends an informant here in 2020 and surreptitiously tapes Steve Lawson. And in that, and we'll go through some of that more later, he says, I didn't have anything to do with it. I don't think Brooks Houck had anything to do with this. Fast forward into 2023, the government, the state government begins a grand jury investigation. His statements change dramatically over time. I think this court in its order from July 3rd actually used the terms wildly inconsistent statements. The September 2023 grand jury is the cleaned up, best Steve Lawson version to help the government. The first point, and we're trying to walk through some of these, Steve and Joey Lawson were with Brooks on a drywall job when Brooks asked him to move Crystal's car. So that's one incriminating point that is brought out of the September 2020.
So where do you remember this?
Ooh.
No. No, I'm just saying, I never even did it. What I'm saying is, see, somebody we're with folks. You let's have a conversation that you had with Brooks, ask you what that conversation was about. Okay. So what your answer was, I've got to take care of a woman who's addicted to that. That's 5 years. I mean, I'm not, that's what I'm telling you. I think that he said it. Oh, I swear I know that.
Let's see how good of a job I did role playing.
Where did the conversation between you with that place then? Where this was mentioned? The reason, here's what I'm saying, as you said this, okay? Here's what I'm saying, but where did this conversation, where did Brooks tell you this thing? Oh, the place that he broke with me that I would ever be would be at that house right in that house. There's a house here, a lot here, and there's a house up here. We have to quit talking in, hypothetical. I'm not talking about that. He has to go to the truck, on the truck. You were in the truck and go stay. That's the only place I could live. That's the only place that I saw. So, what was this conversation?
I wouldn't get your hopes up on any of these other cases.
Okay, do you remember telling me that? You're always saying that, so. I kept saying, I said that to my home. Okay, all right, and when? So was this right before you had to before then? Was this like the night before, the day of, what?
I need that t-shirt. I just realized y'all crazy.
Okay, all right. So you're saying this the night before? We don't say, I mean, we do recall. And that's what I'm trying to say, when y'all said that I got out of the vehicle and said something like that, I never recall ever saying anything like that. When did you say that? And I could have sworn it was at the bar. Okay, so did she actually there? What you were talking about? Oh, you were on the couch match, and how was it? Hang back. Nothing wrong with that. Or what I was doing, or what the hell I was talking about. That seems like this, I might sound good, yeah. But I don't think it will make it. Okay. I don't think it will more. Okay. I'm sure about it. Here, this is a very important thing you have to go to. Okay. The more stuff you say, the more truth you give, the more truth. Freedom, yes. Yes, correct. More truth. And totally like the slate clean, the more your slate's like clean. This is a gift like I ain't never seen. All right. I said Charlie was there. Yeah. Or somebody else walked that phone. Do you understand it? Yes, I'm just talking that, yes, but I don't remember. All right, and where are you talking about Preston from? Is that where you got that from? Then at me saying this, that's what you know, seem like y'all lead me through that. That is what I didn't say. I said I got some very woman. I don't know how I just have 5 children. I said, because the person that said it, okay, says that in their statement, that they understood that person was going to be dead and that you were doing the word favor because they were doing. No. Did Brooks ever mention the fact that she was a donor? Not that.
Horrible day. Horrible shit to wear. Oh, I don't know. I think it's unrelated.
Yes.
What prompted you to make this statement to someone else based upon your conversation with Brooks? What was that conversation?
I think before I spat my mouth up and say something wrong. There. I think George was dead, or maybe. Who knows? And she wouldn't nobody run that way. And somebody was running down here. Okay. I'm liking it was all the same day, and I'm not going to anything. And I'm liking it was.
Stop for a second. So, that was an interesting clip. If you look at him, when they ask about who was running the Bobcat, he immediately answers because it's telling the truth. Here's what they're trying to do. And again, their motivation, I don't know. But what happens is, in October of 2015, a lady goes to the police department and says that Steve Lawson got out of Brooks' house truck and said he had to take care of a lady with 5 kids and methamphetamine. So it wasn't right away. But that's what she says. Now, mind you, there's absolutely no evidence that I've seen in the bazillion pages of discovery that ever indicated this Ms. Rogers was on methamphetamine. None whatsoever. They just glossed over that. What they're trying to do is they're trying to get him to corroborate that statement. And as you can see from the very first clip, we'll go through the rest, he has no idea what they're talking about. None whatsoever. And you see they feed the exact thing that this lady says in this October 2015 statement to him. And you see the progression of how ultimately we get to the grand jury where it looks perfect. It fits like a glove.
Had a conversation. You had a conversation. Okay. From that conversation, you felt the need to tell someone you have to take care of the woman who have 5 kids. And so this is where you're at a crossroads. Okay, this is the stuff that's hard for you to hear come out of your own mouth. I get it. Okay, but this you can't tell me. I'm not calling you a liar or nothing. Okay, but you can't tell me that you remember telling somebody about the conversation you don't remember the conversation. It doesn't work for me. Right? So what I'm saying is, you need to think, whatever it is, that's fine. But we need the details of this conversation. Right? What I'm asking is, what was the conversation between you and Bruce?
I don't, but this is facts, and I don't ever remember saying nothing about it. Maybe I'll throw that in there. I don't know. No, that's a fact.
So tell us about this conversation. What was the conversation? You were there. You know, what was the conversation?
Well, I said we were sitting in the truck here. We got to that point. We just sat there. I don't think I'm going to fight, but I'm only telling you something that ain't so.
Oh.
Then you can get out. But I'm just like this. All the way, one family love. I'm sorry to tell you this, exactly what happened. He said whatever, he said whatever.
Now, obviously, the problem with this is the court knows. The detectives in their minds have decided what they believe the truth is. The whole time this is going on, through all these interviews, they are continually telling him, this is your life. You can go to prison for the rest of your life. You can go to prison for 20 years. Don't screw your deal up. I promise the deal of a lifetime. Never seen anybody get a deal like this. And then they'll come back over and over and over again, and they'll say, this is it. This is really important. We got to have this. We got to have this. And ultimately, he'll get where they want to go.
I think that's for exactly. Well, I just like that. Well, to me, God means God. That don't mean, I'm going to force you, you're going to go your way, I'm going to go mine. God means God. Yes. And I'm pretty sure it's the same thing, yeah. Correct?
I'm saying that.
They didn't say anything, God.
That's
why I'm insinuating. You don't just talk.
I'm pretty sure this is KSP, Kentucky State Police. Yeah, all the documents said Kentucky State Police on top of the interviews that we read.
I don't really know how to help. I
So I'm sorry. What did he ask?
Basically, could you move a car if I need you to move a car? So that means, and this is my opinion, it ain't what he says, it's my opinion. That basically, I don't need that person. We're going to do something that we can do this. Yeah, but that's what I'm saying. Okay.
But you just said you didn't have that kind of reach or have that kind of connections. What would prompt you to say that? What did he say that would prompt you to think or say that you don't have that kind of reach?
Well, when you tell me you want to travel, I mean, why are you telling me this? Why are you telling me? I ain't got that kind of reach. Or maybe you just. Maybe. Or maybe. Even.
Detective Snow was the main investigator, but at this point in time, Detective Snow's already retired. But these are both detectives with KSP.
That's amazing. You're going around here missing very little. This is what I'm trying to tell you. Stop. If you stop coming on, I'm going to tell you about. You know, that can't go. Stay right. I got a stupid question. That's not a stupid question. Y'all may not get. Y'all questions in here are stupid. Y'all might not get the utility. $30,000 for my campaign. If y'all tell me how and I'm not here for this. I'm busy. One deal. That's not where's he?
I like how they put it in big bold.
I think we got cleared all up. We've been all over the place.
Like I told you outside, and go and lose it. So it didn't work for Mr. Rose. So I come home, I don't remember when and how, or what time it was. Today, I said, what? What's got court cases to do? I said, what does he got that he needs about to get for? I said, what do we got? I said, look, we'll have to go see tomorrow. So we ride out there and we enjoyed it. I said, I go to work with Brian Dillon. Got there, he said, well, I need this lot, this lot, this lot, and I need tracked out. Okay, good enough. Give him a price. He went from there. I don't remember if it was that day or the next day. You told me 2 or 3 days I could say that. Choice will go first. Yes, we'll have to move the car. He said, Daddy, I have to go move the car.
Juju babes. I don't think you're gonna like a lot of my opinions when we get to the trial time. But that's okay. We'll still be friends regardless. But I have some unpopular opinions, I'm sure.
I don't give a shit where he's at. Brooks, truck's always parked up there, this house, but at this time, most times.
By the way, the did rest today in Brooks and Joey's trials, so closing arguments on Monday.
We don't get along. He never called her over, that's what I'm gonna use. I will work out. I said, I said, I will work out. Okay, you will work out. First, like I said, I did say straight up, man, I would help you with the law. And I did tell him that. He said, look, I'm gonna use the word guide. And me in the direction. Somebody getting something like that. That's a good way to phrase it. I mean, you know, shoes, you gotta move in the direction to get it. Yeah, I had promised that. Yeah, that's what I'm gonna say.
Okay, done. Okay, KSP.
We say, well, exactly how do you need it right? How do we try to get it perfect? I got looked at, I'm like, I send the truck out, so I'm gonna say, hey, man, I mean, they talk to you. I'm pretty sure he said that when I'm not sure about myself. I'm like, yeah, what do you need?
Yes, closing arguments will be Monday because there's no court tomorrow with the holiday.
We not get along, or we bad words, or whatever we call it there. I mean, it's all the same thing. They're not getting along. When, you know, my heart at the end of the day, you know, I hate to chew your old lady and getting along. Because I don't get along with my old lady, so I wish somebody would say that to me. Well, that's not what I mean. What do you mean? Well, Basically, I hate it. How's that? I'm like, okay, well, that's not a good thing. He said, I like to see her. I would like to see her. And that's the way it brings up like to see her. I think it's exactly what it's phrased. You like to see her down, you know, like, now, what do you say? And I'm pretty sure, you know, I think you done have got to me. And that's the way I interpret it, so probably you just say, that he will cover. Then whatever you want to say there.
And going back to the first, obviously, we put some of this in our section of 410. So if we go back to the beginning of the board's meeting, there is no way you excise that out without an incriminating gross out, because they're going to have a witness that came forward in October who says she saw Steve Lawson get out of that vehicle, and that's why that was so important to them to try to corroborate that. And you see the progression all the way through. So in a joint trial, set aside the 410 issues. That stuff directly implicates Brooks Houck, and he is narrowed to the only person in the world.
Yep.
So this decision shouldn't hinge on what Joey and Steve Lawson choose to do with their 410 privileges. We are a case where we are unduly prejudiced by being in the same trial with these people. And that's why I wanted to show all these clips from just these 2 points. You have a multitude of other points there. And you can go through and listen, as I said, to the countless times where it kind of the goalposts will change.
No electronics are
For the
allowed
June 8th
in
interview, you know,
the trial.
you're almost there. You're going to go home. He does go home. And then you get to the next point. We got to get the next point right. We got to get to the next point right. We got to get the next point right.
That's why
Try
it's
to fit
taken
this
so
all
long to
together.
put Steve's trial together.
Yeah,
Because you
I
had to
can't say
get
it
everyone's
enough.
notes to
None
like
of this is
a complete
against Brooks. So
trial.
all of this is a
Annoying.
joint trial. All of this stuff is dumped into this trial under some sort of theory that's somehow a limiting instruction, saying don't consider 2 full days of trial, 3 full days of trial, 1 full day of trial, ever how long it takes, probably 2 full days of trial. Don't consider any of that as it relates to Brooks, but that's all we're talking about. And that, there's no way that's not unduly prejudicial. It's also, we would have to, under due process, under 410, be allowed to get into that in a joint trial. And then there's the question of Joey Lawson. We've spent most of our briefs, most of the government's briefs, and our discussions have been about Steve Lawson. In their brief, Joey Lawson, the government said they concede that his statements made to the FBI and his statements made to KSP up to maybe August of 2023 are protected by 410. But there is a statement that they specifically mention in their brief that is not protected by 410, which certainly incriminating things are made. We don't know what their position is going to be. Now, if anything comes in from Joey Lawson from that August 2023, or if the court were to join these cases, and Steve Lawson's statements are coming in, how can we not be allowed to play this, which you would have a protection for? Go ahead.
All right. You're in 2 separate cars in this setup. You rode there again.
Oh.
You're in 2 separate cars.
I'm so glad we decided to watch this.
One of them is as far as Steve's operating, and one of them is Crystal Roberts' car. Okay? I don't want you to think that this makes guilt or anything like that, okay? I really am trying to, I hope you can see this thing. Yeah. Okay, and I hope you can see that I'm on this. Okay, all right. Then, Steve, you call Steve a little bit. Steve goes and gets his phone back from Denver, okay? Him and Tammy are doing him and Tammy thing. Because they're arguing, she thinks he's cheating, there's shit going on with the price for 300. Same shit that always goes on in Steve's life at that time. Okay? So the same shit that's going on in Steve has to go get his phone. If it happens a little bit later, you call Steve. Okay? I don't know who did what or what would happen, okay, or who asked who to do what, or what stupid situations people get into. And I'm not concerned because I'm not after you, okay? And I'm not concerned because I'm not after Steve, okay? All right? So let's get that straight right now, okay? So at that time, you call Steve. Whatever, Steve doesn't answer. So call Tammy. Steve then calls you back. Steve calls Brooks then. Tells him the job's done. Okay? Steve goes on the parkway at that point. Okay? Steve goes to the turnaround. It's raining. He goes to the turnaround. Right past where her car was parked on the parkway. 14-mile marker. It's going toward Hardin County from Bardstown. Okay? Steve. Yes. It's going toward Hardin County, okay? So Steve goes past her car. He comes back up the turnaround. Okay? He goes back up the turnaround. He parks. Going back toward Bardstown. Her car's on that side. Her car's on the other side going toward Hardin County. Okay? Her car's on the other side going toward Hardin County.
We didn't put it all on there. You have, of course, the entire interview. And he literally just tells him what to say. You can hear Joey Lawson say, asking questions to make sure he's getting it right. You'll hear in this interview, Joey Lawson saying things to the detective like, what do you mean? Do you need me to say Steve did it? I don't know what Steve did, but if you need me to say, that's fine. I'll take your offer. I'm not trying to go to jail or prison. What am I supposed to tell you? That Steve moved the car? Question. I just want to tell you all what you want to hear. In this August 28th interview, the one that the government doesn't concede is inadmissible, the detective literally says on a recording, whether you killed her or not wouldn't be our concern. Again, as it relates to 410, we don't know what their position is. But we're clearly allowed, if anything he says comes in, to get into that. But more importantly, and this is where it all dovetails, it's back to the point of we shouldn't even have to get to the 410 argument here. If Steve Lawson's, let's say Steve Lawson waives his 410 privilege pursuant to the court's order. Let's say Joey Lawson doesn't. How on earth could we not get that in? As it relates to Brooks Houck's due process rights to show how law enforcement coach these statements. You can't coach someone more than that. He literally starts with the government's theory and ends with the government's theory, and the only breaks in there is Joey Lawson asking a couple of questions to make sure he's going to get it right when he regurgitates it. It's incredible. I wouldn't believe it if it wasn't on the tape. But that's what happened. At one point on that tape, in that interview, you could hear the detective say, I haven't fed him that yet, in a side conversation relating to a different fact. Go back and listen to it. If there's ever a case that shouldn't be joined, it's this one. Cross-examination directed toward revealing possible biases, prejudices, or alternative motives is a proper and important function of the Constitution protected right to cross-examination. Paragraph 104 says everyone has the right of a party to introduce before the jury evidence relevant to the weight of credibility, including evidence of bias and
See, okay, but this is the problem, and so, we have, brother, I got you, okay? You're not gonna tell me how to do this. Okay, got you. Okay? But this is common, okay. Put yourself in mind, this is common sense, so that's what I'm calling it. Okay. I'm just remember, we need the specifics and the truth. Okay? I mean, we have that. This is part of it. Okay. All right. This is part of it. It's part of your, what you want. This is part of it. I want you to do a good life, man. I don't want to burn you. I don't want to.
It's just in different clothes, but he's still wearing the same shirt on a different day.
So I don't have to do that, you in the back.
Okay.
We have to have the truth of this conversation. Honestly, I don't know if you would be or not, tell me. I don't know.
Nice. I hope you're enjoying your pool time. It's going to be a long one today. I did say that at the beginning.
In the course of this interview, and I didn't timestamp it for each one.
That is true waiting, right?
Steve Lawson says, I'm trying to figure out what you want me to say. The detective on the right is saying, this is your life. You and your wife's freedom is in your hands. When he's answering questions, Lawson is saying things like, is that not what you all want to hear? Is that what you want to hear? I hope it is. I hope I made you happy. Does that make you happy? And on and on and on. But I put it in this clip.
You recall that day, and it was clear at that stage. And he told me to call the next day person. Did we not do this? So here we sit, you know? I mean, okay. I'm so here we sit. So what? We have to be told. You know what that conversation was? Like, look, Joey's, I don't know if it was Joey's friend enough. I'm here. What it is, that Joey's asked you to tell him, or whatever you're in the middle of, but there is going to come a problem. But we have to know what that conversation really is. I'm telling you, the conversation, and you ain't crazy, but I know this was some conversation that I had to be. Phone calls, 30 seconds. Okay. Okay. That I needed to read. Whatever the hell. No, this is already there. I was already in the book. What do you want to do that? That was not that conversation. I'm saying that conversation. I'm saying, I'm following that down. Yes. That conversation. The thing is this, again, we're in the fourth quarter right now. I am. We're sorry. So there may be some more guesses. You're so close. You reaching the completion. You're walk out of this and says, you're close. But without this information, I'm telling you, planes, so when I'm going to get out there, maybe I'll just give it a second, start the plane, start. I
I appreciate your patience. I'm gonna call it. I'm trying to think of exactly everything that I asked.
But
What time is that getting you that if the thing took place, everybody? I am here. Well, we call you for, okay. Right. Then I call her for after that. I did, Joe did, you did, I did.
I know you're wrapped up in this, you're gonna come off this conversation, you still have your deal.
I mean, I trust you, I truly trust you.
It's on this piece of information.
I'm just, y'all have to make them think we're in certain, that what was said, what wasn't said, y'all do that. Thank you, sir. Since about, and she's here about me, my entire. Soon or some kind of stuff. Sure. Sorry. No, it ain't your fault, you didn't make the dog water in a hard place. I'm not really in a hard place, sir. You think I'm in a hard place, but I'm not. Because I'm gonna tell you right now, no, I'm gonna get in trouble again when I say what I'm about to say, but I did give you my word. Yes, sir. My son community said the rest, evidently. Because it's now 2 or 2 minutes more to me for what happened at my house. And somebody come out there and said, I got money for fixing up that damn house out there, but he got brought out of her 401k. Now she's so much for me. I'm trying to. And I'm not sure that's what I said or not. And I'm gonna tell you what I can recall, but that's fair enough. Fair enough. Hey, did I have him? Or did I was done? Now, they don't take long to say that, sir. What did you mean by that? What? I'm I don't want him, but I'm thinking, I said it's the wrong man.
We need to be very careful about this. This is funny that you're allowed to do anything. We got
No, actually,
because you've been asked this before. You know what I'm saying? You have to come up with a reason. So this has been played out like, I don't, how long is it?
I'm thinking that's exactly the way you said it.
What did that mean to you?
I don't know, my son asked me to do something, most of the time I done it.
So
Y'all do college teachers.
Joey asked you to call Steve, or asked you, I'm sorry. Joey asked you to call first.
For sure.
And say what, the job's done?
Or, I got it, or got it, whatever.
It's just as good as he is. Can we think? I mean, specifics is important.
I didn't understand that.
What? To your knowledge, what did you say in that 13-second conversation? This is the words.
Well, I think that's what I was saying.
But not that you said, but what
I'm thinking that's what was said.
So what did you say to Brooks?
And he said he got it. I'm pretty sure that's what I said. When I said he yelled out my tail.
Got what?
I said, that's what I was telling, that's what I'm saying. That's in my memory, that he got this.
Now, where I think we're struggling, okay, this is just a small piece, but we just need to clean it up. So, that conversation, Joey calls you, you don't answer, you call him, he doesn't answer, he calls you back, and you guys have a conversation, okay?
Okay.
Right. Joey then, what you're saying is Joey asks you.
That's what now, I'm saying that's just my memory.
You remember to, that's the your memory, that Joey asked you to call Brooks out, is that correct?
When he said how, whatever.
And you know Brooks, right?
Well, I don't even know him like it, but I know him, yes.
So you pick up the phone, you have your phone, and you call Brooks.
Sorry.
And then Brooks answers the phone.
Okay. to your best memory, okay, what were the exact words that Joey asked you to say?
I'm not happy, I think that was it, that I've got the job done.
So the exact words are, he's got the job. And at that point, what do you remember Bruce saying?
I don't.
You get a phone call from Joey, you list the phone call, just like you call him now.
Okay.
What does Joey say?
How you getting? I told you that.
What else?
You told me where it was at.
Was it in the end of the phone call or the other point? Does he say something else that costs him?
Not gonna take long time, no.
When does he say the call? Because around that time, there's a call from you, Brooks.
That's after I get down there.
Yeah.
What do you mean? Had to be, sir.
No.
It had to be.
No.
Now, see, now I'm confused because.
That's bullshit.
No, sir, I'm trying to
I
tell
got
you.
the fucking phone records, okay?
That's fine, sir.
And I got your phone moving, okay?
That's fine, sir.
It's the prosecutor.
You were down there, when you called Brooks, okay?
Where was I then? Cause I'm not trying to get somebody else.
No, man, I'm not, I can't give you the answer.
No, I'm not asking you.
All right, you're not, now listen to what, listen to me, okay? Listen. I can tell you time, okay?
Okay, sir.
All right, I can tell you that Joey called you, there was a missed call.
Okay.
Then you end up talking to Joey, you get off the phone with Joey, you immediately call Brooks.
Okay.
Then at that point, you begin to move,
Okay.
and you go down the blueprints.
Okay. Well, maybe that was the part of the call. I'm sorry, I'm not
Yeah,
sure.
that's why I'm helping you, okay?
Thank you.
But you have, man, this is a significant event, okay?
Yes, sir.
You have played this through your mind thousands of times.
Yeah.
So at this point, you are.
So now there's one interview. We've gone from, this was about an apartment. Then we've gone to, it was the job done. Then we've gone to the car's broken down. In between that, as you go back and look, you'll see constant. This is your life. This is your life. You gotta get your deal. We can send you home tonight. They did send you home tonight. Constantly throughout this thing. And you'll see, and we try to point out different clips, continued suggesting about what the story was going to be. Now, one of the important points I want you to recall from that last clip, because we get into some more of this, where this 1207 call was made is going to be part of the government's argument. We don't believe this call had anything to do with moving Crystal Rogers' car. That said, when he makes that statement, at first, he thinks the call's made. By this time, he's gotten to the point where he's saying, I went to her car. And he's saying the call happened at the car. Well, that's not consistent with what I believe the government is going to present in this case. They're going to argue that that call was made in Bardstown. Watch from that clip where he's corrected that your phone call, we believe, was made in Bardstown, not out on the Bluegrass Parkway.
I'm pretty sure those are on two different dates. That's the thing, sure.
And call Brooks, right? Before you left the house, you called Brooks. Did you?
Yeah, I guess.
Why did you call Brooks?
Yes,
See, you know,
I'm trying to be honest, I'm trying to.
why did you call Brooks? Why did you call Brooks?
Tell him I was gonna get a joke, I guess.
No, yes. Why did you?
That's right, okay, that,
All right.
that,
So why would you call Brooks?
to tell you you're gonna get a joke.
To tell him you're picking up Joe, why would you call Brooks?
I'll be honest, man.
Just be honest, man.
I'm sitting here trying to figure out.
Okay.
Yeah, like you said, why did I call her? I called her because I knew, and I knew. No, don't bring up.
All right, come on, say it. Say it.
I like trying to involve in this mess, of course, you already know that.
I do know that.
Okay. But when you do tell us how they were involved in this mess, that's what's okay.
Like authority, okay. I know there's something very much okay. But I thought he was gonna steal it, and that's fine.
Okay.
You know, I wrote $50, and you know, we. I'm not sure if I told correct.
Nope, we got a different shirt.
You know, is the job done or what the hell else ever, I'm not sure.
He owns 2 shirts.
And I'm just being honest. For that time I was America's motherfucking wreck out there. Doesn't that make any sense to y'all? Therefore, it's done. I've done just that. Maybe he had to tell Brooks that it's done. To make it so, or what the hell ever. I truly ain't got no answer for it. I'm sorry.
Talk about that phone call real quick.
Okay.
You call Bruce.
Okay.
What are the exact words that
It's
you?
certainly interesting and confusing.
Okay. What I just told
And I'm
you.
with you there.
The job is done.
And then what is Bruce's response?
I'm thinking, okay.
No, nothing other than.
No, not fuck you, not none of that crap over. But I mean, I don't know if that's helpful to you, I don't know.
Also, I'm not saying I deserve an Oscar for my role playing of them, but I think I do.
You know, he said that when you was.
That's fine, yeah, that's fine, but I'm telling you.
It was 2 different shirts, but see, there's a skirt and one.
Like I said, I wasn't there. All right.
I mean, if I was a woman, I wouldn't be ashamed to take out after the woman. I mean, that'd be still on the hard feeling.
Throughout this, there are multiple unreported smoke breaks. They taped a couple in June. And you'll even see when we get into one of these, they're clearly talking about this.
There's some point right around there, you call Bruce.
I go Bruce. Maybe I need to, I mean, I'm not, and like, I got Darwin, I got, that's something. I mean, I'm not gonna say that either, because I don't remember calling him, but if I did call him, I'm dead, that's exactly what I put. Now, I know that one time I called him and I told you that I called him.
Was he there?
Actually, I called him at the police station.
To talk about that conversation today.
Now, that was nothing. In the army, like, well, wait a minute, or whatever, he said it, I don't know exactly how he said it.
That conversation was staged.
I remember that, we all know that, I won't admit it to that, or whatever you want to call it.
All right, so someone we call Bruce on their way to say what?
I don't remember, the job done, the vehicle broke down, I don't know, but that's gonna be my guess on either one of them.
We were just talking
Yeah,
about what,
what transpired, how that
or
word.
then later, when did you call Bruce say? Was it shortly after? Was it all the way on the front way or right in the middle? Within that time.
Well, I mean, I don't know, I mean, going up the parkway, but then it ends up getting off the parkway. I mean, I can't say exactly what I did. I was I'm sorry.
It's happening. As you know, with the outside, we weren't really talking about, be specific, talking about not omitting stuff.
I'm not sure exactly what I'll just say, I'm not gonna say it, I'll do the EG, I'll be, I'm not gonna say. That'd be my indirection. Or, whatever you want to pray.
You call it,
That's works.
but you're out of the call.
I can go ahead, but I mean, anyway, he got it out, regardless, whether it's me or Joey, whoever, he got it out.
Well, now that we're going about the phone conversation,
Yes.
and so we're trying to do that, we kind of skip that, we need to get into that.
And I'm gonna go there, and I'll go there.
It's normally after.
Okay.
Okay, go there. Two birds.
On the job, right? Yeah, all day or whatever, I'm not sure exactly, That pretty much the end of that conversation,
Throughout these interviews, talk some about promises that were made by law to Steven Lawson. We've seen a lot of suggestions about what you need to say. There are countless times that Steven Lawson in his interviews said, for example, I put myself on your side of the table. I want to be on your team more than you will ever know. If you will help me out, we will get it right. Boys, I want to be on y'all's team. And on and on and on it goes. At one point, one of the detectives in September even says, we're giving you more than we should. So what this trial becomes, if we do it together, it becomes about hours and hours and hours of Steve Lawson and his inconsistent statements. It becomes hours and hours and hours of us explaining the promises that were made that led him to change his stories. It becomes hours and hours and hours of us pointing out all of the times that Lawson said things like, does that help you? Is that what you want to hear? I want to be on your team. But we loop that back to the very beginning, is none of this is admissible against Brooks Houck. None of it. And it's not admissible against Brooks Houck unless Steve Lawson elects to testify. This case completely changed when they indicted him in December. Now, that's their business. They get to decide who they want to indict. But what happens is, as you can see the progression of these interviews, is he gives them what they want to hear, and they want to hear more because they're going back with other witnesses. Promises are made. He continues to change his stories. And ultimately, in September, as the court is well aware, Brooks is indicted, Joey Lawson is indicted, Steve Lawson is not indicted. Steve Lawson is not indicted until December, when apparently he essentially makes representations about where they might be able to locate this Rogers body. And that turns into a major event, major dig, and of course, it's a lie, and nothing was found. But as the court has said, he is untruthful beyond a reasonable doubt. There's no way that any defense of Brooks Houck can proceed without getting into all of that. And coming back to one of the points I said, because I think it's really powerful if someone points it out to you. Watch his reactions during these times. He's making this up. He is genuinely surprised. You can see him taking time to think and trying to make sure he is saying what he needs to say to go on. Now, the government may have a different spin to that. I'm sure they would stand up and they would say, oh, people lie and it takes a long time to get the truth out of people. But if you watch that, an objective person is going to believe he's making this up. And to defend him, you gotta have to show that. It's not just the typical cross-examination. Did you say the car was red today? Yes, but last time you said it was purple? No. That really is powerful. Go ahead if you can get to the next one. Second point we wanted to illustrate in the in-court presentation portion of this, and again, the other points are in the exhibit we gave you, was did Brooks Houck, in September of 2023, Brooks Houck, according to Steve Lawson, says, I want Ms. Rogers gone. Going back to 2020, an FBI confidential informant secretly taped Steve Lawson. Lawson says in that secret recording, I swear I don't think Brooks had anything to do with it. In a second recording with this confidential informant in 2020, Steve Lawson said, I don't think Brooks had anything to do with it. Next slide.
Did I miss anything new and juicy? Sorry, I was on tick duty, which there was a tick today. So I saved Elfie's life. He owes me forever now.
There was a point we got out of this, right? Okay. And I mean, are you sure about this? Sure. Okay. I know you're trying to, but I don't remember you testing. And then he asked you what you were talking to us about. I don't remember. She asked you what you were talking to us about. Okay. She says, you say, I have to take care of a woman with 5 kids who's cooked on them. Okay, and Brooks lying and let you to believe and lies. You know what I'm saying? What's going on? You know what I'm saying? Because if you think, like, okay, I'm helping because the kids are better.
I understand what you're.
You know what I'm saying?
You're going for. Now, if somebody don't know, that you're better off being without.
Yeah, so you're just a powerful.
Yeah.
But I want to make sure that we're all in here and we're so.
Well, I'm trying to think, you know,
This is really important. Very important. Because one grade is very common. Grade has 2 kids. This is a woman with 5 kids, and this was reported.
I'm a crazy person.
And like 7, 4 children. I can't believe it.
I don't want to raise that.
But, you know, but this.
No, I've seen
This is where you're crossroads. Right, so this is where you're turning out.
Well, I'm trying to think, I said, everybody, you know what they say, is that.
No, correct, I'm gonna say so true, but no, what,
You don't want to minimize it, but you don't want to say, yeah, I said this, if I didn't say anything.
That's right, you're exactly right.
You know, then that is.
Correct, but remember,
Yes.
remember, we know more than what.
Stop for a second.
Let's ask it.
How could you possibly defend this case without showing that clip? You can see on his face, he doesn't have any idea what they're talking about. And they can make a different argument, but I believe any objective person watching that, he clearly has no idea what they're talking about. And then they know better than this. They say it in their interviews. We're not supposed to feed you stuff. They know better than this. My guess is there's so much pressure to solve the case. They want to solve it so bad, and never mind, they're doing the right thing. But what they did is not right. And they're telling him what he's supposed to say. And you can see he's getting at him like, there's no way to defend Brooks Houck without showing that clip. And again, we're showing the clip to defend him from something that's not even supposed to be admitted against him. There's no way that's fair. That is beyond unduly prejudicial. Go ahead, please.
Be straight up, you have to go.
I'm trying to remember if I did say that. And maybe you remember this conversation going in the location? But that is for me and you.
Next, please. Another point is that Brooks told Steve Lawson while they were talking in his work truck that he
I don't know why it
Crystal
jumps like
gone.
that.
Obviously, very incriminating statement if taken on its at face value. The alleged movements of Steve and Joey on the night of July 3rd is another point that's discussed in Steve Lawson's grand jury testimony. The purpose of a 12:07 a.m. call was for Steve Lawson to tell Brooks that the car had been moved. This court is aware at 12:07 a.m. Steve Lawson called Brooks' house on the morning of July.
No, you have bad weather, Amos?
Brooks told Steve to say that the 12:07 a.m. call was about rental property. And finally, from our perspective, the main points of Mr. Lawson's September grand jury testimony. As Brooks promised Steve all future drywall jobs in exchange for moving Miss Rogers' car. Go ahead. A confession by one co-defendant in a joint trial poses a substantial risk for the other co-defendants, notwithstanding a limiting instruction. Such limiting instructions call for a mental gymnastics which is beyond not only the jury's powers but anybody else's. We gave details about this Taylor case in our brief. As the court is aware, anytime the court has a joint trial and a co-defendant's confession or statement is being admitted, the court seeks, if possible, to redact the statement, and the court issues a limiting instruction to the jury, telling the jury, for example, in my hypothetical, you can't use Mr. Butler's statement against Mr. Shoring, you can't use Mr. Shoring's statement against Mr. Butler. Co-defendant confessions are so prejudicial that limiting instructions often don't work. Richardson versus Marks, there's overwhelming probability of jurors' inability to follow instructions to disregard a co-defendant's confessions. I thought this was an interesting point, and it was in the Commonwealth's brief. So in the Commonwealth's brief to the court, and Ms. Young mentioned this, I believe her assumption was that we were arguing that even in a separate trial, that we would want to get into Steve or Joey Lawson's statements to police to show that the police were myopically focused on Brooks Houck. That's not our position. We don't believe that we should be in a joint trial with them. We don't believe anything they say should come into a separate trial with Brooks Houck. In her brief, or the Commonwealth's brief, they're addressing not exactly what my point is here, what they're addressing is, if we had a trial, a joint trial, and Steve Lawson is present in that joint trial, and
I don't
his
even buy the
statements are protected
drywall
by 410,
story.
the statements to the police. But yet we were getting into those statements to show this bias by law enforcement to get Brooks, to convict Brooks Houck. Then a limiting instruction by the court telling the jury, you can't use Steve Lawson's 410 statements against him as incriminating evidence, but you can use these statements as it may impact Mr. Houck's presumed defense in that scenario, that this is showing that they're focused solely on him. And so what the Commonwealth correctly said in that scenario is, it's impossible for a jury to follow such an admonition, because it would be impossible for a jury to listen to all these statements and then do this mental gymnastics, like the Taylor case talks about, and say, well, I can use it as it may show that the law enforcement was really focused only on Brooks, but I can't use it because it's incriminating against Steve Lawson, because there's too much of it. There is, I think I'm right about this, I believe there's over 20 hours of interviews just with Steve Lawson beginning in June of 2023, not to speak of 2 FBI undercover recordings, not to speak to other FBI interviews, not to speak to prior grand jury once or twice. I think he's been to the grand jury 4 times, this young said. I think that's right. It's impossible for any 12 people. I don't think you could get 12 lawyers to sit there and try to figure out, okay, I can use it for this, I can't use it for that. We have that volume of material. And Ms. Young is very smart, and she tried to address this point in her, because this is a huge problem for them. There's really no way to excise Brooks's name from Steve Lawson's statements without implicating Brooks. And Ms. Young said, we won't use the other person. So you change it. Steve was in a work truck and someone told him they wanted Crystal Rogers gone. I don't know how you could do that. So we go back to that, the very first point I made. In this case, there's no way that doesn't incriminate Brooks Houck. It's entirely different than my hypothetical, where I said Steve and I did the robbery, it was his idea and vice versa, where the entire world could be in play here. This whole case focuses on the allegation that he has murdered his significant other. Their entire connection, when I say they, Joey and Steve Lawson, the entire alleged connection between them and Brooks Houck is that they did some work for Brooks Houck. There is no way anyone can excise that statement and do anything but implicate Brooks Houck. And it's, as his counsel in this case, there's no way we can not address that and assume that however cleverly this court tries to redact that statement, that somehow a court's limiting instruction is going to possibly protect him from a statement that connects these dots. And that's why this is, that's why this 20 hours of interviews occurs. Steve Lawson was the connection for the government's case. He was the one that was piecing this together for them. That's why they took, and I'm not criticizing, they're trying to make a case. That's why they took so much time with him and went to extraordinary promises to try to get a statement that connects the dots. There's no way you can excise that out next week. The purpose of the 12:07 a.m. call was for Steve to tell another person the car had been moved. Go ahead to the next one.
So just the title with the number, right? Whatever, yeah, or check contacts, or however you do it, and to see who it is, yeah. 1390. Steven Lawson.
So that's Brooks's interview with Detective Snow of Nelson County Sheriff's Office on July 8, 2015. It is impossible to excise that, knowing they're going to play that, and for it to incriminate anyone with Brooks Houck. There is no, it could be the whole world that he's talking about. There's only one person he's talking about, Brooks Houck.
Fair point.
Next slide, please. And while I don't pretend to know exactly what the government's going to introduce in the case, I feel fairly certain that they will corroborate Mr. Houck's statement with phone records that show there was a 12:07 a.m. July 4th call between Steve Lawson and Brooks Houck. So we have done exactly what Taylor talks about in that case. We have now narrowed it down to there is only one person in the entire world that he is talking about, and it's Brooks Houck. Next slide, please. Again, the reason this was important, Steve and Joey were with another person on a drywall job when another person asked them to move Crystal's car. Again, we're down to exactly what Taylor's talks about. This isn't a typical co-defendant case where it could be someone else, because that really is the standard. Can you do this in a way where you remove the implication that it's another defendant? It really is supposed to be able to remove their very existence. Because otherwise, the Confrontation Clause of the United States is violated. There's no way, given that Steve and Joey Lawson were doing work for Brooks Houck on a drywall job at the time she disappeared, and Crystal Rogers' significant other at the time was Brooks Houck. There's no way to excise that without implicating him. It can't be done. Next slide. Another person told Steve to say that the 12:07 a.m. call was about rental property. Again, there's only one person that Steve Lawson talked to on the phone on 12:07 a.m. on July 4th, and that's Brooks Houck. Can't be taken out of there without implicating Brooks Houck. Another person promised Steve all the future drywalls jobs in exchange for moving Ms. Rogers' car. Again, we're back to the same thing.
I would say did better with the evidence for that than what they got for these guys. All I'm saying.
Allegedly, this moving the car, doing something to her. There's no way that doesn't implicate him. It can't be done. Next slide, please. Once it becomes obvious that names have been pruned from the text, the choice to imply identity is narrow. That's exactly what I'm talking about. We've narrowed in this case, these are the most important points from Steve Lawson's grand jury testimony in September after 20 hours of investigating and interrogating. There's no way to that this could be anybody but Brooks Houck who's incriminated. We've not narrowed the identity. Some have narrowed it down to the only person in the world that he's trying to incriminate is this man. The jury could immediately infer on the evidence of the redacted confession alone that the defendant in this case had likely named the co-defendants. It can't be anybody that Brooks he's talking about. So, while Ms. Young is correct, there is a preference for a joint trial. In this case, there can't be a joint trial and get a fair trial. I really believe that there is a joint trial in this case, and there's a conviction. I believe everyone's going to be back here in 2 years doing it again, because there's no way to do this. And the state of the law is not, thou must have joint trials. That's not the law. The state of the law is, if he's prejudiced, the court shall order separate trials. And this is a different scenario than the vast majority of cases where there is an ability to redact. It doesn't make that identity, the implied identity, extremely narrow, or in this case, only one. Next slide, please. Which is, again, why the Commonwealth said it in a different context about how could you possibly let us play Steve Lawson's 20 hours of interrogation for the purpose of showing a myopic focus on Brooks Houck while not incriminating Steve Lawson with the statements that he's made during this time. It's impossible, even if you gave a limiting instruction. But it's the exact same scenario in our circumstance. How can you possibly play Steve Lawson's grand jury statements, as the court has ruled are admissible against Steve Lawson,
Hello,
and not have that
Alicia.
incriminating Brooks Houck?
Hello.
Regardless of however clever the court may be in trying to excise his name, change it, put other person, put whatever, it can't happen. It's going to incriminate him, which then forces us to try to explain how these statements came about. And here's where it gets particularly impossible from counsel's standpoint. Let's say Steve Lawson decides he wants to waive his 410 protections that the court has found.
Aw, Amos,
Now, let's
giving
say
5
the court
memberships. Thank you,
joins
babe.
this case.
Thank you. Congratulations to all of our
So
new
what's going
members.
to happen
You guys are in for a treat
is
this month, I'll tell you that.
chances of Steve Lawson testifying.
Thank you again, Amos.
It's not my decision.
I love your face.
Likely slim. So we would then be forced, knowing, and I don't think anyone can look at those quotes I just said objectively as a lawyer and say that those two directly incriminate Brooks Houck.
I have a
But
theory
rather than getting to cross-examine Steve
about the
Lawson
motivation behind this, but we'll
about
save it. We'll save
how
it.
those statements develop, because if he doesn't testify, we don't get to confront him. We are forced to try to cross-examine police detectives as to how these things developed. That's not what the Confrontation Clause gives us the right to do, to protect him. That's what we'll have to do, and we'll do the best we can. But that is a direct violation of the Sixth Amendment rights. Because we can't, just as they said in a very similar but different context, no one can rely on that limiting instruction. It's impossible that that jury's going to follow that. Because this isn't a 20-minute statement.
Oh, that's a good question. I
This is
will
20 hours.
let you guys
Just
over the end of the stream. Maybe
state police in the summer of 2023, not to speak of all these other.
we are going to finish all the pretrial stuff today.
things.
Go, for sure.
Judge, you made a finding that all of the discussion of Steve Lawson's interviews after the 50-55 mark on June 8th, 2023 is inadmissible in your order on July 3rd. You made a determination, which I think is really important from counsel's perspective in this case. You determined that the recordings, which was Steve Lawson's interviews and his grand jury testimony, clearly establish that Lawson provided loudly inconsistent information about matters that are material.
That's what a judge
You
said.
found in that order, beyond a reasonable doubt, that he was untruthful. And in fact, your order says, after considering all the above, the court finds beyond a reasonable doubt that Lawson breached his immunity agreement with his untruthfulness about matters that are clearly material to the Commonwealth's investigation and prosecution. So, kind of flipping back before we get right into this 410 stuff. We have what I believe to be, from a government's perspective, they may say something different. This was the most important witness against Brooks Houck. This is a person that they spent days and hours upon hours interrogating. Because I believe in their mind, completely disagree with this, but I believe in their mind, he connects dots to that. So in a joint trial, we would hear, pursuant to the court's ruling, 2 grand jury testimony, 2 grand jury statements by Mr. Lawson. We would hear jail calls that Mr. Lawson made to his mother and I believe maybe his wife or his ex-wife. All of which, as I hopefully meticulously laid out for you, are incredibly incriminating against Brooks, and it can only be against Brooks. And that person, so we would hear the sanitized version of this. The best the government could do with someone who, the one thing I think we all agree on in this today is that he gave wildly inconsistent statements. He has been untruthful beyond a reasonable doubt. And we would be stuck with, because you had the ability, I've had the ability, governments had the ability, they were there to watch this whole train wreck unfold.
You don't have to apologize.
But in a joint trial, the jury would hear the sanitized version. We wouldn't get to cross-examine. I have never in my nearly 30 years of practicing law had a court find beyond a reasonable doubt that a witness is untruthful. That's remarkable. I'm not allowed to ask you questions, but I venture to say that the court has never had to make that finding before. That's incredible. And yet, we would leave this jury with an incredibly false impression in a joint trial. In a joint trial, we have to be able to show a jury how Steve Lawson's statements to law enforcement developed. Prior to June 2023, Steve Lawson said the purpose of his 1207 July 4th call to Brooks Houck was he was trying to get an apartment. And he had been consistent with that for years. And what we've done before we start, please. So I didn't keep us here for literally half your week. We've edited clips. You'll see breaks in between them. You'll see the timestamp at the bottom. So obviously you have all the interviews we've tendered them. You can go back and watch where it is, but we tried to clip the most important points. We've also, and I'm going to refer to some of this, we haven't put every promise made by the government in there. I'm going to reference some of that as we go. But what we've tried to do on each one of these clips is show the court how we went from this 12:07 a.m. call was about renting an apartment to the ultimate incriminating statement that was made in September. But again, and then the number 2 exhibit we have up there, Your Honor, is some of the other points in that slide where we went through the 6, what we believe the government's 6 important points of the September grand jury. We broke them down for you on that exhibit, so we didn't keep everyone here all day going clip by clip through each point. I'm trying to think what we think are the 2 most important points from the government's perspective from that September interview. Hit the clips. Go ahead, sir.
Okay, immediately after that, you call Bruce Allen.
Okay.
Okay. That's.
And I told everybody that I told him I got the job. I'm not talking about the, whatever you call it, the ski stuff.
Stop for a second. Stop for a second, please. Prior to this, Your Honor, as the court probably remembers, Steve Lawson was indicted for tampering with physical evidence. This is the day he was arrested. Prior to us getting into this, he's told, we can give you immunity, as the court is well aware. He's told the goal is not to send him or his son to prison. He's told we're not after you. You benefit us. And for brevity, you can go back and watch it as it develops. And you probably have to do any order for Steve Lawson. Before we even get here, he says, what the hell do you want me to say? What the hell do you want me to say? And how on earth can we defend Brooks Houck against these statements without being able to say he got arrested, he went into custody, and when he was told he could go home, the first thing he says is, what the hell do you want me to say? Because he literally would say anything to go home, and he did go home. Go ahead, say it.
I am telling you right now.
I'm listening to you right now, sir.
You have something that's going on there. Okay?
Okay.
What? That wasn't the conversation we had with Bruce Allen.
What do you mean it wasn't the conversation?
That's not the conversation. Okay? If Joey asked you to call Bruce and tell me something.
Wait a minute, hold on.
Yes. Okay, because this is, listen.
I'm listening to you, sir.
We know, like I said, we are doing your study. The same thing we're gonna do. Okay?
I'll listen to you.
In the course of this interview, again, they're promising him immunity and going home from jail that day. They're promising his son immunity to him. They have also arrested his wife at the time. They're telling him that she can go home. There is absent physical force. There is no more coercive tactics that you can use than that. Now, that's just a fact. The jury can draw a conclusion about what the motivation was for the officers to do that, whether they believe they were doing the right thing to try to solve a crime, or whether they were under so much pressure that they felt they had to solve a crime. I'm not them. But that's all on tape. And Brooks Houck didn't create that. That's how this stuff develops. And for him not to be able to get into that completely violates his due process and his confrontation clause rights. But to go back before we get to the next clip, none of this stuff should come into a trial of Brooks Houck. None of it. None of this stuff comes in if he is by himself. We're not talking about what Steve Lawson said in September. We're not talking about jail calls that Steve Lawson made. We're not talking about what the detectives are promising. We're not talking about the detectives putting words in his mouth, because it doesn't matter. But we are doing all of this in a joint trial because there's no way that we can let that September stuff come in. There's no way we can let those jail calls come in without diving in literally to all of it. And it's not, this is, and I want you to want to point this out because you just saw it. It took me a while watching this to really pick up on it. This isn't just going to have to be us trying to cross-examine one or both of these detectives about his changing stories. We got to play this. Because you can see in his face, he doesn't know the answers. He is making this stuff up. And he's looking to them, and over time, they are feeding him this stuff. And they catch themselves even. They know they're not supposed to do that. It's countless times that they say, we can't give you all the answers. Then they turn around and give him the answers. But you can see it in his face and his reactions. But next.
Joey is out on the carpet by her car, or her car, somewhere in that vicinity, right there. Okay, in front of it, okay. Okay. He's out. Okay, he calls you, you call him back, calls you. You call the man who was last with her, right then. Do you?
Prejudice. Everything in these interviews, from the promises of immunity to the this is your life, this is your, we're giving the same offer to your son, we're giving the same offer to your dad, we're giving the offer to the wife, you can go home tonight if you just got to say this. All of that is about, Davis versus Alaska is just about the fact that you could introduce the fact someone was on probation because they might want to curry favor with the government. And that's somewhat speculative because there was no direct promise. And here, there are direct promises over and over and over again. So there's the carrot, and then right after the detectives are there with the state, you're going to go to prison for 20 years. You're going to go, this is the rest of your life. Your family's going to go to prison. All of this is admissible to show their interest and bias, except, again, to come back to the point, none of this is admissible against Brooks Houck. Because we're just going to operate under this fantasy that simply saying, don't consider any of this against Brooks, it's not admissible against him, is somehow going to protect his confrontation clause rights. It is a fantasy. Next slide, please. Which brings us to the third point. KRE 403, a joint trial confuses the issues about whom the evidence is admissible against. It needlessly lengthens Brooks' trial and denies him due process. Just think about, I've been talking maybe an hour and a half, and I have just given you short clips from different parts of these interviews. You have a document that breaks into some of these clips of some of these other points, because I didn't want to take up your entire day and the government's entire day. We're talking about.
Oh, I took up everybody's day today.
Over days. And then if you had Joey, you're talking about probably 30 hours of this stuff. Just to demonstrate their interest and bias to combat the fact that we all know it's a fantasy that people aren't going to use that against Brooks Houck. And we have to explain how these statements come about. That, if there's ever a confusion of the issues, that's it. So. At the end of the day, due process mandates a separate trial, and it really shouldn't rely on whether Steve Lawson wants to waive his evidentiary privileges and Joey Lawson wants to waive their evidentiary privileges, or one or the other. When one says yes, one says no. What happens if one of them changes their defense strategy later, gets new lawyers? Who knows? We don't even need to get there, because this is a case that is, and I believe I have firmly demonstrated that it is unduly prejudicial to Brooks Houck to join these people regardless of this 410 issue. But the 410 issue guarantees this case cannot be tried together. Thank you, sir.
Michelle?
Also, yes, both she is prosecutor Young, and then we also have prosecutor,
Judge, I
special
thought
prosecutor
that
Shane Young, which I think is interesting.
explain their position in this, that I would understand what they were trying to argue, and if right now it's about as clear as mud to me. I have already told the court, and I explained before we started,
Teresa
no
Young.
intention of using grand jury testimony from Steve Lawson against Brooks Houck. I can't use things that Steve said about Brooks against Brooks. That's testimonial evidence, and I know what Samia says, but I'm not gonna try to redact that in order to get that in a joint trial. So that part makes no sense to me. What else makes no sense to me is the 410 part. That makes no sense at all. Joint trial, I can't use it at all. Doesn't come in at all. Can't use it in any way, shape, or form. Guess what? In a separate trial, I can't use it either because it's testimonial evidence. How would I utilize that? So I don't understand this argument that I've got to be able to show how that developed when it's not even coming in a trial. Doesn't matter what kind of trial we have. It's not coming in unless they want to waive it. And if they waive their privilege under 410, then it's Kate bar the door and we can all talk about everything. We can get into every bit of it. And they can waive it standing up in an opening and say, hey, my client was forced to go and say this or had to say this or whatever they want to bring up, and we're all there and we can get into it. But it makes no sense to me why you need a separate trial in order to explain statements that are not coming in against your client. They simply are not going to be utilized. So I guess I don't understand that. I also would like to clarify that on the August 22nd interview and the September 12th interview, Steve Lawson's attorney was present. And part of those big long breaks you see is Steve consulting with his attorney. So I assume if we're going to talk about all the breaks and smoke breaks and stuff, we'll have to bring in other witnesses and talk about what's going on. And that Mr. Lavit's consulting with his client during part of this, and that's why these breaks go on forever. The June breaks are taped because Lawson's in custody. So they taped everything. But after that, he's free to come and go as he pleases. If he wants to go out in the parking lot and smoke a cigarette, that's his choice. One thing I do think that we need to address while we're here, well, there's more than that, but one thing that I do think we need to address is this idea that every statement that Steve and Joseph Lawson ever made cannot come in a separate trial against Brooks Houck. Out-of-court statements play by a whole different set of rules than testimonial statements. They are not the same as testimonial statements. And these two made plenty of out-of-court statements that incriminate them. That's part of the reason Steve Lawson's getting interviewed that day. It's because he's already told people, I got paid $50,000 to move Christopher Rogers' car. He's already in it. So those statements can come in a separate trial. And I'm going to let, or in a joint trial. It does not matter because those statements, which are made by a co-conspirator, where they're either admitting their own penal conduct, it's a statement against interest, or they talk about a statement in furtherance of conspiracy, as long as it is something that meets a hearsay exception, is going to come in. And if we weren't really thinking we were going to talk about this today, but I think we've gotten there. So if Mr. Lasowski could address that for just a minute, because it goes to the phone calls that they're addressing later, the phone calls at the jail that Steve Lawson makes later on that are not in custody.
I'll be brief, Judge. I just followed up on what Ms. Young talked about. As the court knows, for as many years, she's been a judge, a prosecutor herself, in trials as these young men who I've worked with have tried many cases as well.
Yeah. What? I don't know why it's done. Is it still going?
End of this case,
that's weird.
The court permitted conversations that occurred between one of the defendants and an inmate. And in those conversations, that individual not only implicated themselves, but others in the crime. And so the question before the court is, could that evidence, that conversation, which implicated not just one of the defendants, but two of them in the crime, could that come in? One, it's not testimonial, which is what the restrictions that Crawford has put forward. Conversations of this sort are not testimonial. 804B3 under our rules of evidence allows testimony to come in that can implicate not just the person talking, but others that they reference in the crime. If they can show that the conversations they have implicate criminal conduct. And so in that particular case, that person's conversations about their role in the murder and the role others had can come in and implicate and be evidence.
Oh, so we got a jailhouse informant too.
But also the other defendants are referenced.
Cool.
And so other rules that you may have the state of mind exceptions. There are the rules of evidence will come into play in this trial, whether it's jointly, as we are requesting, our severance. There's going to be legal issues and constitutional questions this court will deal with that guide all of our activities, actions, and evidence presented to this particular jury. This, whether we have a joint trial, as we're requesting, or if it's severed, there's going to be evidence directed right at Mr. Brooks from statements of co-defendants in this case. I think that's what the point that I want to make, that some of these statements that they're concerned about are going to come in, I believe, and that you'll properly prepare that for the court with arguments and briefs. But I believe they will come in and will address his role and the roles of the other individuals that are involved in this crime. Thank
you.
Yes, certainly.
Okay. Oh, and we're at a sidebar. Cool. We're almost done with this. He's going back to say some more things.
This is the case Teresa keeps talking about.
Got it.
Which I promise. To be very clear, our position in response to the government is we do not believe under any circumstance that they introduce any portion of either phone calls that Steve Lawson made to his mother, where you have those where he is talking to some extent about some of the things you've heard here today, talking, continuing, we believe, to be hopeful that he's going to get immunity, whether they introduce any portion of these grand juries, the last two, where there are statements that you've seen the end result of. We have, under due process, to get into these other statements. That is unduly prejudicial to us. It confuses the issues, aside from the 410 issue. With the 410 issue, of course, then there's no question that it's a violation of his due process. But it's a violation of his due process because all of this stuff we cannot rely on a limiting instruction. That's what Taylor says. So it's not as simple as simply saying, well, we're not introducing, that's what's not said there. What they're saying is, well, we're not introducing Steve Lawson's statements against Brooks Houck because the court is going to say, hey, jury, don't worry about it. This is not against Brooks Houck, it's against Steve Lawson. But we have to be able to explain how it got there. That's what this is all about. And there's no way we can get a fair trial with these other two, given what I've showed you. With regard to what Mr. Lasowski said, what the law is yes, whether it's a joint trial or a separate trial, and even in a separate trial, we'll have future litigation about any sort of statement made by a co-conspirator. First of all, you'll have to make a determination whether or not there was a conspiracy. And obviously the court has already found beyond a reasonable doubt that Steve Lawson is a liar. So that is a question the court is going to have to answer. First threshold is whether there was ever a conspiracy with these people anyway. Second question that the court would have to answer is, was the statement made in furtherance of a conspiracy? So for example, going back to my hypothetical, if I called Steve right now and said, Steve, we're going to go rob the Fifth Third Bank in Louisville when we get home, that's a statement made in furtherance of that conspiracy. If I'm sitting in the police station after Steve and I got caught robbing the Fifth Third Bank, and I say something about, well, it was Steve's idea to rob the Fifth Third Bank, that is not a furtherance of a conspiracy. So Jim's right. We're going to have to litigate what statements made before any of these police interrogations may or may not have been in furtherance of the conspiracy. But talking about things after the fact to other people are not made in furtherance of the conspiracy. They're just statements. It's statements made to further the ends of that conspiracy. That potentially, if there was a conspiracy, may be this. So they're really separate issues, and one really has nothing to do with the severance issue. Thank you. I appreciate the time.
Counsel, I believe, and I'd like to hear, I guess, from Joseph Lawson still hasn't presented his objection to the consolidation motion. I've heard now from Steve Lawson, and I've heard now from Mr. Houck. I believe we have Joey Lawson set for July 18th.
Yes.
Were they going to address that at that time?
Judge, I think we can. I don't think they want, and I'll have to check. I'll get back tomorrow. I don't think they want to be present. But their motion, I don't want to speak for them, but their motion is mainly premised on redactions. They want to see the redacted statements before they make their mind up on what they will do. But we can address that with July 18th. We get a date, either do it that day or shortly thereafter, and I'll check with them this week and see and get with your author down and figure that out.
I certainly think I should take into consideration what that co-defendant has to say also for making a decision on this. So at this time, then, pending that hearing, the court will get a decision out as soon as it can after I've had that hearing. All right, anything else we need to take up at today's day?
I don't believe so. Judge, I'm going to go ahead, I'm going to send an email out to all the parties. We've had our assistant go back through and compare what we got from various agencies and what went out. And it looks to be either complete or substantially complete. There may be a few little things, like we send stuff out every once in a while that we find. But she's going back through and comparing file to file. But at the end of that, I'm going to ask everybody to come, to set aside some time to come to the office and we go through it. Because I really don't want to end up in a situation where somebody goes, I don't have this. And so we're going to, and it'll be under day. I don't mind the attorneys looking at underacted stuff. So I just want to make sure once we get past the severance joinder issue and we can all start setting down and having them come to the office and just compare with what they got with what we have. Because it's really easy to miss something. And I'm just going to be honest with your audience. And I think the defense can tell you, when you open up a file, there'll be 100 sub-files. When you open up a sub-file, there'll be another 100 sub-files. So it's just, and it was all intermingled in all three Bardstown cases. So we had to go through each of those sub-files, weed out.
Just like all that information.
That would be it.
And the trials
And
of the
if council,
last
when we
week.
get finished, I'd like to talk to you on Chambers a little bit about venue for a little bit
Yes.
today.
Yes, sir.
Okay, so I'd like to talk to you
Very
about
interesting.
All right, that concludes today's hearing. Thank you all.
Take a nap. Okay, so that got us through one of the few hearings that were televised. Now, can you guys tough it out for like maybe an hour and 15 minutes and we can wrap up all of the pretrial stuff. So that way, when we come back, we are just focused on trial things. I think we got it because I just have reading to do. We're going to fly through that pretty quickly. And then we do have one other court video that says tense hearing, but that's only like 22 minutes long. So it's not as long as this one. Year end, Amos is in. Let's party. It's her Thursday night. We're such party animals. We're so cool. Lady in Gray says it's so annoying that this trial wasn't televised. Girl, oh my gosh. I'm so annoyed by it. So annoyed. I think shenanigans are afoot everywhere, to be quite honest. All right. So let's switch over because some wild things are about to happen. Oh, not this one. I like this one. There we go. All right. So that ends July 2024. Now we're into August 2024. August 8th, to be exact. So Steve Lawson, that's Steve there, Daddy Lawson, was in front of Judge Sims for what was supposed to be a hearing about whether he wanted to include or exclude statements he made in 2023 police interviews in his trial. But he raised his hand as the hearing began and said, I need to say something to the court, sir, Lawson said to the judge. Judge Charles Sims responded, what is it you're wanting to say? And Lawson stood and addressed the judge, quote, it's come to my attention. I'm not trying to knock nobody, but my attorney is not doing his job for me anymore. I can't use his, I don't know what you want to call it, his counsel anymore, sir. Yeah, that's right. Are you saying you want a different attorney? Sims asked. Yes, sir. That's exactly what I'm saying. I'm sorry. I did not make myself clear, Lawson responded. Lawson accused his attorney, Ted Lavit, of providing ineffectual counsel and told the judge he wants a public defender until he figures out what he can afford. And prosecutors responded by saying, quote, they have serious concerns about whether Mr. Lawson has had conflict-free counsel in his representation. That's right. The prosecution's being like, yeah, we don't think this is working out for him. We're actually pretty concerned about his lawyer as well. So prosecutor Teresa Young, who that was the woman that was just in this video here, told the judge that in an August 5th jail phone call, Lawson told his family he had already fired Lavit and that Lavit had a meeting with co-defendant Brooks Houck's attorneys behind his back. Because remember, they're listening in on all the calls. And quote, I was surprised yesterday when Lavit filed a motion in court on Lawson's behalf because I had assumed that he would withdraw from the case, Young said in court. She said there is a peculiarity going back to March between Lawson and Houck regarding the similarity of the language and evidence used in the motions filed on behalf of both defendants. Do you remember? We read those. She also said the motions filed by the attorneys even shared misquotes and paraphrases. She also accused Lavit of being unfamiliar with the motions and reasonings behind them when proved in court. Yes, you remember when I was reading Brooks's motion and we had read Steve Lawson's before where they had, broken down those videos for us and I was reading and I was like, oh, okay, this makes sense. this is what I'm referring to now, is that they were literally verbatim. The one that Lawson's lawyer wrote was shorter than Brooks, but it was verbatim, like a lot. So Young told the judge that she could not think of a scenario where Lawson's attorney would collaborate with Houck's attorney where the interviews are concerned, because Lawson gave law enforcement information about Houck during those interviews. Quote, I don't know what's going on here, but I know that it's something I think the court needs to inquire about. It's disturbing, Young said. I'm not sure Mr. Lawson received conflict-free counsel. I'm not sure that he has had what he is entitled to under the Sixth Amendment. That's right. The prosecution is going up to bat for Steve Lawson. Wild. Okay. While Young called it disturbing and asked for an investigation into Lavit's representation of Lawson, the judge did not address the request for an investigation. Now, it is not atypical for the attorneys of co-defendants to work together, but this is kind of crossing a line when your emotions are literally identical in all of the ways, including the footnotes. Where was I? Lavit told the judge he was unaware of any problems or that Lawson wanted a new attorney. Quote, I've done my best at this point in time without any conflict whatsoever regarding my client, Lavit said. I believe Mr. Lawson has been aware of what I've been doing on his behalf. So the judge ordered the public defender's office to appoint a new attorney for Lawson by August 22. Now, when Lavit first broke on the scene here in December and was saying all the stuff his client did, I was like, yikes, what is happening? But I must say, this is probably honestly one of the best things that happened to Steve, because that guy, I don't know. I thought I don't know. And then he never got an immunity deal written down after letting his client say all this stuff for months. Oof. So much so, even the prosecution was just like, yeah, this isn't good, Your Honor. So on August 22nd, Darren Wolf and Zach Buckler now represent Steven Lawson. I think he kind of has that poly hair from The Sopranos. But anyway, so you have Darren Wolf and Zach Buckler now representing Steven Lawson. Wolf told the court they'll need more time ahead of the scheduled trial set for February 2025. He argued they just got the case almost 48 hours ago and now have to sift through evidence that the Commonwealth's attorneys handed over. Quote, we literally got appointed to this thing, Wolf said. We've been given 2 terabytes of information, which clearly is more than most cases, and the investigation in this case has strung on for an extensive period of time. Quote, I think it would be important to at least put the court on notice that I'm not 100% positive that we are going to be prepared to try the case at the time period this court currently has scheduled for that. And it shouldn't be a surprise to the court. Well, we'll, of course, put anything that we need to in writing and file the appropriate motions, but I don't want to come here today and basically put anybody in an illusion that is just going to continue as originally planned. And Judge Charles Sims said 3 people have been in jail. So it's important to him to have cases handled quickly and efficiently in time. Like, sir, I mean, okay, but like at this point, Houck has only been arrested in jail for a year, which is pretty short comparatively, but okay. Lady, but Your Honor, I know this is late now, but my lawyer isn't smart and stuff. All right. So then September 3rd, federal agents conduct another multi-day search for Crystal Rogers' body based on a recent tip. Now, this search is at least the 9th. Keep that in mind, guys. The 9th that the FBI, Kentucky State Police, or the Louisville Metro Police have conducted since Rogers' disappearance. That is a buttload of searches. A buttload. There should be a buttload of evidence, probably, right? One would think. And by the way, that's the location of all of the FBI searches related to this. So the properties they are searching this time, though, were previously linked to the Houck family. According to Nelson County real estate records, the two properties once belonged to Anna Whitesides, Brooke Houck's grandmother, who owned the land until 2018, and it was owned by another Houck family member before that. But a family unrelated to the Houcks now own the property. The Ballard family said they searched this land with cadaver dogs years ago with a reason to believe a missing part of their case may be traced back there. So October 4th, Steven and Joseph Lawson are back in court. Look how different that guy looked. That was his mug shot. Doesn't even look like that anymore. That's why you stay off the serious drugs, kids. Crazy. So Steve's new legal team discussed how the case will move forward with the motions that have already been filed. His attorneys want to exclude prior interviews with police by their client from his trial. There had been some questions about how these police interviews conducted prior to Lawson's arrest would be used at trial. Previously, Lawson's former attorney wanted them included to show that prosecutors were offering him immunity behind closed doors. However, there was also a separate motion filed by Lawson's attorney that wanted them excluded. Right. So Mr. Lavit is saying we want them included because they promised an immunity, but also we don't want them in here because it makes my client look really bad. So maybe we should get rid of them. So see, there was some wild things going on over there. So Steven's new attorney agreed on the previous decision to exclude certain evidence from the trial, including his grand jury testimony. His attorney also said he still hasn't received his client's full file from his previous attorney, Ted Lavit. Quote, "We've received nothing." All right. Almost a month and a half later, and they've received nothing from Lavit. So then on October 7th, Judge Sims rules that the trials of Brooks Houck and his two co-defendants will be held in Warren County. That's the same place that Brooks's theft trial was held. So it's Bowling Green, Kentucky, in case anybody is not familiar with it, like myself. Now, in his ruling, he wrote that under state law, when moving a trial, the change shall be made to the nearest county to which there is no valid objection. Specifically, the trial will be held at the Warren County Judicial Center in Bowling Green, Kentucky, which is about 2 hours south of Louisville. Then, October 9th, Judge Sims ruled that certain testimony from Steve Lawson will be excluded from trial. Now, October 25th, Steven and Joseph Lawson appear in court for a hearing to keep their trials separate. The hearing began with an update from Steve Lawson's new attorney saying Ted Lavit, his former attorney, has since turned over remaining evidence in the Rogers case. Lavit was accused of not turning everything over at a hearing earlier. Judge Sims then took up the motion from Joseph Lawson's attorneys regarding splitting his trial from the others. Now, last week, Joey's attorneys filed a motion saying it's unlikely he could receive a fair trial unless the trials are separated, particularly due to an overflow of evidence in Houck's case. They also said Joey's trial should be separate from his father's because Steve implicated his son during grand jury testimony last year. The document said Stephen testified his son was closer to Brooks Houck than he was, and Joseph Lawson worked with Brooks Houck frequently. It added, while confessing that he moved Crystal Rogers' car, he further implicates Joseph Lawson by testifying that Joseph did it with him, that he saw a Louisville Slugger baseball bat inside the car, and that the bat belonged to Joseph Lawson. Now, even if Steven Lawson took the stand All right. Joseph Lawson's attorneys argue evidence would be presented to the jury, which would be inadmissible in his father's case. Based on these grand jury statements, Joseph Lawson's attorney said Steve Lawson will have to pursue an antagonistic defense against his own son. Quote, he makes every effort to absolve himself of as much blame as possible and lay the blame on his son, Joey's attorney said. A joint trial between the father-son duo will only result in irreparable prejudice to one of the expense of the other or to both. It's like in Harry Potter. Neither can die where the other lives, or neither can, oh crap, I forgot. Anyway. They argue the bulk of the more than 1 terabytes worth of evidence in Rogers' case is irrelevant to Lawson's case, calling it a gross disparity of evidence between the two men. According to the motion filed, discovery in Rogers' case includes evidence from multiple state and federal law enforcement agencies spanning the last 8 years and contains more than 300 separate folders for different witnesses. His attorneys also argue media coverage of Rogers' disappearance would negatively affect the jury. Judge Sims did not issue a ruling on whether to separate the trials. However, Special Prosecutor Shane Young did file a response to Lawson's motion. Young also told the judge his office needs another 2 weeks to finish reviewing discovery turned over by the FBI and the U.S. Attorney's Office. He said after the indictment in October, the U.S. Attorney's Office found additional discovery and gave it to prosecutors on a 10 terabyte hard drive. Young said the files had different names than what's already been sent, but the majority of the discovery has already been turned over. However, some of the evidence is new. Quote, it's been very tedious, Young said. We were advised that we had everything when we indicted the case, and subsequently, I think they went back and looked, and some stuff had been filed in an unusual place on wherever their server is. So we're just going to go through and make sure that everything lines up. He told the judge he didn't expect there to be any more discovery, quote, unless somebody finds something. Young also added that not much had come out of the recent search in Bardstown either. Now, I just want us all to keep this in mind, okay? They have everything that the FBI found, did, talked to, all right? They have all of the FBI stuff. They have all of, who's the other? All of Kentucky State Police. They have literally, as they said, terabytes of discovery. And it's federal government here is stepping in, right? They have the tools to get people. Oh, the IRS agents were there. Okay. So you would think that they would probably use what they found, right? You would think. And just saying, keep that in mind later, because that is all I thought about constantly is, all right, so all these other people were involved, or agencies, I mean. Why is everything so short? Why is everything so weird? Just saying. So, November 5th, Judge Charles Sims rules that Steven Lawson will be tried separately from his son. That's right. That's why we went through all that long stuff, you guys. Joseph Lawson and Brooks Houck will be tried together. Any testimonies mentioning another defendant will be redacted to other person. Yeah, they're still going with the other person redactions somehow. Right? The government has all the power. So the ruling stems from what the judge called Stephen's wildly inconsistent and ever-evolving testimonies of what occurred leading to Rogers' disappearance. In his ruling, Sims said grand jury testimony from Steven Lawson that prosecutors want to use as evidence could create an undue prejudice against Houck and Joseph Lawson. Quote, as a result, this court has no choice but to sever Steve's trial from his co-defendants, he wrote. If they were tried all together, Sims argued, and convictions resulted, they could be reversed because of that evidence. So see, the judge did agree with him that, like, ooh, yeah, this is murky territory. Now, lawyers for Houck and Joseph Lawson had filed motions for separate trials for their clients. Houck's attorneys argued 2 interviews from Joseph Lawson could create an unfair prejudice. Sims, however, ruled the contents of the interviews are irrelevant at trial. Okay. I don't need to know now that we're having problems streaming on Facebook, but okay. Weird to pop up now. Okay, where was it? Okay. Attorneys for Joseph Lawson said being tried with Houck would create an unfair prejudice against their client, which I do agree with, citing the negative media attention surrounding Houck in Nelson County. Statements from Houck that could be used in the trial and prejudicial spillover from evidence admitted against Houck that couldn't be used if his trial was separated. Sims said he believed both Houck and Joseph Lawson would receive an impartial trial in Warren County. Further, he said that Houck's statements never implicated Joseph Lawson of any criminal wrongdoing, and that he failed to identify specifically the alleged spillover evidence. Quote, "This court is unable to find any undue prejudice," Sims wrote. Oh, no, actually, the streams, I keep meaning to tell you, Amos, but for some reason, Facebook, they just keep not linking. Like the last couple times I've been on, I keep forgetting to mention it, but just to let you know. All right, so November 12th. It's some behind the scenes conversation during our live. All right, November 12th. The trial set for Steve Lawson on February 11th, 2025. And trial for Joseph Lawson and Houck's will be June 24th, 2025. Also, in November 19th, is the 8-year anniversary of Tommy Ballard's murder. Now that wraps up all of 2024. Now, good thing with 2025, we only have a couple months before we hit trials. So stick with us here. All right, so January 2025, that's right, this year, guys. Steve Lawson, one of the 3 men charged in connection with the disappearance of Crystal Rogers, is asking for his jury trial to be pushed back from its current February date. The judge previously ruled that Lawson would be able to be tried separately from the other 2 men charged in the case. In the motion, Steve Lawson's attorneys argued that Lawson would not get a fair trial if it was held as soon as February. They cited the volume of evidence in the case and the fact that they took the case over less than 6 months ago after the dismissal of Lawson's prior attorney. Fair. I mean, hell, they didn't even get the attorney stuff until like October, like the end of October. A motion filed in the Nelson Circuit Court said Darren Wolf, who represents Steve Lawson, previously expressed concern with the trial's scheduled date of February 11th. However, he didn't want to show bad faith and request to delay it. Wolf and Zach Buckler have represented Lawson since August after he fired his previous lawyer, Ted Lavit. Now, Wolf and Buckler argue in the motion there is still a substantial amount of evidence they need to review with Lawson, including the entirety of a 10 terabyte external drive from the federal government. They say delaying the trial will ensure Lawson will receive a full and fair defense in anticipation of trial, as opposed to its current date. Now, January 9th, Judge Sims approves motion to delay Steve Lawson's trial. New trial date now set for May 27th, 2025, due to amount of evidence review. So they got like a whole, 4 months, 3 months, I guess. So January 21st, a court document filed in Nelson Circuit Court read that the family of Crystal Rogers hereby invoke their right to a trial without unreasonable delay. Now, by the way, you're like, hey, we haven't heard anything from Sherry in that entire last year. Obviously, because of the arrest and the trial, they obviously told all the family to be like, ooh, let's keep a lid on it, you know. So that's why I didn't have any stuff really about any of them. So the Constitution states that the victim's rights, quote, shall be respected and protected by law in a manner no less vigorous than the protection afforded to the accused. So the document noted that the Commonwealth requests the trial of Steven Eugene Lawson to proceed on May 27th. So like that rule is like, right, like you have a right to a speedy trial. And for Kentucky, the victims and families also have the equal right of a speedy trial as well. So that's, excuse me, that's what that's about. Is this live? I mean, I'm live, but we're not watching like a live trial right now or anything. But hi, Meowsers. I like your name. That's fun. Love that. All right. So February 21st, you remember that the Houck's family got away with secretly recording their grand jury testimony. Remember that they recorded like 8 years ago, and the statute of limitations was only a year? Well, Sherry Ballard sure didn't. No, she did not. Quote, it blows my mind that they can break the law and there's nothing anyone can do about it. I'm not okay with that, Ballard said. So in late 2024, Sherry started getting in touch with lawmakers to amend the Kentucky law. Quote, Sherry contacted me about the current law. I looked into it and saw a discrepancy. I filed a new bill to fix that in the justice system. Republican State Rep Candy Massaroni said, oh, that's a fun last name. Massaroni filed House Bill 623 this week. The bill would extend the statute of limitation to 10 years. It also specifies the charge will be a Class A misdemeanor unless the offender is a public servant, such as a police officer, in which case it isn't upgraded to a Class F felony. Quote, as a Nelson County resident, we've all seen what the Ballard family has gone through, and Lord forbid there's another family in that situation. I don't want them to go through the same situation under this same system, Massaroni explained. Sherry Ballard knows this won't change anything for her case, but said the work is still worth it if it helps other families. Quote, it's too late for me, but if another family doesn't have to go through what I have, it's more than worth it, she said. Oh, I love it. I love her. All right. So February 27th. Hi, Mousers. If the stream is 8 hours long, she's trying to get her channel going. Support her for trying. I mean, yes, but also I'm trying to get this big chunk of this case out of the way so we can cover the trials that have already happened and will be happening since they weren't televised. So we're here for the long haul today, but I only got a little bit more time left. So yeah, we're doing a huge deep dive into Crystal Rogers. Literally everything from the beginning. I've been doing it for 2 weeks. And after today, we will cover the full trial of Steven Lawson and then the trial of Brooks, Houck, and Joey Lawson. Neither one of those were televised. So I'm compiling all the news info and we're just going to cover the trial that way. So join us again if you want to know how this is going. All right, so February 27th is a status hearing for Steven Lawson. So during the hearing, Judge Sims stressed the importance of staying on schedule for Steve Lawson's May trial date. Well, him and Bev have something in common. Quote, I'm trying every which way I can to get this case to a conclusion, Sims said. Lawson's attorney, Zach Buckler, cautioned Sims that Steve Lawson is still reviewing the prosecution's discovery materials. Quote, Mr. Lawson, as of August 2024, had not reviewed the 2 terabyte discovery, Buckler said. It appeared it had not been provided at that time, so we certainly have concerns about where Mr. Lawson is as it relates to his appraisal and comprehension of the discovery. I agree. I don't know why he's rushing this thing along. It is kind of wild considering, but to keep Lawson on pace for a May trial, Sims offered Lawson space at the Nelson County Circuit Court to review any necessary materials leading up to trial. Quote, I can have him brought up here to the courthouse and we can make things available where he can review whatever he needs to every day between now and the trial date, if that's what it takes to be ready, Sims said. I have never heard of them busing an inmate in to go over evidence every day. That's wild. The judge and attorneys also discussed keeping pretrial conferences in Nelson County before his trial in Bowling Green. Quote, for the defendant's family, for the victim's family, for everyone involved, it makes more sense to do everything here if you all can agree on that. Now, March 2025. March 26th. This is where things get a little spicy. All right, March 26th. A court order is issued for 2 hairs collected from Roger's vehicle after she was reported missing will get tested for DNA as part of Brooks' Houck's trial. The 2 hairs were recovered through tape lifting and was never initially tested because the process could destroy the samples. The order was signed by all parties, the judge, special prosecutor, and Brian Butler, Houck's attorneys. According to the order, the hairs were identified by the KSP lab in 2016 as suitable for DNA testing, though testing would consume the samples. The samples will be tested by Bode Technologies and the state will cover the cost. The order says this one follows another allowing the FBI to test a totally separate hair sample. So, 2 hairs found in our car that have not been tested in 10 years, pretty much. So, March 27th, the next day, court documents revealed that in 2016, Kentucky State Police found a 3rd hair that appeared to be similar to Roger's inside the trunk of Anna Whiteside's white Buick car. Remember that whole ordeal? That hair was sent for testing and the hair was consumed, but the FBI was unable to develop a DNA profile from it, according to Special Prosecutor Shane Young. He also said that the attorney for Steve Lawson has not agreed to the testing of the hairs. So the prosecution requested a hearing to ask the judge to continue ahead with the testing and that Steve Lawson provide a cheek swab to compare DNA with the hairs. Okay. All right. So guess what we have? We have that hearing video I was talking about. So April 3rd, prosecutor remands, meaning takes back his request to test DNA found in Roger's car. He doesn't want to do it anymore. But now Steve Lawson's attorneys are fighting to have the hairs tested in search of a new suspect. Yeah, what a turnaround, right? In literally a couple weeks, the state is like, hey, we'll test those hairs. Don't you worry about it. And we'll even pay for it. And they're like, you know what? Never mind. Just kidding. We don't want to do it. And now Steve's lawyers are like, but we want to. So this is the last televised anything for these trials. So it's only 22 minutes long. The title says, oh, wait, hold on. I don't even have it up for you guys. I'm sorry. Full tense exchanges at Crystal Rogers murder case hearing for hair DNA testing. So let's watch this. And then we're almost done, you guys. So, all right, let me make this bigger. Are those good for you? We'll make this one bigger too. All right, let's go.
Commonwealth of Kentucky versus Steven Eugene Lawson. It's 23 CR 165.
I have not watched
and
this, by the way.
23 CR 371. Mr. Lawson is present with counsel. Mr. Wolf and Mr. Butler also present on behalf of the Commonwealth or special prosecutors, Mr. and Ms. Young and Mr. Lasowski. I believe there's several matters that are pending on today's date. I believe the first motion that was filed was in regard to DNA testing of 2 hairs. Is that correct?
Yes, sir. May I please report?
Certainly,
Judge, I think I can short circuit this because we're going to remand this motion this time. I'm going to explain to the court why.
Okay.
Initially, when me and Ms. Young and Mr. Lasowski first come across the court order, which come in KSP notes and lab reports, we had not realized there were 2 hairs that hadn't been tested. And I got freaked out by it, to be honest with you. So I hurried up and filed a bunch of stuff before I really sit down and talk to the chemist himself. And we've had a chance to actually talk to the chemist and speak about it. And once we learned the hair's lengths and the colors of the hair, which one hair was approximately 8 inches, the other was approximately 12 inches. And the hair was a brown tan that had been chemically treated, which usually comes along with female, the majority of the time females. That is not.
You don't think I color my hair?
Well, that's why I look like I do. But they're not going to belong to either Mr. Lawson or Mr. Lawson's son. We would anticipate Brooks Houck's hair being in the car because he used the car. So we're going to go ahead and stipulate that the 2 hairs don't belong to either of the Lawsons. And I don't really want to spend the state's money because of what it was going to cost to have it expedited testing.
Because we've already wasted millions of dollars and got nothing in return for it.
Based on the visual analysis, if they would have had hair samples from them back then, they would have excluded them to begin with on the visual analysis and would not have performed the.
So that takes care of your motion so that motion's remanded. I believe there's a motion on to continue that has been filed by Mr. Lawson. Is that the only other motion pending here today?
It is, Your Honor, but I believe that we would still like to address the DNA motion made by the Commonwealth and ask the court that in our response to construe that as also a motion by the defendant to be afforded the opportunity to have these hairs analyzed, irrespective of whether there's a stipulation that it's Mr. Lawson, our client, or Mr. Joseph Lawson, his co-defendant. These are not hairs that were located at a location that bears little to no nexus to this case. They were located in the alleged victim's automobile, which is a center point of prosecution against our client, certainly. It stands to reason that the hairs may not be either Joseph or Steven Lawson, but regardless of that, if the identities are unveiled to be somebody else who's been identified as a suspect in this case or someone involved in this case, that could fundamentally alter our defense strategy, to be sure.
True.
Moreover, we appreciate and have no reason to doubt the Commonwealth's representations to the court today that they have consulted with a chemist and that they don't believe the hairs to be belonging to either our client or to Mr. Joseph Lawson. But we cannot, in good faith, on behalf of our client, do due diligence by relying on those representations. We would still need to conduct a separate analysis through our own experts, which we've recently retained in light of this litigation. So our request articulated in the response would be the same that we would request from the court today, and that's that we have the opportunity to analyze this. It doesn't sound like it's necessary to have a separate hearing to determine what the appropriate testing method is if the Commonwealth has withdrawn that motion. But certainly we'd like to have an opportunity to inspect the 2 samples, have our expert inspect the 2 samples and determining what type of testing, if any, is feasible, and whether sample consumption is inevitable or not. That's effectively what we requested in the response, short of the adversarial hearing between 2 experts to determine what type of testing would be appropriate. So as it relates to the DNA issue, Judge, I think that is our request on behalf of Mr. Steven Lawson.
Competency response.
Judge, there on one lip there was 43 hairs. And
I'm sorry, on what?
They're on one tape lip. The report. There's hairs. I didn't realize. I guess in my car was probably as many hairs too, living on a farm. But a lot of the hairs were animal hairs. But you go ahead and say they go ahead, we're stipulating it's not them, okay? I mean, that's their defense. So if they want to use it as, there's another person out there that could have done it or whatever, but you don't have anything to test it against. That, you know, so that doesn't make, we're stipulating it, and I'm telling Your Honor, what this is doing, what they're trying to do is delay this trial. They want to go behind Mr. Houck. There's some tactical advantage they figured out, and I think this is done in conjunction with Brooks Houck's attorneys, that they want to go last. Because it benefits, the only person it benefits is Brooks Houck. And we're willing to stipulate to it. The defendant has admitted he was in the car. He's admitted he was in the car in front of his counsel and me. His hairs may have been in the car. I don't know. But what we're saying is these two hairs, we know for a fact they don't belong to them because of the length and the color. And there's no reason at all to delay a case that has been pending for 10 years.
Your Honor, may I briefly respond?
Yes,
I apologize.
Sir,
I mean,
it was
interrupt the court. Judge,
that's not
these
true.
hairs have been in the custody of the state for nearly 10 years. It is not the fault of Mr. Steven Lawson that they're being brought to our attention in March of 2025. If the Commonwealth wishes to speculate that we're co-conspiring with co-defendants counsel, so be it. But ultimately, the case law that we've cited in McGregor v. Hines, which is a Supreme Court case from the Kentucky Supreme Court, our client has a right, be it inculpatory or exculpatory, to test these hairs. He has the right to that independent test. It's an implied right found to be through Kentucky Rule of Criminal Procedure 7.24. They may be immaterial, but we can't speculate on the materiality of evidence that has not been analyzed or subject to forensic analysis. That's the reason we do it. And if we simply say that we'll agree to waive our right to exercise separate analysis of the test, then that ultimately jeopardizes our client's defense strategy. We don't necessarily know who the identity is. And there may not be an identity guilt from it, but that doesn't defeat the fact that he has a right to have these samples tested. And the case law and the rule supports that.
Well, I don't see how you're going to match it up with somebody else if there's nobody to match it up with. That's the problem I see here. I mean, they're telling you, they're admitting that it's not his hair or any co-defendant's hair. So I would certainly give you an opportunity to have your expert look at it. If he wants to present some type of testimony about it, I really don't think it's particularly relevant if they're saying it's not any of the co-defendant's hairs.
Oh, thank you, lady.
And we can arrange for them all.
Just because you're.
If you want to have your expert go look at the hair, certainly talk to Mr. Young and y'all can go and look at the hair. But I don't know what good it's going to do to test when they're telling you that it's not their hairs and you don't have anybody's sample to say we're testing to see if it's this person.
Well, Judge, we don't know if it's not our client's hair. We don't. That's the whole point here. Is we do not know whose hair.
So you want to test it to see if it is his hair, to put him in the car.
With all due respect, Judge, you don't know our defense strategy. So depending on what the results are, that could absolutely change what we are planning on doing from a defense standpoint. And with all due respect to the court, I really do not want to state on the open record in front of anybody, specifically the Commonwealth, what our thoughts are on what our defense is. So I'm going to respectfully decline to answer your question about whether or not I want it to be my client's hair. I'm not going to answer that.
And his client's admitted to being in the car.
Okay. I'm denying the motion for any testing because there's nobody to test it against. They're telling you it's not his hair, so I don't. And apparently, it's not the same color. It's chemically treated. But I'll allow your expert to take a look at the hair if they want to look at it. Okay.
So is it the court's position that the Commonwealth can state on the record that it's not our client's hair, and the court takes that for it not being our client's hair? I mean, that's what I'm
letting you look at the hair, and if you come back and you tell me that the hair is not chemically treated or the hair, something that they're saying is false, I'm allowing you to look at the hair. And if it's a different color or something of that nature, I'm giving you an opportunity to look at the evidence.
Right.
But I'm not going on this fishing expedition of having it tested. We don't have anybody to test it against.
With that said, Judge, I would anticipate after our expert looks at the hair that we would want to do an analysis of that hair. So maybe now's not the right time. And if you tell me it's not because we don't have enough information, perhaps what we need to do is get our expert here and explain to the court what type of testing could be performed and what type of end result you may anticipate depending on those particular results. I'm not a DNA expert, and I know counsel's not a DNA expert, and I sure know the Commonwealth is not a DNA expert. So I think we're taking and making some significant leaps here without any testimony from somebody who has expertise in this particular area.
If you want me to have somebody come from the lab to testify that it wouldn't be their hair and the reason why, I'll be fine doing that. But at this point, I don't see any reason to have this hair tested if they're going to tell you it's not any of the co-defendants.
But I just don't think they have the ability to do that, Judge. They don't know that. Just because Mr.
I said I was going to take testimony on it. I'm willing to give you testimony on it, is what I'm saying.
Okay, very well, Your Honor. I'm uncomfortable with taking the statements that a Commonwealth attorney has spoken to a chemist, and now we are all concluding that the hair is what they say.
If I said I'd give you a hearing on it and let the person testify, I'm not making a finding here today at all, but I take Mr. Young at his word. He's an officer of the court. He's not going to come in here and misrepresent things to us.
No, Judge, what the chemist said was, he told us what the link was. He told us what the color was. He told us it had been chemically treated. We know what color Mr. Lawson's hair was then and what Mr. Joey Lawson's hair was then and the approximate lengths of their hair. It can't be their hair.
Well, like I said, I will have the person show up and take testimony on it.
And Judge, are you, when you say the person, are you referring to the chemist?
The chemist who says it's not their hair.
All right. Well, we would like our expert, of course, to potentially testify as well. So we just need enough time to arrange for him to be here at that particular hearing.
Do we have any other motions today?
And Judge, just so we can be clear, I am trying to struggle here about how to articulate a response to a claim by the Commonwealth's attorney on the open record in front of the media, this court, and everybody else, that he is now determined that there is some conspiracy between the co-defendants to delay the trial. I'm offended by that, Judge, and I'm going to ask the court that in the future, if he doesn't have the ability to back up such statements, those are, to me and my counsel and to my client, those are inflammatory statements. Out of respect to the court process, I didn't get up and object when he made that statement. But I want the court to know, and I want counsel to know, that those don't go unnoticed by us. That was inflammatory, was not appropriate. And in the future, we're going to ask the court to strike that from the record if he ever makes such claims again in the future.
Judge, we've also asked counsel to not file motions at 4 a.m. before the hearing and abide by the court rules.
We would ask the judge that they not find errors on May 25th.
Let me see you to it. Come on.
Uh-oh. They got called to the principal's office.
Judge, give me a second. I need to mute you there.
Okay.
Okay, so they're doing that, and then they're off the record.
Judge. You need to hit the unmute button on the box. Yeah, right there.
Okay, when y'all came to the bench, everything was muted, so people on Zoom can hear what we're doing again. Go ahead. I'm sorry.
All right. Just to confirm where we're at, we're asking the court to set a hearing for a discussion related to whether or not it is relevant and or necessary for the 2 hairs that were found and disclosed by the Commonwealth on March 25th of 2025. And we, at that point in time, anticipate bringing witnesses, or perhaps one witness of our own. And we also anticipate that the Commonwealth will be bringing the chemist. The counsel for the Commonwealth has stated on the record, states X, Y, or Z related to said hairs.
Okay. When can your expert go and view the hair? Was the hair at the
Frankfurt lab?
At the Frankfurt lab. When can your expert go and do that?
I can tell the court that when we get out of here today, we will contact him. There's really no, I don't have his schedule. So
I'll tell you what, why don't you go make a phone call and find out? Because I want something done the next 2 weeks for this hearing. So.
I will attempt to contact him. May I step out, Your Honor?
Yes, certainly. Okay.
Oh, that must be the ghost witness. Spooky. All right, let's fast forward through this. Nothing's happening. Still not bad. Do. Okay, he's coming back now.
Judge, I was informed by his staff that he is out of town until the end of the week, and I have left him a very long, lengthy voicemail asking him to call me back as soon as possible.
Okay, well, if he wants to review the hair, he's got to be available next week, April 7th to the 11th. Arrange a time to go view that hair. Just contact Mr. Young with what time during business hours he wants to go next week. I'm looking at setting the hearing the following week. What about April 14th?
Yes,
I can do morning or afternoon.
Either one's fine. Your Honor, I would just request to be in the morning if it's on April the 14th, because my afternoons.
Sure. 9 a.m. okay?
I'll defer to Mr. Lawson on his schedule for the morning of the 14th, Your Honor.
I'm good.
You're good?
Yeah.
Okay, Judge, I think we're available for the 14th in the morning.
I'll put down that hearing will be at 9 a.m. on April 14th over the haters.
Over the haters.
Anything else we need to take up today?
And just, I don't mind drafting, and then we probably need to go, the lab will probably need to order.
Sure. If you will draft a order that says that that the defense expert has a right to come and view the hairs, and that's to be arranged through a date sometime between the 7th and the 11th during business hours, and they're to contact the experts to contact. You want to be direct to the lab, or do you want to be the in between?
I don't know who the expert is. The lab guy may know him. I don't know who it is. But, they can call me.
Okay. That they contact you to arrange the time for this. Okay, if you'll tender an order that, I'll be glad to sign it. Anything else?
Judge, we have an opportunity to review that as well before it's signed.
Yes, if you'll email it to counsel, and you'll have an opportunity to review it.
Judge, and we also have a motion to continue the jury trial, given that we are going to be having a hearing in the near future. We ask that that motion be passed to that particular day.
I do have one thing. If you sure can, I did call I was concerned about Mr. Lawson not having, because they said they'd asked DPA to buy him a computer, and it hadn't happened yet. So I called the jail, and there is a computer available that Justin, Mr. Hall, or Jailer Hall, says he would make available anytime. But we actually brought a computer. It's a computer at the office. It has nothing on it. We'll give it to him. We just asked for it at the end back. It can stay here. You can come here. You can use the computer.
Well, I tell you what, this guy over here knows about computers.
Yes. So we'll give it to him. So it'll be here anytime they want to use it.
Okay.
So the prosecution's giving them a
I'll show them
computer.
there's a computer available. You all just tell me what days you want him brought up here, and Timmy will set it up in the back, and he can look through the discovery in it.
Yes, and I would, obviously, we would like to see the computer. I just want to make sure that, as you know, there's some security concerns. So I want to confirm that that we do not have any Wi-Fi access, that there's nothing else on the computer. Those are things that I and/or our expert related to.
Do you have the computer here today? Okay, well, why don't y'all view it before you leave then?
Yeah, I'm not qualified to tell you whether or not it's got the meaning. You know this as well as I, Judge. We have other people involved in our team that can tell us whether or not that's an issue. So, but I appreciate the offer. So let's leave it here. Here's my suggestion. Let's leave it here. And before we make arrangements, and I have one of the sheriff's phone numbers here, and I've communicated with him about not wasting anyone's time bringing Mr. Lawson over until there's actually something there for him to look at. How about we just do this? They leave the computer, we come look at it, or have whoever else look at it to determine that it's an appropriate computer to use. And then I will communicate with the sheriff and have Mr. Lawson brought over at the appropriate time. Again, I'm not trying to waste anyone's time.
I guess I don't understand what makes it an appropriate or inappropriate computer.
Ever heard this?
Here.
I haven't even seen the computer, Judge. I don't know if it has the appropriate
If it
things
works
to accept the discovery. I don't know. I don't know if it has any connecting ports on it. I mean, I just don't know.
It's just what we've been using.
I think they got it here if you want to look at it.
Okay.
Judge, it has Adobe on it and it has VLC media player, so they'll be able to view it. As long as they don't hook it to Wi-Fi in the building, I don't know how anyone would have any Wi-Fi access. I don't know the code for the Wi-Fi, so I can't put it on here. So somebody can go in the settings and look and see if it's hooked to the Wi-Fi in the building. Other than that, it won't have any access to anything outside of what he's viewing on the computer.
That was a concern of the courts, of course. So I was just trying to address your concern.
That is a concern. Any contact with people through any type of social media would be a concern.
Yes, sir. So I was trying to be respectful of your thoughts on it.
That certainly would be something he should be having access to. Okay, anything else? Okay, I'll see everybody then April 7th at April 14th at 9 a.m. Mr. Houck, if there's any point you can't hear anything, you let me know. I'll make sure you can hear everything that's happening here today, okay?
Yes, sir. Thank you.
Okay. I believe this is your motion, Mr. Young. I believe we're talking about two reports. One report, Mr. Houck, before you joined us, there's been a report that your attorneys have made a supplemental.
Oh, what is this one? I didn't have this one saved. May 8th. Oh, okay. Hold on. Let me look at my notes. Oh, okay. We could watch that one, I guess, instead of me just reading about it. Do you guys want to watch that one when we get there? We're almost there, but well, I'll let you guys decide. So anyway, though, back to, they then go and have the hearing that they were just scheduling with bringing the hair expert person in, okay? And to try to postpone Steve's May 27th trial date. Now, prosecutor Shane Young argued testing the hair is not relevant to the case, again, not believing it matters who the hairs belong to. Just like Young said in the video we just watched, he also goes ahead and says that he is to blame for the uproar over the untested hairs, telling the judge he freaked out when he found they had not been tested because they may belong to defendants. But Young said he was ignorant of the initial analysis of the hairs and didn't realize they were too long to be either Steve Lawson or his son and co-defendant Joseph Lawson's hair. Now, he said this mistake could cost more than $30,000 for DNA testing that would be meaningless because the Lawsons have admitted being in Crystal's car. I don't know what your guys' opinions are about that, but I disagree. I disagree. All right, you already spent millions and millions of freaking dollars. What if that hair may not belong to, I mean, their whole theory is that this conspiracy went on and she was murdered because they all conspired to do it. What if there is another conspirator? And what if that hair points to another person that might have information, I don't know, helping find Crystal's body? But they don't want to spend the $30,000 to find out, even though they have spent millions and millions of dollars in searches in the last 10 years. Just one of my many rants today. All right, so they end up bringing somebody named Mr. Reed to testify. So Young goes on to say, and this is after the testimony of that person, hairs are readily shed, as the doctor testified. As Mr. Reed testified, they're readily shed. Static electricity, they come in on shoes. The simple fact that someone else's DNA is in the vehicle is not exculpatory, Young said. According to Young, the two hairs were found in the driver's side of Roger's car, were not similar to Roger's hair or similar to Nick Houck's hair. Young stated the hair was several inches long. Okay. So then his attorney, Zach Buckler, that's the younger guy of the two, said Mr. Lawson has a fundamental right through due process to have these hairs tested. Lawson's defense attorney, Zach Buckler, said the fact that these two samples were not tested is not because testing is not feasible. It's because it simply was not done. The fact that it was not done previously does not now deprive Mr. Lawson of the ability to now make a request under these purely legal arguments. Quote, Judge, the victims in this case have a right to go to trial without an unreasonable delay, and that's a constitutional right. And I think when you balance that right against the speculation and this fishing expedition this is going to lead to, they have to triumph in this, Young argued. And I just want to say, all right, Young's whole comment of this has been a 10-year proceeding. No. You just arrested them a little under a year ago. All right. It took you guys 10 years to bring somebody to trial, and you didn't do a very good job, if you ask me. But let's not be like, oh, they've been waiting on you all. That's what they've been waiting on. I'm sorry. I just don't think that this is like a fair trial situation going on here. So April 18th, Steve Lawson's trial will proceed as scheduled after Judge Sims denied his motion to conduct additional DNA testing on 2 hairs found in Crystal Rogers' car. Sims said even if DNA testing revealed the identity of the hairs, it would not have excluded Lawson's alleged involvement in the case. Quote, the court also believes the Commonwealth has records to substantiate these telephone calls and tracking data from their phones to establish that Lawson and his son were in the vicinity of said vehicle, the order said. Now, Sims also argued it is unlikely the hairs had any relation to Rogers' disappearance, given hair is easily shed in day-to-day activities, and additionally, DNA testing would take months to complete. He added he believes Lawson was looking to further delay his trial. I'm going to have to disagree there, but okay. All right. So May 8th is the expert hearing. Let's see. Oh, that's what I have the video for. Did you guys want to watch the video for that? Or I can just, it doesn't seem like a whole lot actually happens. There's no judge ruling now that I'm looking at my notes. We'll just skip that for now. If you want to watch it some other time, we'll watch it, but you probably should kind of wrap this up. All right. So May 8th, there's an expert hearing for Brooks Houck. All right. Special prosecutor Shane Young filed a motion requesting the defense to provide more information on the testimony of the experts they plan to call at trial. The defense plans to call a retired detective to the stand to go over the timeline of the investigation done by Nelson County Sheriff's Office and later the FBI. Defense attorney Brian Butler said the detective won't comment on any missteps the sheriff's office may have taken early on and will instead give a general overview of the investigative process. If that sounds familiar, followers, it's exactly what Karen Reed's defense team tried to get. What was his name? Something Easter, I think was his last name. So, quote, the primary purpose is to talk about this investigation from start to finish and present what they did, how they did it, when they did it, why they looked, and what they found, Butler said. The defense also plans to call an interrogation expert who will review recordings of police interviews with Houck and Lawson and describe tactics used by detectives that could be considered coercive. Oh, Michael Easter. Thank you. I was thinking Nick, and I was like, that's not right. Thank you for the assist. The defense also, oh wait, I already read that one. The MSP needs to hire him now for their new initiative, right? Oh gosh. Ugh. The prosecution asked the judge to require the defense to give more details on the basis for that expert's opinions, including specific examples within those interviews. He is saying threats of prison can lead to false statements. He's saying leniency, promises like you can go home today, that can lead to false statements. He's saying manipulation tactics like you could lose your child if you don't cooperate, Butler said. It's not our obligation then to take the evidence that they provided and do a laundry list of them every time that happened. Quote, if he has an opinion on each and every one of those, he needs to include what the statement is, what his opinion is, and the basis for that opinion, Young said. Young also said he does not plan to call Steven as a witness during the trial for Houck and his son, Joseph Lawson, which is interesting. Now, as I said, the judge did not make a ruling there. Okay, but May 13th, he does make a ruling. One that I am not a fan of. Ooh, there we go. Okay. So, May 13th, Judge Sims ruled no cameras, cell phones, or any recording devices will be allowed in the courtroom, which is unusually restrictive for trials in Kentucky. Sorry about the noise. We're just going to power through. I don't know what Elvafe's doing right now. Just making noises in the kitchen, playing a song, I guess. Quote, unfortunately, this case has generated tremendous interest among the news media and the general public, which has resulted in a circus-like atmosphere, Sims wrote. Okay. Sims said it was the first time in his more than 2 decades on the bench that he has not allowed a camera in the courtroom. So he's never ruled this before. The cameras can, as you saw in his court, there's freaking cameras everywhere. They did televise or stream quite a few hearings, both through the court system, and they allowed one of the 2-hour hearing we watched. That was by local media that had that camera up, and now he's saying it was a circus. Y'all saw the gallery. There's barely anybody in those galleries. What circus are you talking about, sir? Because this was also in Nelson County when that was going on, where they're always protesting and doing stuff with, Sherry Ballard and stuff. Now you're going to be 150 miles away and you're like, oh, I'm just worried about the circus that's going to be happening everywhere, when you specifically chose this place because you didn't think that it would be like that kind of environment. But no cameras, guys. No cameras for the first time, his own words, first time he's ever ruled that. I call shenanigans. I am very, very suspicious of that. Hiding much? I mean, why? Why? There's absolutely no reason. But he gives reasons, I suppose you want to call them that. But so in hearings leading up to the trial, this is what he says. Sims said he has allowed reporters to have phones, and some have violated his rules and live streamed the proceedings. What? Which ones? Because you had a camera in there and your own cameras were on Zoom. And you're telling me somebody had their phone is in court, and they're just doing this, recording everything, and nobody saw that? Like a reporter who's sitting right there to your right? Like, we saw the courtroom. What are you even saying? It's wild. Okay. And he says, but some have violated his rules and live streamed the proceedings. Quote, this court finds that the trial proceeding must be conducted in a dignified manner without the distraction of anyone recording this proceeding with any electronic device, Sims said in his order. Not even Auntie Bev pulled this shenanigan. Like, you think this is going to be freaking Karen Reed chaos? Outsider, get out of here. I mean, yes, this is a very big deal for the state of Kentucky, but like, sir, what are you even saying? Quote, unfortunately, this court believes that it must impose limitations herein to assure a fair trial, Sims ruled. With this order, Sims said he hopes to avoid sequestering the jury during the trial. The judge also prohibited anyone from wearing any clothing, buttons, or pictures of anyone related to the case, which is completely normal. And that right there, that's a completely normal thing to do. But I'm sorry, but his reasons for their not allowing camera when he's always has, right? Because it's one thing if a judge doesn't do that, right? And they're like, I don't want to try this new thing. I don't like it. We're going to be old fashioned. But this judge is not like that. And then all of a sudden, the two biggest cases for that state, the trial, they moved 150 miles away from Bardstown. All those people in Bardstown who spent 10 years with this case aren't going to be able to watch this. All right. They're not going to be able to. Instead, what people are going to have to do is get what happens in trial off of a news source. Okay. And right now, I am putting together from, I don't even know how many, I have like 100. Okay. 100 sources to go through tonight. I've already used 17 different sources to compile what happened in a 4-day trial, because so much is left out by every news station. Okay. And that's not their fault. I'm not knocking them, right? They got to write all this, like archaic in the trial. And you just want your average people to just read one article about what happened and just take that. Because I'll tell you what, you guys are going to see. You guys are going to see when I tell you about Steve's trial, because I had only read a few articles, and same with the one that's going on now. No, you have to read hundreds of them to get the full freaking story that the people could just watch themselves, right? And why? I get that streaming comes with problems. It does, right? People reaching out, crossing lines when they shouldn't. I agree. But why would you not want the public to be educated about what's going on? Why would you not want the public to see to the transparency? Think about how many of us are now into law and all of this because we were able to see trials. I don't like this. I don't like this one bit. All of a sudden, the last minute, the 11th hour, and no cameras. Okay. Okay, sir. Right. I'd say BS on the recording stuff as well. I mean, again, like what? Yeah, exactly. I have literally read every single article on Google month by month for the last 10 years. And not once have I ran across that. Not once. Oh, girl, if you only saw my Google Doc. Lady in Gray says he saw those interrogation tapes. He doesn't want the world to see them. So does hiding shit. My theory is that once people do find out, that's why I want to cover the entire trial of each with all the information I have, because it is my firm belief that the people of Kentucky should be real pissed. We, in my opinion, have another situation going on here where millions of dollars are spent. They rushed bringing somebody to trial. And here's the thing, right? I am on board with this isn't great. But what we're going to talk about in these trials is bananas. Bananas. When you had all these federal agencies involved, what they chose to bring to trial, the Commonwealth, what they chose to bring to trial will blow your guys' mind. You'll be like, wait, was the FBI even involved? Like, what are we even doing here? It's crazy. And I think that's why the trial isn't streamed. So, anyway, sorry, I've been promising you guys this rant all day because I am very, very upset about it. Because I don't think that's right. Now, May 23rd, media outlets file a motion to request a pool camera be allowed in the courtroom during Steve Lawson's trial, which I do have the document for. It is very often when they deny media to come in, the media will file a motion. And we're going to read that motion. It's only 6 pages. It is going to be quick compared to what all I read earlier. Is there a way I can make this one full screen? I don't think so. What does this do? I'll try to make it. It doesn't have the nice pop out one that the other one had. All right, so this is all of the media companies filing a motion with this judge. All right, the first one, that's just labeling who they all are and why they're mad. So the media petitioners understand the concerns expressed by the court in its May 13th order and are prepared to abide by reasonable restrictions to ensure that court proceedings are not adversely impacted in any way. However, given the enormous and appropriate public interest in this case, media petitioners request that this court modify its order in part to allow them to keep the public informed of these important judicial proceedings, which will increase the public's confidence in the rule of law, knowing that a fair trial was held. That's the only argument you need right there. Right there. People can see it with their own eyes and know that a fair trial is occurring. That is, if it's even a fair trial. So they file this emergency motion to intervene. Kentucky law is clear. The media petitioners have the right to intervene in this matter to seek access to court proceedings. The Kentucky Supreme Court affirmed more than 30 years ago that the media has a unique right to intervene in civil and criminal cases to assert the public's right to access court proceedings. And it says the news media is a unique position in demanding access to court proceedings, wherein the media is permitted to intervene and demand access, even though a non-party. And if denied intervention or refused a hearing, is permitted to attack the decision in the appellate court by writ of prohibition or mandamus. And then I'll list a bunch of the stuff. Here, the media petitioners seek to intervene for the limited purpose of asserting the public's right to access court proceedings that the public has a right and need to see. More case stuff. A motion for partial modification of May 13th order. So they're given like some other ideas here. They're like, okay, what about this stuff, right? So the media petitioners appreciate the thoughtful approach that the court took to its May 13th order. I'm not the media, so I don't necessarily feel that way. They acknowledge the discretion granted to this court regarding the use of cameras or other electronic devices in the courtroom and agree that it is important and appropriate for this court to maintain control over the courtroom so as to minimize or prevent activities that might distract the jurors during the course of the trial. Also, that is fair. That is fair, right? You know, but trials are streamed all the time in different jurisdictions. Just fine. May 13th order at 1. Oh, sorry. And they can tell that this court took seriously its obligations to ensure a public criminal trial, which ensures the proceedings are fair because it allows members of the public to observe these proceedings. At the same time, the media petitioners believe that these goals may be accommodated in less restrictive ways that allow the public to remain informed of legal proceedings being carried out in its name. For that reason, media petitioners ask that the court modify its order to permit a single pool camera to film court proceedings, subject to the rules and restrictions set out below. Oh my gosh, how many other trials have we watched where that exact thing happened? Oh, that's right, we just watched the Karen Reid one. And that's what happened. These criteria have been used to successfully allow coverage of court proceedings in other sensitive cases, including in cases involving juvenile defendants. 1, a single pool camera will be allowed in the courtroom, which will share video and audio recordings with all media petitioners and other media outlets who elect to participate in the pool at no charge. 2, the camera will be located at a place within the courtroom to be designated by the court. 3, the pool camera may record the proceedings, but they may not be live streamed, right? They're saying we can delay it. It could come out later. We just still want a camera there. 4, the camera will not produce any distracting sounds or employ any artificial lights, and any cables used to operate the camera will be securely taped to the floor. 5, the camera and its operator must be in place no less than 15 minutes before the beginning of each day's scheduled court session. 6, no member of the jury may be shown or otherwise identified at any time prior to the jury's dismissal, and thereafter only if the juror consents to being identified. 7, the pool camera may not record any audio of off-the-record conferences between the court and counsel, or between counsel and co-counsel, or between counsel and their clients or any witnesses. 8, the pool camera may not record any proceedings held in chambers or otherwise closed to the public pursuant to the standards set forth. Now, media petitioners acknowledge the court's concern that members of the jury or witnesses may watch news coverage of this case. It happens, right? But they're given strict instructions. So, however, those risks inherent in any public trial. That's right. Like all of them. And those risks will be present whether cameras are permitted or not, because this court's May 13th order acknowledges that the media will be covering the case. So stories about the testimony will air regardless. That's why courts have generally found that these concerns are best addressed through the use of jury admonitions and instructions to potential witnesses at the outset of trial, rather than prohibiting media access to proceedings. Moreover, concern about potential juror or witness taint is particularly antiquated for evidence or testimony already presented in open court. Oh, no. Why did it restart my thing? Jerks. I was getting too spicy, and this channel was like, ooh, calm down, Llama. It's too excited about it. All right. Where were they? In open court, we did that. Oh. That's just quotes from those things. Oh, I do not like this page. Oh, and it's going to play that ad. Hold on. I listened to the beginning of that ad so many times in the last week. I haven't memorized that. And the Weatherman's ACT. He was a weatherman that took the ACT, and you should too. That's what I learned from that. All right. Likewise, concerns about future trials related to this case are at present, quote, too speculative to justify denial of the public's right to see proceedings playing out in open court. And any such concerns can be addressed in subsequent trials by other means, such as more searching voir dire or even a change of venue. Simply put, the benefits of allowing the public access to contemporaneous reporting on an already public high-profile trial in a controlled manner outweighs otherwise speculative risk that may be addressed through other means. Because guess what? That's what everybody's doing now. Just speculate, and they saw one thing on Facebook. They don't even know if that's what happened in trial, but whatever. The media petitioners respectfully request, therefore, that this court modify its May 13th order to allow a single pool camera subject to the conditions set out above and in attached proposed order. Finally, given the short time remaining before the start of trial, the media petitioners request that this court rule on this emergency motion on the papers, or if the court would prefer, following a short telephonic or video conference set to discuss these issues. Undersigned counsel stands ready to discuss this issue at the court's soonest convenience. So that right there is a media motion, which very often see. That is not surprising. In case you've never heard of one of those before, that's how they word that. So now, so that's May 23rd is when the media files that, okay, because Lawson's trial is supposed to start on May 27th. So also on May 23rd, Houck's defense has 4 expert witnesses ahead of the trial. The experts are expected to offer specialized testimony related to law enforcement practices. Among them is Dr. Jeffrey Neuschatz, a professor at the University of Alabama in Huntsville. Neuschatz has published extensively on jailhouse informants, a topic that could play a role in Houck's trial. That's right, University of Alabama. Isn't that where Burgess was going to school for like 15 years? Also listed as an expert witness is Denver Butler, a former Kentucky state legislator and the founder of Clemency Investigations, Inc. In his LinkedIn profile, Butler describes himself as a retired, results-driven law enforcement professional who helped reinvestigate historical homicide cases, leading to the exoneration of 2 wrongfully convicted men. There is also an Adrian Lauf and an unidentified 4th expert also named in the court filing, though it does not specify the nature of their testimony. So, May 26th, an order comes in from Judge Sims that the defense must disclose any ultimate opinions their experts have about the investigation with the Commonwealth. I'm sorry, this is in regards to Brooks House. That means the defense must now disclose any broad opinions their experts will share, including who they believe is responsible for criticisms of the investigation. However, the judge will not require those opinions to be connected solely to evidence in this case. That could potentially introduce alternative theories that could significantly influence jurors. All right, so May 27th comes. It's the day of Steven Lawson's trial. And I'll just go ahead and tell you now that it starts off, all right, the morning of. The judge comes in, denies the media motion, saying he is exhausted after receiving so many requests from media, adding, quote, "a fair trial is my primary concern." Exhausted. Oh, skull. All right, you guys, we did it. We got through all the pre-trial stuff. All right, we did it. Woo. Cheers, everybody. Cheers. 9 hours. Oh, wow. That's probably like the longest they've streamed ever. But we did it. So that gets us all caught up to where next we will be doing the trial of Steven Lawson. It's 4 days. Okay. It's not even that long. And I had to go through so many sources to put it all together because different people report different things or can write quicker than others. So I'm going to be putting that together over the next couple of days. Between that trial and Brooks' trial, it's going to take a lot to organize all that information. But you have now heard everything there is on the internet to share with you guys, news-wise. All right, I did not go into forums and Facebook groups, and I didn't make it messy. All right, everything you've heard through all of these parts all came from the news on the internet. So from the time Crystal Rogers disappeared, and then we went back with Jason Ellis and the Netherlands to these trials, every single thing that has happened, you guys now know. Do you guys feel experts of Bardstown now? Because I do. Now, so when are we going to cover the trial of Steven Lawson? Ideally, I would like to do it Sunday. All right, that would be my goal. I'd love to do it sooner than that, but I just don't know if it's realistic and I don't want to put myself in a bind. Listen, if I get it done early, we'll do Saturday. But I don't know, Sunday at the latest, probably Monday morning. So I'm having contractors in here to redo our bathroom Monday. Supposed to be Monday through Wednesday. I don't know. We're not going to know anything until they show up here in the morning. So I can't schedule anything for next week until I know Monday morning. So we might do like evening night streams maybe to cover the trials, and because closing arguments for Brooks and Joseph Lawson are Monday. The defense rested earlier today. So I'd like to have it out before a verdict comes. I'm hoping a verdict actually doesn't come the same day, because oh my, if so, from what I know, yikes. But that's okay. We'll take our time, right? If we want to know all the facts of how it went down exactly, we're patient. You guys are a patient bunch, and I really appreciate that for sure. I promise I have been working nonstop on this for like 2 weeks. But I mean, and this is what's really hard to admit, right? Is that I do feel like we know who is probably behind it. Okay. I mean, what are the odds of something else? But then we go, can the state prove that somebody did it? You know, and that's what we're getting ready to do. And it's really hard when you have all of this background information of everything that's happened and try to separate that when they go to trial. And you have to be like, really try to put your bias aside and examine the evidence that the state brings. I mean, what kind of evidence do you guys think that they would have, right? The FBI did all these searches. The IRS has everyone's financial information. Surely they would have a bunch of stuff, right? I know people are probably gonna come after me because I'm sure I'll have some unpopular opinions, but that's not my fault, right? Like, could be investigation, it could be the prosecution, who knows? Or maybe I'm completely wrong. You guys, I don't have all the details of both trials, okay? I too only have news articles to read, and I've only been able to read a few every night. But putting together the trials, there is a lot of stuff that has actually come out, but you just got to dig everywhere to find it. So even my opinion that I have right now might change once I'm able to piece all the tangled pieces together. So we'll see. We'll see. But you guys, I will not be streaming tomorrow. Make sure if you haven't yet, turn your notification bell on, subscribe, all that stuff so you don't miss when we go live. Because I think Terry was talking about going live to cover some Chase Lackey stuff, I believe. But I will try to get these trials out and us hanging. Those will be long streams too, except we won't have any videos to watch. So they'll be fairly long, but nowhere near as long as this. But I want to thank you guys all for being here for me tonight. All the gifted memberships that were given today and the super chats. You guys' support is amazing. I don't know how you listen to me talk for like 9 hours, but I did it. Am I going to talk tomorrow? Nope, I'm not talking to nobody. It'll give me a good excuse at the cookout. I'm sorry, what are you saying? Oh, I'm sorry. No, I'm just kidding. All right, I will see you all later. You guys have a wonderful and safe, happy 4th of July tomorrow. Remember, get an Uber. Don't be pulling Canton cop business. No drinking and driving. Don't do that. If you're using fireworks, be safe. Okay. And until next time, you guys, go forth and be amazing. Bye, guys.